What is the suit? What was the suit for?
It is for selection of sale agreement. I have filed suit for cancellation of sale agreement. The expected duty was transferred, even though there is no appearance by the defendant. Even though there is no prayer, the sale court directed to refund the amount along with interest. Wherein I have forfeited the amount under the notice. Therefore,
What is the urgency?
since they have directed to deposit the amount within 2 months. 2 months, otherwise directed me to pay 18% interest per annum.
When are the 2 months expiring?
And the 15 days.
We'll have it. Just see it now. First week. Just see it first week.
For admission,
1 minute. Take the date. You should. Is the caveator there? Okay.
This is a suit for eviction. The eviction is ordered against the defendant. Now, there was an appeal petition. There is a counterclaim against the suit. So the time is already
What was the counterclaim about? You were whom? You were the. You pleaded adverse possession, rejected, and eviction order passed. What was the time period granted?
3 months is already.
So what is this? 8 August?
They first gave it as third copy.
Just give it, ma'am. We'll see our convenience also. Is that a ground?
No, Mr.
Then just give it whatever is convenient. This.
matter.
Yes.
Suit for declaration and injunction that was filed, my lord. The society executed an illegal sale deed, my lord. Suit for declaration and injunction was granted, filed, my lord. Throughout I had the interim order benefit, my lord. Now they filed an application under 7 Rule 11, meaning that section 125 of Cooperative Society Act should have issued notice. My lord, I have not claimed any relief against the society. And it is not going to come in the way of day-to-day affairs of the
What
society.
happened? What happened ultimately?
7 Rule 11 application is filed that came to be allowed, and my suit is rejected. Now, since I have the benefit of interim order,
What was the interim order?
But I had an injunction order in the trial court that was been modified before this honorable court granting an order of status quo. Now, my lord, by taking advantage of the rejection of claim, they are trying to they have cleaned up the site yesterday, my lord.
They have?
They have cleaned the property yesterday, my lord. They may take forcible possession. That is my.
No, they are seeking eviction. Your eviction.
No, my lord, not evicted, my lord. I am in possession of the property.
That's right.
Now illegally they came and they cleaned the site, and I have resisted yesterday. Since my suit is.
Just take it, ma'am. Give it on Monday or Tuesday.
21st, sir.
That's one.
Just ask them.
Let's.
Yes, Mr. Amresh.
Let's one writ appeal. Let's fresh writ appeal. Let's pending for admission for a long time.
When?
23 minutes.
What is this, Mr. Amresh? 23 April.
September
What is the
23.
urgency?
It came up for once before the Chief Justice.
What is the urgency?
Urgency is, let's, they may move the execution proceedings. Let's.
They have initiated.
Not yet initiated, but they may.
We'll give it in February.
This is between BSNL and BHL. Lot
We'll-
crore they are demanding. Let's.
They have
27.
not filed execution.
Not yet. We have not yet received.
Very well, we'll give it. Just say it. But objections removed?
You remember long back. It came up before the Chief Justice once. Last, but later it was not.
Just say it.
Let's, there is one writ petition. Let's CIT matter. Let's.
Huh.
So.
What is the urgency?
Urgency is only that the petition may move content petition before the CIT. That is
We'll
the
give it.
short point is involved.
Very well. Give it along with that only.
17th or Monday also it will be.
We have given a date in the other one. Just check up the date.
Yes.
That's not. One RFM law, I filed a partition suit, it is dismissed. Now the respondent trying to alienate the property.
The final decree proceedings are pending?
No, man.
Ah.
Suit
No.
is dismissed, that's
Oh, suit was dismissed.
dismissed.
Oh, was there any interim order?
No, man.
There was none.
No.
Just give it, man, conveniently, whatever is there.
Hearing an IM,
Just one. You just check up caveat, huh?
Yes, on hearing on IA, my lord, I have filed IA for stay. The suit for partition was, my lord, dismissed, my lord. Against that, my lord, I have filed.
Is
it's
it a pending
it is
appeal?
pending. Final decree proceeding is pending. Now, my lord, the court is going to appoint a court commissioner. If court
Now, what, is there any date in the appeal?
date is not given,
There is no date.
date is not given.
Just give it, ma'am.
Oh, my lords, it's a
Just one.
fresh,
Just check up. ma'am. Yes.
my lords, it's a fresh matter for admission, my lords,
Or
for admission. My lords, our section 34 petition got dismissed by the commercial court and the respondents have moved before the high court with regards to the execution, my lords. So hence there's urgency.
they have initiated
They have
execution.
initiated execution, my lords.
What is the date?
My lords, before the Bombay High Court, the petition came to be dismissed on 24th of July, my
No,
lords.
execution is before the Bombay court.
Before the Bombay court, my lords. But then, however, the commercial court in Bangalore had dismissed our section 34
Right. The
petition.
property may be there.
Yes, my lords. Hence, there's
And
extreme
what is the
urgency,
date
my
of the execution?
my lords. They've initiated the proceedings in August, my lords.
But what is the date?
My lords, I never got the exact date, but in August they had initiated,
it,
my
ma'am,
lords.
next
Hence, there's
week.
extreme urgency. Kindly have it listed next week, my lords.
Just check up. That writ appeal which was mentioned, the tower was still.
My lord,
Just one. Yes.
Lord's commercial appeal, my lord's pending. I am for the respondent. Normal amount of 1.4 crores is due and payable. There's a second round of litigation before the High Court, my lord. Urgency has not come up since 2023, my lords. But the Union of India has preferred the appeal.
We'll just give it any convenient, just check up in February.
My lord, I appear for the appellant.
Just one.
My lord, I have filed this RFA against the order passed in the FDP on 22/11/2024. And this on court bench of this honorable court on 10/12/2024 ordered to post them immediately after arbitral vacation to consider application IN number 1 of 2024 filed by me for stay.
There is no date.
There is no date is given, my lord.
Ma'am, just check up. Just check up. Don't give, just check up when they listing it. Just wait. We'll just check up.
Yes,
my lords, RFA pending matter, my lords. We have filed the IA to withdraw the deposit amount, my lords.
Just take it.
We are for the
Give it
respondent in this.
February. Is there any date here?
No, my lords.
There is no date.
No, my lords.
First week February.
My lords, it's a
Lord.
fresh matter, my lords, a commercial appeal. I am for the appellant. The plaintiff, the decree has been passed, my lord.
Objections?
They have filing execution, my lords.
Have you removed the objections?
Yes, my lords.
All?
Yes, my lords.
Just say so also, no objections are pending.
Yes.
And any caveat?
No, my lords.
Just check, say so. Says, I think will be immediately listed for winter vacation. Listed, just check it also. List, no date, no, listed.
My lord, commercial appeal,
Just one.
this is an old matter.
Just 1 minute. Just take it that way.
So, bless.
This is ours only. Would be ours. And this would be ours. Check up that one. Just a minute, please. Then final.
My lord, commercial appeal, this is an old matter. Upon request, we were permitted to file additional documents on or before 6th of January, my lords. We have filed the same. Date is given for 20th of January on hearing on the same. However, my lord, senior is not available from 18 to 21. I request a date before 18 or after 21.
Difficult.
Uh,
We are having a 20th, we'll have it.
My lords,
Okay. No, this is not the way, ma'am. We have given a date.
please, my lords,
So you should have filed an application for early hearing. Possibly we could have considered. We will not
Earlier.
change.
yes, my lords, before 18th,
It's not possible. We will not change the date. Okay? Yes.
Your lordship, this
Next.
is a fresh commercial appeal, your lordship. We are for the appellant. Your Lordship, the trial court in a commercial arbitration application has vacated the interim order granted to us without a reasoned order, without a speaking order.
What was the interim order?
The interim order was non-alienation, that the respondent shall not alienate the property. An MOU was entered into between the applicant and the respondent therein. Now, Your Lordship, with the interim order having been vacated without a speaking and reasoned order, that in attempts to alienate, hence the urgency, Your Lordship. Kindly the matter may be taken up, Your Lordship.
The 34 court has vacated it.
Not 34, Your Lordship, section 9, section 9.
Oh, this is section 9.
Yes, Your Lordship.
Arbitrator appointed.
No, Your Lordship, not yet. We have filed a CMP, but its appointment is
Just
not.
take it, ma'am. Next week we'll have it. Please. Yes.
It's the first appeal 2022 matter, my lordship. Suit in the year 2011, my lordship. This honorable court had granted the interim order, my lordship, and due to non-availability of the proper information from the appellant advocate, they deposited the amount before their account, my lordship. For the same, I'm filing application for extension of interim order, my lordship. It may be happened tomorrow, my lordship.
No, they have deposited money where?
Due to non-availability of the knowledge, they deposited in their personal account, my lordship, for fixed deposit.
Whose personal account?
Appellant personal account, my lordship.
Who has deposited? The,
Appellant itself.
what is this?
For the same.
Just take, no, what do you want? Tell us.
For extension of time, I filed the application, my lordship. That application has to consider and permit me to deposit the same before this honorable court.
Just take it, ma'am. Let's. Any other mentioning?
Yes, my lord.
Lord, specific performance, the suit has been decreed in part, where my lord's defendant was directed to deposit the earnest money with interest, my lord. My lords, now the plaintiff has filed an appeal before this honorable court. My lords, I have filed an application for seeking permission of this honorable court to deposit the earnest money, my lords, with interest. My lords, I have filed an application. Could be taken up next week, my lord.
No application in the pending matter?
Yes, my lords.
Is it a pending matter?
Yes, my lords. My lords, I am the respondent there, my lords, in this appeal, my lord.
No, but there is no date there.
No, my lords. There is
Who
no
is
date.
appearing for the appellant?
My lords, I'll verify it.
See, you have to inform the appellant
My lords,
also.
only thing, my lords, I have to deposit the amount, my lords.
And then also,
Yes,
he
my
should
lords.
have knowledge.
My lords, I'll intimate him, my lords.
Just take it, ma'am. Just see next week, next to next week.
My lord, RFA pending matter, my lords. The respondent seeking for appointment of court commission, my lord. IA in pending ಇದೆ ಸರ್ ಮೇಲೆ trial court ಅಲ್ಲಿ court commission appointment application ಆಗುತ್ತೆ ಸರ್. See, kindly maybe posted for.
What are you seeking? What is the prayer? No, the suit has been decreed against you.
No, my lord. The response.
Who has filed the appeal?
ನಾವೇ ಸರ್ ಮಾಡಿದ್ದು appellant.
You are for?
Appellant.
You are for appellant.
Appellant. The
There is a-
respondent seeking court commissioner trial court, my lord.
You are the appellant.
Appellant.
What was the suit for?
ಇದು specific performance, my lord.
Big buff. Just take it. ma'am.
My lords,
Explain to me.
and
Press matter, RFA 2024.
Any objections?
Objections are complied, ma'am.
What is the urgency?
They are trying to alienate the state civil property, ma'am.
Just give it, take it. ma'am. Next week, anything.
My lords, a commercial appeal, we appear for the respondents. There's an interim order that is granted by this honorable court. We are now filing for vacating of the interim order on the basis that the order which is passed by, which is under challenge is appointment of arbitrator application has been rejected. Meanwhile, there's also an interim order that the respondents are restrained from disturbing the peaceful possession of the appellants who are tenants. And the developer, we are the landowners, the developer has entered into a lease agreement with the tenants with regard to our property. As per the joint development agreement, it is our property. He has entered into a
Who
lease.
is the appellant?
Appellant are the tenants, my lords. That is
But
why.
Are they here? Have you mentioned, have you told the council who is appearing for them?
Yes, please. We have served
Have
them.
you
the-
informed them?
We have served them the copy. The endorsement is also on the memo.
No, you will inform the date also.
Yes, please. We'll inform.
Just give it next week, any date, ma'am. Any other mentioning?
my lords, an RFA, it's an RFA, my lords, an old matter from 2016. It's pending its post of final hearing. A date has not been given in this matter. A date may be given. We are asking for the 17th, any date.
You file an early hearing application.
A date has not been given in
File an early hearing, file a fixing a date, application would be better, not like this. Okay?
My lord,
For the appellant, my lordship. The appellant filed the OS for the Performance Act and jail code has been dismissed, my lordship.
What has been dismissed?
Specific performance.
The suit has been dismissed. You have filed an appeal.
Yes.
Is it pending? What is the year of this appeal?
Fresh matter, my lord.
What, fresh matter? What is the urgency?
My lordship, after the, by virtue of dismissal, the respondent is claiming the property, my lord.
Claiming?
Claiming the third party interest over the property, my lord.
Objections in the appeal? Are there any objections in the appeal?
No.
You have removed it. Caveator there?
Yes,
Just check
sir.
up, ma'am.
You have complied the office objections?
Yes, my lord.
my lord,
Take it. Yes, ma'am.
my lords, it's an old matter, commercial appeal, and we are State Bank of India, and the matter has been pending for a long time. My lords, there has been the matter is posted for hearing on IA,
Posted for?
hearing on an IA, and as appellants, we are not able to invoke the guarantee agreement against the.
You are the appellant in the appeal.
Yes, my lords.
Who is the respondent?
Patel Engineering. Respondents are not here, my lords.
No, is the counsel there in that matter? Are the respondents represented by the counsel?
Yes, my lords.
Very good. What do you want? What is the urgency?
Ma'am, my lords, we are not able to invoke the guarantee agreement despite the wanton delay by the guarantor and the borrowers, my lord.
Just take it, but you will inform the counsel,
Yes, my lord.
the other counsel. Just take it, take an endorsement, inform the date, then you will give this to the court officer.
Okay, my lords.
Just
My
give it next week, ma'am, after 2 weeks.
Hello, it's a fresh matter. We are NBFC Home Loan Financing Company. We had performed Section 14 of SARFAESI Act and we had taken possession of the property. The respondent had filed a writ appeal under single bench, honorable single bench, and the interim order granted was to hand over the key and possession. We cannot hand over the key possession because it involves public money, my lord. Kindly post it for admission.
What is this you are mentioning?
Admission, for admission.
Is it a writ appeal?
Yes,
Okay. Your objections clear?
yes, ma'am.
Any caveat?
Yes, my lord.
Caveat is there?
Yes, ma'am. Yes, ma'am.
Have you informed the counsel?
We have, right now, we'll do it after taking the.
Ma'am, just take it that.
My lord.
Say next week anywhere.
Sir, date of filing.
Hmm? Oh, this is 24. You are just check.
My lord, pending.
Just check up that.
May I please make a mention? Manoj?
Yes, just 1 minute. Mr.
Yes. In a pending MFM, my lord, an application has been filed for the repair of the building, my lord, due to specific performance which has been granted in favor of me, my lord, by the district court, my lord, under section 34. The appellant is before this court, my lord. Because the building is old, it needs some repair, my lord. I have sought for
Who is the other side?
other side, my lord. I will inform, my lord.
Just inform me.
I will inform.
What the urgency, we can have it just after 2 weeks, ma'am. But you have to inform the counsel.
Definitely, I will inform today, sir.
Take an acknowledgement, then give it to it.
Yes.
May I make a mention for adjournment?
Just 1 minute, please. Just wait. Yes, yes, Mr. Surnaran.
Well, my lord, item 42, may I make a mention? This is a matter, my lord, we had moved for Monday. Item 42, it's
Yes.
a commercial appeal. We had moved it for Monday, but it's unfortunately come up today. It may clash with one of my matters here in Delhi. I don't want to
Who
take
is
a
the
pass over.
other
I'm
side?
back.
Who is the other side?
Mr.
I'm appearing for
Hari-
the caveat or respondent, your lordship.
We have informed them, my lord, that there's some difficulty. If it can be taken up tomorrow, I'm back in Bangalore this evening.
No, where is the counsel for the respondent?
He's
I'm
also on
appearing for the
VC.
respondent, your lordship.
Who is the counsel, ma'am?
Mr. Harikrishna Pramod is on VC. my lord.
Krishna Pramos.
Yes, you are for the respondent?
I appear for the caveat or respondent, your lordship.
Very well. We'll just say that at the request of Mr. Surnana, Leonard, senior counsel for the appellant, re-notify. Just give it next week. We'll have it next week, Mr. Surnana.
Next week also, my lord, there's some matters I have back to back in Delhi. Can it, the execution is on 18. That's the only difficulty. Either tomorrow or day after, my lord, subject to your lordship's convenience.
No,
Execution
what about
is on
Tuesday?
Saturday.
What about Tuesday?
Next Tuesday, my lord,
we have moved something here in Delhi. There's something fixed in the Supreme Court.
No, you can appear through virtual. What is there?
Because I'm the appellant and we have to convince
Doesn't
your
make any
lordship for
difference.
stay.
See, Tuesday would be fine.
The matter execution is on 18th, my lord. That's the only difficulty.
Who is,
Yeah, that
you
is
can
this
be-
Saturday.
The council will, both of you take an adjournment in the execution.
Very well. Very
It
well.
is only
Then
listed
about
for appearance of the judgment debtor, in fact, on the 18th.
Appearance, na, it's only coming after notice.
yes,
Please.
first time.
Then
First
it's
time.
all
First time
right.
coming
You
after
can
notice.
appear and seek an adjournment. You can tell the court you have filed, you have in the High Court.
Very well. Would next Monday at least be all right?
Pardon?
Next Monday at least?
21st would be more convenient, Mr.
Very well. Very well. Very well.
21st.
Great.
Okay.
Much appreciated.
Yes.
Serial number 43 or 43, 44 and 45 it is connected.
Just wait a minute. We'll just run through it. Otherwise, we'll delay it. Next, just call the matters.
My lord, one mentioning, my lord, one commercial appeal for admission. I have sent a memo through my friend, my lord. I'm
No, for a
Somsekhar
fresh
Advocate.
listing.
Yes, my lord.
Who is there? What
My
is
friend,
the urgency?
my lord, employee was injured. She filed a claim application, which the insurance company remained ex parte. Therefore, the execution was filed against us. We paid 3.5 lakhs rupees. Then we filed a commercial appeal, suit, my lord, before the district court. Commercial, that there also insurance company did not appear. Now, after the decree, instead of filing an appeal in respect of the compensation order, they have filed a miscellaneous application, which is allowed, my lord.
What
So
have they filed?
they have filed a miscellaneous application to recall the ex parte order in the commercial suit instead of filing an appeal in the Employees Compensation Act. That is allowed, my lord. The case is now posted to 21st before the trial court.
No, is it a 913 which was allowed or what?
My lord, I mean, ECA was allowed, ex parte, insurance company was ex parte. The execution was filed against the employer. We paid the amount. Therefore, to recover that amount from the insurance company, we filed a commercial suit. That commercial suit was decreed because insurance company did not appear. Now, instead of filing appeal in the ECA application, my lord, Workmen Compensation Act, they filed an application to recall the ex parte order in the commercial suit, which is allowed. Though in spite of our objection that the remedy lies there, not in the commercial suit.
Okay. When is the date? Otherwise,
21st, the case is posted before the trial court, madam.
just take it.
Lordships kindly,
Much
madam.
obliged.
Just run through the list, ma'am, now.
My lord, serial number 35, my lord.
Now, just 1 minute, please. We'll run through the list. Just start
Yes,
the list.
My lord, I am out of Bangalore, my lord. I'm in Bombay. Tonight I am reaching, my lord. That is the difficulty. Serial 35. Tomorrow also I am ready, my lord. I'm reaching Bangalore tonight.
You are for the appellant.
I am for the appellant.
Pardon?
Yes, my lord, I am for the appellant.
Who is for the respondents?
Shaker Shet.
KV
Have you
attorney.
Have you
KV
informed
attorney. I will inform, my lord. The moment I come to Bangalore, I will inform.
You should inform it beforehand,
Yes,
please.
my lord. The personal difficulties I am out.
Suppose he has an objection for adjournment.
My lord, I am ready, my lord. Next day, 1 day accommodation, my lord. Tomorrow, I'm flight
The
will
request of
reach.
counsel for the appellant re-notify. Just give it convenient hour date.
Lord, serial number 65, my lord.
1 minute, ma'am. We'll just come back.
21st March,
Next.
serial number 1. Amit Hegde.
I am appearing for appellant, my lord.
Let's translation of the Kannada documents be filed
1
within
week time, my lord.
4
I will
weeks.
file.
List on.
3rd of March, serial number 2, Shri Saravana.
Not sir, pay for the appellant.
File your court fee, please.
Not sir, court fees is paid, my lords.
When did you do that?
Not sir, on last date of hearing itself, I paid the court fees, my lord. 20 rupees was the deficit I paid.
What is the one objection which is there?
Para 16, my lords, para 16 of the appeal memorandum. I have detailedly stated the valuation, my lords. Officers raised objection that.
But you have stated valuation. Have you deposited the court fee?
It's not deposited, my lords. Now the only office objection is that I have to file a detailed valuation slip. That is in the.
You have
para
to?
16. File a detailed valuation slip.
Valuation slip.
That's in para 16, my lords. And valuation slip of the trial court is also produced at page number 36.
You are appearing for the respondent?
Caveator.
Caveator. Now let's see what is this. Yes. Just say that learned counsel for the appellant states that the court fee has been deposited in the registry on how much you have deposited?
Notes in all, my lords, 66,145 rupees.
66,145.
No, sorry, 66,145 rupees.
First, the registry shall check the same and give its report. Yes, now what is your case on the?
Merits, my lords, suit for ejectment. This is a society. Not as a matter of fact, my lord, the former president, the plaintiff happens to be the son of the former president. Not the former president. For this time, my lord, she lost the election. Not the term of the lease is 11 years, not 5 years. Not now, unfortunately, not we are running a education institution. Schools and colleges have been run in the institution. Not unfortunately, we didn't file the written statement. On the score, we are not permitted to cross-examine the plaintiff. Not in fact, not at para number 19. Whatever the reply which has been given by the societies has been called out at paragraph number 19 of the judgment. May I read minutes para 19 minutes?
Yes.
In spite of issue of service of summons to the defendant number 1, they need not have appeared before the court, though defendant number 2 representing through her learned counsel but not filed the written statement. Therefore, defendants are not challenging the case put forth by the plaintiff. Exhibit P6 is a reply notice dated 29/9/2022 from the defendants. Shows that Mahila Samaja is started in the year 1957 and registered under Karnataka Societies Registration Act 1960 with an aim and objective to promote and develop social welfare among the women folk and impart education to the girls and boys. And the said Mahila Samaja is not individual to anyone and it's having good reputation. in the society.
Was there any interim order in your favor before the suit below?
No, it's a ejectment suit, my lords. There was no interim order because it's only a suit for ejectment.
Obviously, what is the effect of ejectment?
Not ejectment until the final order is passed, my lord, there will be no, we continue to be the position, we have paid rent up to date, my lords.
What do you say?
Lord, I don't have the copies. I'll have to seek instructions, my lord. Let him serve a copy and.
I have served.
Just say this, let the copy of the appeal paper book be given to the counsel appearing for the respondent caveator, respondents caveator. Respondents caveator during the course of the day. But tell us one thing.
Not on the previous day, same.
One is,
submission was made.
see,
I
there is
served the copy.
something inter se issue between secretary and
Yes.
the president.
Yes, my lords.
Now, who represent? Now, how would you represent two?
No, sir, it's now I filed through the secretary.
Now, who is the contesting party in the?
Plaintiff. Not for the society, not now secretary, my lords is filing because the institutions have been run and.
See, you have to serve the.
Not previous date itself, the same submission was made. I've served the copy. I don't know, not my friend.
You have an acknowledgement.
You appear for whom?
I have an acknowledgement. I am for the landlord, my lord, the owner of the building. But he says that he has served it to me, my lord, I have not.
Who was the plaintiff?
Yes, he was the plaintiff.
So you are the contesting party?
Yes.
Now there is an interstate dispute between the secretary. It appears to be between secretary and the president.
I'll have to.
You are not concerned with that.
Yeah, I'm not.
Mother is also a president. He's also a member. She was a.
She was a member and a former president. That I admit.
But how is that relevant?
How is
Not,
that?
it is the reason, my lord, she took away the original lease deed. I couldn't produce before the court. It's 11 years. Not now, probably, my lord, if she wins the election next year, my lord, she may continue the institution.
That is all on presumptions, my lord. He is making submissions. I don't have such instructions. Whether she will.
Just give him a copy of this.
Not, I will serve it today itself, my lords, but not let them not precipitate, my lords.
Lord, we have not filed any execution till date.
You don't intend to till the next date, surely?
Please, please. No, let it not be recorded.
No, we will not record. We'll give you a date so that.
Yes.
Just give it after 2 or 3 weeks.
Lord, the time expires somewhere in the month of
Stop. The
first week itself. It would be better, my lord, because I think it is in some third week of January. That is why.
Give it in first week February.
Please, my lord. Until then, I will not.
4th of February.
Now, very well. We don't say anything insofar defendant respondent number 2 is concerned. That we will see. But this respondent number 2 was also a party.
Yes, my lords.
In this capacity.
Yes.
Before the court below.
Yes, my lord.
The secretary was made and even the president was made. Very well. So next,
4-2, sir.
just give him a copy.
I will today itself happen.
Serial number 3.
The counsel for the appellant shall also clear the one office objection put by the registry before the next date of hearing.
Serial number 3, Abhishek Chandragowda.
I appear for the petitioner, my lord. I seek a week's time to come live.
You have to deposit the court fee also.
Court fee and also there are some.
Let objections be cleared, 2 objections be cleared within 2 weeks, list on.
11-2. Serial number 4, Shri Hirematad.
Let objections be cleared within, within 6 weeks. Re-notify on.
11th of March, serial number 5.
Office objections be cleared within 6 weeks, list on.
17th March, serial number 6.
Office objections be cleared within 6 weeks.
17-3, 7, Shri Manjunath.
Present the appellant. Matters were clubbed below, so there are two. In the first matter, my lord, there is one office objection with regard to production of the arbitral award, which has been produced in the second appeal, my lord, 7767.
But both the matters arises from the
Same common order.
common award.
Common order. In the
Why
second,
two-
in the
Why
second.
2 appeals?
Well, they said it's a common order, though it's a common order. I initially filed one appeal. my lord.
No,
There was an office objection raised. Then I filed the second one.
or they had also filed 34.
Yes, my lord.
So they were cross 34s or 2 34s against a common award.
Yes, my lord.
That may be the reason.
Yes. There are two different survey numbers. They said you can't maintain a
Yeah,
single
no,
number.
it's all right. Now, what about this arbitral award?
Millard, finally, we have obtained Millard with great difficulty because it is an old matter.
No, you
So,
will file it,
not today, Millard, a week's time. In both matters, I'll comply with.
both the matters.
Yes, Millard. They've been connected.
The
with
learner
now.
counsel for the appellant states that the office objection of filing the arbitral award
Yes, Millard.
with translation,
No, it's in English.
is in English, shall be
If
complied
it, if
with,
it is in Kannada, Millard, I'll definitely
shall be
file that.
complied
translation.
within 2 weeks, list on.
Millard, with regard to the second appeal, Millard, there is one.
No, we
Right.
have passed a common order in both.
Yes, Millard.
The objection is common in both.
No, Millard.
No.
Different. The first one is for protection of the arbitral award.
Second also,
In the second one, Millard, they say that I have to mention the award number. I've clearly mentioned, Millard.
no, but this also says so about the non-filing of the arbitral award.
It's, the scrutiny report doesn't say so.
Very well. I was a counsel submission with regard to non-filing of,
I'll produce, Millard.
just check up.
Yes, with regard to the mentioning of the award number, I've clearly mentioned, Millard, at page number, the second one, second appeal, 7767 of 23. Is at the threshold, paragraph number 3. I mentioned the arbitral award number. In the prayer, I need not mention because, Millard, I'm challenging the order of the district court. So I have mentioned that to set aside. I have mentioned it here, Millard. That office objection may be overlooked.
Just show us that.
Challenging the award number to be stated. The first effect.
Insofar as the office objection dated, where is the prayer made by you?
Millard,
Where is the prayer made in the appeal?
page number 14, Millard.
But would you not make a prayer in 37 also for setting aside of the arbitral award?
I need not, Millard, because 34 it is under challenge. What the order is under 34. So I am challenging the order under 34,
Now
not
that-
the original arbitral award, because I'm okay with the arbitral award because I'm in benefit.
Manner in which it has been given.
Yes, my lord.
You are
Yes, my lord. It is the,
the counsel for the appellant has drawn our attention insofar as the office objection about mentioning of the award number is concerned. Learned counsel for the appellant has drawn our attention to paragraph 3 of the memorandum of appeal to state that he has mentioned the details of the
arbitral award.
arbitral. There are two arbitral awards.
Yes, my lord, there are two. Instead of mentioning one, I've mentioned both in both the appeals.
Now, this appeal is concerning with which award?
Look, this is one.
Say that though the reference is made with regard to two arbitral award, comma, this appeal concerns arbitral award being,
Serial number 5, my lords, of the
no, will it be 2011-12 or 8-9? If you see paragraph,
82 bar 2020, my lords.
pardon?
82 bar 2020 is the arbitration petition number. So in this appeal, my lords, the second appeal, I've challenged 82 bar 2020. And
See, we are concerned with the
yes, my
arbitral
lords,
award.
I'll just point out, I'll just point out from the order.
1.1 comes to para number 3.
Because this order,
Serial number 5 is the appeal, AP 82 bar 2020, my lords.
right,
Survey number is 111 bar 2, 6 kuntas.
no, but we should be clear
Yes, my lords.
that this appeal pertains to which award? Because if you see, there were many other awards also which were subject matter of challenge.
Correct, my lords. Correct.
So that clarity is required.
Correct, my lords. My lords, here, serial number 5, my lords, NH 7D CR 48 bar 2008-9. What I have mentioned is both. So, my lords, 48, the second one, my lords. Para 3, the second one. LAQ ARB NH 7D CR 48 bar
Very well.
2008-9, my lords.
Say LAQ/ARB/NH-7 bracket capital D/CR/48/2008-09.
Dated 9/7, it's a common award, my lords.
We don't know, but there should not be any conviction.
No,
Be
it's
so,
a
comma,
common one.
the objection of the registry in this respect is overruled. Now you clear other objections if.
Yes, my lords. Yes, my lords. 2 weeks, my lords.
To list after 2 weeks, next,
Obliged.
whatever is convenient.
25 to serial number 8, Sri Rajeshwar,
My lord,
number 8.
I'm filing wakalat today, my lord, for legal representative of my son, Ratan. My lord, I am the appellant number 2, the wife of my lord. Appellant number 1, my husband died. Because of my cancer of me, my lord, I could not able to file an application in time, my lord. I filed an application for.
You have to file an application for abatement also, setting aside of
I
abatement.
filed, my lord. I have filed abatement and also delay application, my lord.
So there are certain office objections.
My office objection, wakalat has to be bring to my son, my lord. I'm filing today, my lord, wakalat.
The learned counsel for the appellant states that the office objection of not filing wakalat shall be complied with during the course of the day, as he intends to file a wakalat on behalf of the LRs.
LR of my appellants, my lord, 1 and 2. I am the wife, my lord, appellant number 2, my lord. My
On
husband
behalf of
died.
the LRs. At his request, re-notify.
4th of February.
Yes.
Serial number 9, Mahesh.
Appearing for the petitioner, my lords.
We are for respondents number 1 and 2, my lord.
We filed a memo for retirement, my lords, in this matter.
So
You may
what
be
will you
taken on
do
record.
then? Tell us one thing.
Yes, my lords.
See, we will not, the court must, you will be responsible, or you will say, so you are not getting instruction, we will pass appropriate orders.
My lord, that was the submission we made for the past couple of days.
Very
We've
well,
not
then
been getting any instructions, which
Very
is a
well.
reason for filing this retirement memo.
So we will note your submission that you are not getting instruction, we will pass appropriate orders.
Yes, my lords.
Though an application has been filed by the counsel for the appellants seeking retirement, he also states that despite his efforts, he is not getting instructions from the appellant company. If that be so, the appeal is dismissed for non-prosecution. Great. Next.
Serial number 10.
For appellant, my lord. Pray for 1 week time, my lord. I will
Let
take
notice be issued
sub-service.
to respondent 1 and 2, returnable on.
19-3. Serial number 11.
Lord, in this case, I'm appearing for the respondent number 3. Here for the appellant's counsel, please, my lord. One K.R. Bharadwaj intends to file wakalat for the appellant and seeks time, my lord.
Lord, in this case, there is a the respondent number 1 and 2 has died, and they have informed in the last event. Lord, I have filed an IA for dispensation for them because they have placed ex parte before the trial court. If they say no objection, my lord, respondent number 1 and 2 may not be served because I am the contesting party.
Well, he is intending, K.R. Bharadwaj is filing wakalat. I shall inform him, my lord. Your lordship
No,
kindly
who
grant
is
me
Mr.
1 week time.
Who is Mr. Thimmappa Nayak?
No, he has retired from the case. He has given NOC.
Just say this adjournment is sought on behalf of, who is the now counsel?
K.R. Bharadwaj.
Mr. K.R. Bharadwaj, who according to the counsel shall file a wakalat on behalf of the appellant. Which appellant? Achha, there is only one appellant.
Yes.
Full stop. We find that the learner counsel for the respondent number 3 states that the respondent number 3 being the contesting party and respondent number 1 and 2 were ex parte before the court below, comma and who have expired, comma there is no need to implead the LRs of the respondent 1 and 2. The counsel for the appellant, Mr. Bharadwaj, shall take instructions in that regard.
Great.
Next.
Let the date may be fixed, my lord. There is an urgency.
18-3.
Great.
Serial number 12.
My lord, can it be much earlier, my lord?
Next.
12.
Appearing for the appellants, my lords. Memo for withdrawal has been placed on record.
You want to withdraw this?
Yes, my lords.
Say that learner counsel for the appellant has drawn our attention to the memo for withdrawal.
Has been settled before the local adalat.
Memo for withdrawal dated 13/1/2025, which reads as under. The memo for withdrawal also annexes annexure A, which is, no, just say that. Cut the last sentence. He reiterates the prayer for withdrawing the appeal.
Yes, my lord.
Okay. The appeal is dismissed as withdrawn.
Oh, yeah.
Just reproduce the memo, contents. Give us
13.
Give us the CPC now. CPC. What is the challenge, Mr. Ravishan?
Lords, an application is filed under Order 21, Rule 97 and 98 before the executing court, which was seeking to enforce a award passed under the Arbitration Act. Lords, the application is dismissed on the ground of its non-maintainability.
But how is this appeal maintainable?
Lords, any order passed, Lords, against an order passed under.
Under 43 only?
Lords, no, not under 43, because if your lordships were to see, Lords, Rule 103 of Order 21, this becomes a decree in an execution proceedings passed by the commercial court. It's an appealable order, which again eventually becomes appealable.
No, let's see 43. We
Please.
will only confine ourselves to 43.
Please.
Thus 43 refers to Rule 103.
Lords, does not refer.
Then, see, if you see 13(1)(a.
Lords, if your lordships were to see, Lords, any Matter decided under Order 21, Rule 97, 98, under Rule 101.
Right,
It determines the rights of the party which is appealable under Rule 103 as a decree.
right. But surely now this appeal is under 13(1)(a).
Yes, that's the reason, my lords. I'll have to only demonstrate that this order is appealable. Because once an appeal is maintainable under the Code of Civil Procedure, then it becomes appealable before lordships as a commercial division.
No, but we will see 13(1)(a), which is the enabling, which is the
Lordships.
provision.
It could.
Does 13(1)(a) refers to 43? Does 43 refers to this is an appealable order under?
But this is an appealable decree, my lords. It's a decree. Under
don't know.
103, Rule 103, it becomes a decree. Rule 103 of Order 21, if your lordships were to see, my lords, Section 13, any person aggrieved by the judgment or an order of the commercial court below the level of the district judge, so and so, then 1A. Any person aggrieved by the judgment or order of the commercial court at the level of the district judge, exercising original civil jurisdiction as the case may be, commercial division of High Court, may appeal to the commercial appeal of the High Court within 60 days, provided that an appeal shall lie from such orders passed by the commercial division or commercial appeal that are specifically enumerated under Order 43 of the Code of Civil Procedure as amended under Section 37 of the Arbitration Conciliation Act.
That's right. So the scope.
But see, it doesn't, there is one division bench judgment, my lords, if that was because it doesn't restrict the scope, my lords, of the appeal under only for those orders which are appealable under Order 43. Those which are appealable under Order 41 is also appealable as a commercial appeal before your lordships. Let us assume that a commercial court dealing with an original jurisdiction passes a decree. That is appealable under Order 41.
Right. You're right, where ultimately final determination is there.
Yes.
Then it's an appealable according to you.
Yes.
That's the.
That's what it
But
is.
how would you come over?
Because I remember having appeared in this matter, my lords, where the coordinate bench had taken the view that this does not restrict it to Order 43.
We want to see that because it says 43 here. Maybe there is an interpretation. Will that mean that even
Otherwise, my lords, what happens? Every decree which will be passed by a commercial court would not be appealable before your lordships because the appeal doesn't lie under Order 43. Order 43 speaks about the appeal against the orders. Basically, the interlocutory orders in which some rights are determined, not the final disposal.
Show us the judgment.
I'll do that.
Just show us the judgment.
Tomorrow or day after, my lords, subject your lordships convenience. That's the only point.
We'll have it next week, Tuesday.
Very well.
Just say that at the request of Mr. D.R. Ravi Shankar, Senior Counsel for the appellant, re-notify
21-1.
Tuesday.
21-1.
Lordships.
14.
But I appear for the appellant, my lord. This is one where an appeal does not lie, my lord. The office is right. Because it's an order not returning a plaint, but challenging the dismissal of an order of an application seeking return. So therefore, my lord, would your lordships grant me liberty, my lord, to.
The learned counsel for the appellant fairly stating that the present appeal shall not be maintainable intends to withdraw the same.
Please.
To seek such remedy as available in law.
Please.
Dismiss as withdrawn.
I'm so grateful.
15.
Lords, serial number 12, my lords, we have withdrawn the appeal. The court fee may be funded, my lords.
File an application, separate application, file it.
Sure.
Okay.
Yes, my lords. All clear.
15.
My lords, the same issue of maintainability arises. My lords, if I may be granted liberty to convert it into a writ petition or avail such remedy as a.
Better you file it. Writ petition, then grounds, everything would be there. The format would be different.
Please, my lord.
Just say that learned counsel for the appellant fairly stating that the present appeal may not be, is not maintainable, intends to withdraw the same.
I'll file a memo of withdrawal.
Have you said so? See that you may get the benefit of this so many days whenever you will go. Show, give us. See, just say that learned counsel for the appellant has filed, appellants has filed a memo for withdrawal, which reads as under learned counsel for the, in view of the memo for withdrawal, the appeal is dismissed as withdrawn. Okay.
Benefit under section.
And to seek, to enable the, to enable the appellants avail such remedy as available in law.
And the benefit under section 14.
You will work it out. Suppose you were not there. Now, what is the remedy you wanting to seek? Writ appeal.
Writ appeal or a writ petition under two.
That in any case, you will get it. Next.
Obliged.
16. Serial number 16. Is Syed Ahmad Shah.
Yes,
Serial number 16,
just pass over members.
17.
Here for appellant in this case.
My lord, this
What's
the
that?
appeal is, my lord.
One office objection, my lords, is on
Appeal
production
is-
of color photographs.
Appeal is, my lord.
Annexure N, my lords.
Appeal is meritless, my lord, for the reason. May the learner single judge by affording opportunity to both parties may by calling for the report from the Panchayat Development Officer notice that there is a apparent obstruction is made to the respondents, my lord, access to the residential
Lords, may
house, my
kindly
lord.
see page
Just
11.
for a purpose of ego, my lord, this writ appeal is filed. Absolutely, there is no merits, my lord. There, the dispute is with the brothers. The learned judge has taken care of the interest that he shall be relegated before the civil court. My obstruction to the residential staircase has been obstructed, my lord. For that purpose, learner single judge has called for the report through the Panchayat Development Officer. He has noticed that there was a recent obstruction is made. Now, my lord, gaining the access, my lord, is a fundamental, my lord, my access, my lord.
Yes,
My lords, may kindly see page 112 annexure N, my lords. That is the office objection regarding furnishing of color photographs. That is, this photographs was produced by the petitioner, my lords.
but he had actually shown it in the impugned order also. If you
Not that
see-
photographs, my lords. But
It's a
annexure N,
different
there's a
photograph.
Page 112 of the writ appeal, my lords. This was the photograph which was produced by the petitioner before the learned single judge, my lords. I do not have the colored photographs. Therefore, that office objection has to be overruled, my lords. That is off.
That's the objection.
That is the only objection.
You have that photograph?
Yes, my lord, 112.
No, the color one. It appears to be a sort of a corridor, you know.
Yes, my lord, the obstruction is made, my lord, here by putting the permanent obstruction to reach my house.
Just.
Yes, my
in the
lord.
front.
From this way, my house entrance is there. His contention is that I have to pass through some other area of corner and this is the
That is not
permanent access
correct.
available.
If my lords permit, I'll
Let's see, what does the single judge say?
kindly see. He has a separate access to his building, my lords. There are two separate buildings. I'll show the colored photographs, my lords, which is at page.
What is the difficulty here? What is your position or your case in law
My lords,
that he is not entitled?
He wants to access his building through my staircase, which is in my building. We are brothers. It's my building is separate, his building is separate. He has a separate entrance from the main road.
For how, okay, very well. For how long you have been, this position was existing? He was using it.
This was not there, my lords. In 2018, my lords, I obtained a modified plan, my lords, to put up construction of the second floor. I put
Paragraph
up
number
construction
6,
of the second floor, my lords. At that point,
Then you will work it out. Was it a writ petition?
no, that is
Paragraph
what, my
6,
lords,
my lord.
the executive officer says, directs the respondent number 3 to go to civil court. He challenges this order before the learned single judge. Single judge says, asking me to go to the civil court. My lords, he wants to claim access to his property through
But
my.
in any case, tell us one thing, interstate dispute between the brothers is a civil dispute.
Please, my lords.
It would not be amenable insofar as 226 is concerned.
Correct.
Now, what was a duty on this local authority which has been violated
There is,
between both of you?
well, as far as the local authority concerned, my lord, there is no violation. They give an approved plan to me, my lords. In terms of the plan, I put up construction.
You will work it out.
Well, that is
That is what
incorrect.
the executive officer says. Directs him to go to civil court. He raises a dispute before them. No, that is challenged before single judge. See, single judge per se says that I should go to civil court when he is claiming access through my building. My lords, if he says or shows any document that he has any right, my lords, of access through my building, my lords, I have no case before this honorable court. That is not his case.
Paragraph 6, my lord.
Nowhere he says that he has right.
Paragraph 6.
But what the learner single judge has said, he has rejected set aside that order also to remove the.
Yes, my lord, because the panchayat, my lord, noticed that the obstruction made is, my lord, without, my lord, obtaining the permission from the panchayat. He has put up a permanent structure without there being any, it was, excess was there. That is why, my lord, paragraph 6, the learner single judges
So
observed.
in the original plan,
Yes, my lord.
this obstruction was not there. This
That is why
construction.
learner has stated, my lord, in 1995, the third respondent is categorical that this staircase has been in existence from the year 1995. But a fresh plan is obtained to construct second floor as seen in the first floor. However, the third respondent contends that because the subject wall is constructed within his property, the petitioner cannot have any complaint about the construction of the wall. The third respondent asserts that therefore it is justified denying the existence of staircase. But after to ascertain this, learner single judges called for the report. Panchayat has submitted the report.
Tell us one thing, you had put that wall?
My lords, in 90,
You had put
yes,
that
yes, my
wall?
lord, in terms of the plan, in terms of the plan.
Is it in terms of plan?
Please, my lords, plan is
Now, how
produced.
do you, then let's see what is the basis for the learner single judge to set aside. If it was in accordance with plan,
Please, my lord.
then he could not have directed it.
My lords, what the confusion the learned single judge had, my lords, that in 1995, my lords, there was a ground and first floor of the building, my building. He had ground first and second floor. He was using the other stairs, my lords, to the main road. In 2018, my lords, I obtained a modified plan to put up the second floor, which is at page 140 of the writ appeal papers. I put up the second floor. At that point, my lords, the wall is constructed to his building. He had no access there. Now, what he says is, he wants to use my stairs, which is easier for him, to go to his second floor, whereas he has a separate access from the main road. I have produced a photograph.
See, we want to know,
My
the
lord.
plan per se has this construction, yes
Yes,
or no?
yes. My lords, may
Where
kindly,
is that? Where is that?
my lords, page 140, my lords. I produced the approved plan.
One forty?
Page 140, my lords.
140?
Please.
You can't see it, we can't make it anything. Show us this. Yes. Now, which page you said?
140. 140. Plan. My lords, the proposed second floor plan, which my lords is the second portion of the plan.
Now, we are concerned with which portion?
But it's now second floor, my lord. On the. My lords, it took the.
We
got
want
the-
to know
My
the
lords,
construction which is there, which has come about,
my lords,
which is sought to be, directed to be removed, is which part of this plan?
my lords, in the plan, my lords, the second portions, proposed second floor plan on the southern side, my lords.
Yes,
My lord sees there are stairs.
that's right, on the right side.
Please,
Huh.
that is the portion, my lords, where my lords will find it. the
So
sta-
one climbs the stairs
Please, my lords.
and this portion is the construction.
Mark
Which
it in.
portion is the construction?
I'll mark it in.
Just show us, and just take that.
I've marked it in the pencil.
Staircase is there, my lord. 149 is the obstruction. The exact picture, you also could get it 149. Ma'am. That is access made, which is already arrangement is there. But my lord, just to prevent my access, my lord, he has unlawfully blocked this. 149 is the picture by putting a gate.
No, my-
Besides that, a stone
My
compound.
lords may kindly compare this with page 60.
Yes, my lord.
This is the gate you are talking of.
Yes, that was.
No, no, not the gate.
This-
That
this
that is
has
the
been
gate
put
to his
now.
house.
This has been put. This is the arrangement made available for me. For the purpose of blocking me, he has put up a gate along with his compound wall.
Said there is a permanent structure which has come.
Common, my lord. You also may kindly see the resolution before that. You also may kindly look into the Panchayat resolution. Panchayat resolution, they say it's unlawful construction.
Since my
Kindly see
lords-
page 70, my lord.
Since my lords are in my plan, my lords may kindly see page 61, the plan which is approved in his favor, my lords.
It has been deliberately done. Page
It
70
shows
is the
that, my lords,
resolution.
there is an opening to the northern side. Page 61, my lords, is the plan which he has produced before the learned single judge.
We want to know what has been directed by the learner single judge
My lords,
or the authorities to remove it.
Yes.
Is reference to which area?
my lords, authorities did not ask me to remove it, my lords. They relegated him to civil court. That was the order.
No. Your Lordship, may kindly see annex 70, my lord, page F. Page 70, my lord,
Just one
Panchayat
minute.
resolution.
Come to page 24, the direction.
Please, my lord.
Allowed endorsement dated is squashed,
Please, madam.
directing the third respondent. Who was third respondent?
I was the third respondent, my
To
lord.
remove the obstructing wall within period of 4 weeks.
Please, my lord.
Now, what is sought to be directed is to remove that wall.
Please,
Which is the wall he is referring to?
The one that I have marked, my lords will find that wall. I will show the photographs.
Surely this gate gate is not the removal.
Gate is not the.
The obstruction, my lord, by way of putting the laterite stones, my lord. Besides that door was available for me by locking it. Besides that door inside, my lord, he has put up the laterite compound one stone.
Behind that,
Yes, my lord, to
Yes.
deny the access.
he has put a wall.
Yes, besides that gate. Now, your Lordship, may kindly turn
My
to
lords,
page
may kindly
70
see what
resolution.
my lords are referring is page 149 photograph, my lords.
See, we don't understand, just a simple. There is a door you have put at.
No.
One minute, you listen to the court now.
Sorry.
It should be clear. You said 149.
Yes, my lords.
Now, and mind it, what impression we are getting from your submission is this. This is the door.
Please, my lord.
This is the door. It's not a door per se, but one is visible through across. Now, what is being said is behind that, a concrete wall has been put. Is it yes or no?
No, my lords. It is his building access.
It has been reported through this report, my lord, personally
What
inspected.
are your
Learned Singhal, they directed the concerned panchayat to make a spot inspection and whether he has constructed a wall in this staircase, my lord. On spot inspection, my lord, it is true that he has put a wall in between that.
So how do you come out of that?
My lords, if both the respondents, my lords.
One thing, let's be very clear. We will be very clear. If it is thing found to be incorrect, we will take it to logical end.
My lords,
We will not any misrepresentation being made here.
there is absolutely
Let's
no.
be very clear
There is
and mind it, and we will reiterate it. Now, what are you saying is, this is the door? No, we are asking the authorities.
Yes, my lord.
Behind this door,
Yes.
there is a concrete wall.
Yes, he has constructed.
Are you sure of that?
Yes, sir, that is the inspection.
You have heard him? You
Yes,
have heard him?
Yes, my lords.
Yes. Now, what do you want to say?
My lords, that is incorrect, my lords. First thing. Second thing, my lords,
Where do you say in
My lord-
your appeal,
my lords.
what has been the basis for the learned single judge to conclude so is an incorrect finding or their report is incorrect? Where do you say so?
My lords, in paragraph.
And where is the reference by the learned single judge about a concrete wall having been constructed?
My lords, may kindly see page 15, para 23 of my appeal. Page 15, para 23, my lords, regarding the report. Para 23, my lords, page 15. My grounds, my lords, page 15, para 23.
No, page 15.
Page 15, 15, my lords, page 15, para 23. Not it is submitted that the report dated so submitted by the respondent number 1 panchayat is completely contrary to the approved building plan issued by the respondent number panchayat in favor of the appellant. The learned single judge does not consider the fact that the said report is also silent on the fact as to in whose building or property the wall is constructed. It is an admitted fact that the said wall is in the building or property of the appellant and it has nothing to do with the respondent number 3 or his access to his building. It is ironical to notice that the respondent number 1 panchayat is directing the appellant to grant access to respondent number 2 to the building of appellant. This is clearly contrary to the rights of the appellant and it affects his privacy.
See, you're right. Does the plan contemplate that structure or that wall? Yes or no? Intersay between brothers is an issue which you will work it out.
Please, my lord.
We just want to know that whether, and it appears the intent of the learned single judge was only this, that this wall is not part of the plan. Forget it. Who has the right to access? Whether he doesn't have the right to access, it's only you. That's an interstate dispute.
Yes.
As a part of the plan, does a wall exist there in
Yes.
terms of the plan?
Yes, ma'am. That is
Does
what
it exist?
Yes, sir. That is what I have marked, my lords.
This, my lords, may kindly compare with this plan, which
There is the wall in the plan. We want to know that.
it's a closed structure. There is no opening for him from that second floor. My lords, may kindly see that marking which I have done. My lords, it's a closed structure. There is no opening. Now, my lords, kindly compare this with page 61, the plan which he has produced. My lords, I can understand if he had no access to his property from his building. Page 61, my lords, the plan which he has produced.
But page 155,
On-
report of the.
On the
concerned,
northern side, my lords will see,
based
my
on the
lords,
direction of the court. That is the report after spot inspection.
page 61, my lords, got it, my lords. The plan on the northern side, my lords, there is no opening for him. There are several litigation between the brothers. To cross a event kai, my lords, he puts a gate, files a complaint before the panchayat, my lords. He was the former president of the panchayat. Tries to get an order, my lords. I go before the executive officer.
Just 1 minute. Now come to 156. See the last 4 lines. That's what they say. And we are only on that.
Please, my lords. That is
Do
the,
do you have the permission
yes, my lords.
from the panchayat to have a wall at that place?
That is the plan which I have produced before.
We
my-
don't know. This is what this thing is.
My lords,
Now, is it your case? Do you have the license to put the wall?
yes, my lords.
How? Show us.
That is the plan which I have produced, my lords. My lords may call for the.
How would you know? How would we know this is there is a wall or not? Now you are making good. You are saying that there is a wall. You also don't deny it.
Yes, my lords.
Now question is only the way they have put it. That whether you have the permission to put that wall at that place.
May I make a request, my lords? My lords may kindly direct the panchayat, my lords, make a statement as to where exactly the wall is, whether it is in my property or his property.
Irrelevant. For them, interstate dispute is not relevant.
Please, my
For
lord.
them, it is there is a building has to be in accordance with bylaws.
Yes, my
There
lord.
is a wall which has been constructed, whether that permission has been given by them or not.
That is what I have produced at it's an approved plan, my lords. Let them make a statement, my lords, whether the
The
bill
approved plan was of which year?
2018, my lords.
Very well. Now till 2000, even after 2018, there was an access from that place.
No, not to him. Not to him, my lord.
When was that wall raised?
Immediately, my lords, in 2021, when the construction was completed.
Very well. So 2018, when the plan was approved,
Yes, my lords.
there was no
There was
wall
no-
there.
There was no second floor at all.
May not be. But what we are saying is, in terms of the plan, there was no approval of a wall at that place.
Yes. My lords, I'll clarify it, my lords. My lords, there is no separate approval for a wall, my lords. What they are saying is, I am permitted to construct this wall, my lords, towards this portion. He says there was an opening here for him to access his property. My lords, I need not take a separate permission for my lords. If at all there was an opening, I am saying, my lords, if at all there was an opening, I need not take a separate permission, my lords, when they have an approved plan for the entire floor to close it off. If at all there was an opening, I'm saying. But what I have done, my lords, I've constructed the wall in terms of the plan. Now they are saying to put up a separate wall also, I should take a permission. That is not the case here.
See, that's their case.
Please,
That's the panchayat's case.
Please, my lords.
That there is no license to construct a preventive wall.
My lords, let them verify in accordance with this plan, my lords, whether I put up the construction or not.
No, this is what they have.
That is
said.
incorrect, my lord. That is what I have said in my appeal papers also. That is what I.
And mind it,
My
what they say is there is no license obtained from panchayat to construct that wall. That's what they say.
There is license, my lords. I have produced it approved plan. It's an approved plan. They can't go contrary to the plan, my lords.
Where is the license?
My lord, what I have produced is the approved plan. If my lords grant me time, my lords, I'll produce the license also, my lords. Approved building plan, approval dated. Just on page 131, there is an approval. My lords, page 131, my lords, the approval which is granted in 2018. 130? 131, my lords, page 131.
Direct answer is, my lord, your lordship question is available at page 70, Kannada, madam, and my lordship's learner brother can, my lord, understand the language. Translation is also 70, my lord.
Excuse me.
ಪಂಚಾಯತ್ ಅನುಮತಿ ಇಲ್ಲದೆ ಕಟ್ಟಿರುವುದರಿಂದ ಮತ್ತು ಪ್ಲಾನ್ ನಲ್ಲಿ ಗೋಡೆ ಕಟ್ಟುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ there is no reference with regard to the construction of the wall as per the plan.
My lord,
This is the answer to your lordship question.
I am showing the document itself, my lords, which is at page 131.
Translation is at page
which is
72.
issued-
That is the straight answer to your lordship's question. ಗೋಡೆ ಕಟ್ಟುವ ಬಗ್ಗೆ wall, with reference to the wall, there is no reference under the plan. ಗೋಡೆ ಕಟ್ಟುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಮತ್ತು ಮೇಲ್ನೋಟಕ್ಕೆ ಓಡಾಟ ಮಾಡಲು ತಡೆ ಒಡ್ಡುವುದರಾಗಿ ಕಂಡು
And
ಬಂದಿರುವುದರಿಂದ.
that
So
is my-
it is apparent violation.
And that is my whole case, my lords. He was the former president of the Panchayat. He ensured that such an order was passed. I go before the executive authority. He assesses the issue, my lords, and says, directs him to go to civil court.
Right, we are still holding that. Inter se between brothers, it has to be. We are only testing from the anvil of whether this plan is in accordance with the bylaws of the panchayat.
Page 131, page 131, my lords, the approved plan. This is the Kannada version, my lords, translation at page 133.
Now come to page 133.
Please, my lords.
Which portion of this thing, this document
My lords.
says that wall which has been put has been permitted? See, you may be right. You can say so that he can't access to his portion from your place. You
Correct.
can say so.
That is my whole.
But you're right, but that would be between you.
Please,
We are only concerned with panchayats. The whole case, the learned judge has only looked into from that perspective. Say this wall is impermissible, leave it at that, and you remove it.
if I may understand, my lords are saying that there is no approval to put up that construction is the only issue.
They say,
Please, my lord.
panchayat says,
My answer to that, my lords, is page 131, the approved plan, approval which they have given in 2018, and a plan which is approved, which are placed before my lords at page 140. Now let them, my lords, my lords, technically, my lords, they should have said whether the wall is in whose building and whether it is in terms of this plan.
they will not decide the interstate dispute.
What they cleverly do, my lords, they do not say where the wall is. They say they could not have put the wall. That they cannot do, my lords. They should say whether the building is in terms of the plan or not. They do not do it.
Is the plan contemplates a wall at that place wherever the wall has been constructed?
My lords, there
Yes
is-
or no?
Yes, my lord. There is a complete closure on that portion, my lords.
It was complete
Yes,
closure.
that is what I have marked, my lords.
It was a complete closure.
Yes, my lords.
So according to you, there was a license in terms of
Yes.
the plan, there has
Yes.
to be. What do you have to say on this?
My lord, that is the reason, my lord, the lordship exceed the page 71, that is a resolution by the panchayat also. So far as wall is concerned, my lord, there is a obstruction or there is no permission from this, page 71, my lord. That is a translation copy, page 70, the resolution.
See, mind it, if you see 74,
Please.
we are just reading 6 lines from the bottom. It says, since the wall, you got that?
Yes, my lord.
Since the wall across the gate is constructed without permission of the panchayat, and as there is no reference about the wall in the plan, mind it.
Yes, my lord.
And prima facie, as it appears that obstruction is caused for the moment, we are not concerned with this. We are not the court, even the learner single judge is not concerned about the movement. If the movement is there or not is irrelevant. What is relevant is the wall. And for that, there is a permission or not, that's all.
Therefore, I said, my lords, cleverly, my lords, in their report, they do not say whether that wall, my lords, is a part of this plan or not. They should have said it. My lords, may call for the report, whether this wall is in terms of this plan or
They
not.
have said so.
But this,
The last 3 lines, as there is no reference about the wall in the plan.
my lords, this is the point, my lords. He was a former president. He ensured that such an order was passed. I go before the executive officer. He says this cannot be done because there is a plan. Go before the civil court.
How would you say so that that this plan contemplates a wall?
My lord, that is what I explained, my lords. My lord, what they permit, my lords, to close this side of the portion, my lords. I have closed it. Now they are asking me to show a separate plan for putting up a wall in a closure. It is not possible for me also. What I have done is, my lords, I have put up the wall in terms of the plan. They are saying that the alleged obstruction which my learned friend is saying for respond number 3, they say for that alleged obstruction also you should produce a plan. My lords, when they permit me to put up the entire wall, can I obtain a separate permission, my lords, to put up a closure?
Pardon?
My lords, they have permitted, my lords. This is the building, second floor, my lords. They have permitted me to put up this side of the portion, my lords. I'm permitted in terms of the plan to completely close it off. I have done it. Now, because there is an allegation that there was an opening and he was permitted, respondent number 3 was permitted to use it. They say that I have closed it now, or that portion of whatever was permitted, I have closed it now. For that, my lords, should I obtain a separate plan, my lords? If at all,
No need. No need. But if the plan does not contemplate a wall, what will do? Can you construct it? You can't.
I cannot, my lords.
That's what they are saying.
But it does, my lords. That is what I have marked. I am permitted to construct the entire portion.
You are not an engineer.
My lords,
Why? How do you say that it contains a wall?
my lords,
It is a staircase.
my lords, next to the my lords may see the photographs. Next to the staircase, my lords, I can't keep it open. It's a separate building next to me, next to my building.
Photograph says it is a staircase and there is a gate. How do you say that it was?
That is what you have to put. Therefore, I said, my lords, if he is able to show from his plan that there is an opening from his building to my building, my lords, then they have an okay. My lord may kindly see his photographs, his approved plan.
What is the difficulty to remove the wall?
My lords, he wants to come to my building and
You're not understanding. You remove the wall,
my lords,
put a lock on the door.
Complain that.
That will not give him access.
I have not at all put that gate, my lords. It is he who has put the gate next to the wall.
You can put a lock.
Just comply the order of the single judge.
That's all.
My lords,
On an accessibility between both of you, we'll go to the civil court.
Correct.
not the,
On the accessibility through that gate, we'll go to the civil court, work it out.
my case is that, my lords,
That is why, my lord, the learned single judge reserved that right. Because of the reason, my lord, page 154, in his presence only, this photograph, it is very much visible, my lord. He was sitting there. The Panchayat Development Officer is there. He is showing that this is the access reachable to my property. This has been boxed. The Panchayat Officer himself has visited in this property as 153 and
my lords may
154.
kindly see page 60.
I think that you can still achieve your purpose, not to access him.
My lords,
Remove the wall, put a lock, whatever you want to do it. Any dispute inter se will be worked out in the civil court.
my difficulty.
That is why learned
my
single judge
difficulty is
reserves
this.
that fine. Whether I am having the right or not, you work it out in the civil court. Before that, it is not as per
My-
the plan. That is why learned single
My
judge
We will
protected.
take Panchayat stand on record. It has been taken by the learned single judge.
That is what they have done, my lords. Cleverly, my lords, they do not state, my lords, whether the wall is in which building.
Follow
That is the whole difficulty. What he does, my lords, he puts up a gate. I have put up this construction. Towards his side, my lords, he puts up a gate. Files a complaint with the Panchayat, my lords, saying that I have not produced access. My lords may kindly see, my lords, page 61 his plan.
All disputed all these things. Yes, and we will take that stand. on
Page
the-
61, my lords, got it, my
Yes.
lords, the plan. My lords, if, my lords will see there's a elevation, my lords, front elevation section AB. The first two pictures, my lords.
Hmm.
Below that, the first picture, my lords, where my lords will see that there is a staircase at the bottom.
Hmm.
That is, my lords, is access, my lords, to the main road. What he claims, my lords, from that staircase, if my lords come straight, there is no opening for him to my building. Next to this is my building. There is no gate, nothing. If he has no opening
We
there,
don't know. This is what they say, you can still achieve, but there is a wall which you have put up after the plan was sanctioned. Are you right?
no, my lords got it confused, I guess. I will just say that. There was no second floor at all, my lords. It was only ground and first. Modified plan was obtained for putting up the entire second floor, not the wall. In terms of the plan, my lords, modified plan in 2018, I put up the entire second floor. What he does, my lords, to the wall which was facing him now, he puts up a gate, says that you are not providing access, he files a complaint before the Panchayat. My case, my lords, are specifically pleaded also. He was a former president of the Panchayat. He ensured that there was a direction to me to remove that wall or providing him an access. I go before the executive officer. I say that, no, this is not possible. See, there is a plan. The executive officer directs him, sir, if you want an access, go to civil court. He challenges this order before the learned single judge. Single judge calls for a report from the Panchayat. Again, from the Panchayat, my lords, he was a former president. Now, my lords, Panchayat says there was no license. I have produced the document before the learned single judge also, my lord. The plan was there. The approval was produced before the learned single judge. Learned single judge does not look into it. Learned single judge directly says, no. You remove it, go to civil court, Single judge directs me to go to civil court. My lords, I am saying if he wants access, my lords, to my property, I can understand, my lords, if he even shows a single line in his pleading that he has
See,
a
we
right of
don't know.
access.
We can't work it out whether there was a plan, there was a wall in the plan or not. Their stand is there was no, he doesn't have the license. That's all. You say so that he was the past president, we don't know. We can't go into all
Then-
these things.
Then in which case, my lords, my defense to their statement, my lords, that report I was also pleaded in my writ appeal that it is not not in accordance with the plan which they have approved. My lords may kindly see that plan which I have produced at approval letter is on page 131. Plan I have produced, my lords, where next to the staircase, I am permitted to put up the entire closure, my lords. I have closed it. No panchayat cannot say contrary to the plan, my lords.
We don't know.
Then
Their panchayat, we don't know. See, that's a disputed fact.
please, my lord.
How would we go into it?
Therefore, my lords, the learned single judge order requires to be set aside. The
Now,
respondent-
suppose as a fact, there was a wall. There should not have been a wall as a fact. Then they are right in what they are saying.
if plan did not contemplate a wall,
Don't know. That's your understanding that plan doesn't contemplate. Their understanding is otherwise.
therefore, my lords, I made a request, my lords, let the panchayat be called for, my lords, whether the next to the staircase, the wall is put up in terms of the,
How many times we will call for that? This is the panchayat stand before the learned single judge.
my lords, they did not specifically say, my lords, whether
conducting
the
this
wall is in my property or his property.
We will not go into that. Neither they will go into that. They will not work it out, the
Then, my
title
lords-
to the property or which portion you are in the, you are having the possession of which. This inter se you will go.
Yes, my lords, I
They are
understand. my
only
lords.
concerned with the bylaws.
Therefore, the report is wrong, my lords, in terms of the plan which I produced before my lords and all approval which is produced at page 131. They themselves have approved the plan. There is a wall, my lord, my lords are contemplating a portion. I am not saying that, my lords. I am saying on the southern portion of my property, they are permitted to put up a staircase. Next to the staircase, I can't keep it open, my lords. I have to close it, which they have permitted in terms of the plan.
Right. So that's what we are saying. You can think over it. You will remove the wall in terms of this, but you can put a lock on the gate. Purpose is solved.
Lords, then either,
His accessibility will be stopped.
then there will be opening again, my lords. He will get a relief before civil court saying that there.
Very well. You are everything. Obviously, if he gets it, he is entitled to, he'll get it. You can't apprehend everything. What is this? If he gets it, if you are unable to prove your case, he will get it.
That is what I'm
What is this?
demonstrating
Okay, it's
before.
all right. We have heard a lot.
My lord, that is what I'm
Second.
demonstrating before my lords, my lords.
We will
Kindly-
not, it's a purely a disputed fact. You say the plans has a wall, which they say it doesn't have, and you could not have put it without their permission. That's their stand.
But that is
My lord-
infinite is what I'm saying by way of the plan which they have approved themselves.
Okay, very well. Just say this, the challenge in this appeal is to an order dated 21st March 2024, passed by the learned single judge. Yes. In writ petition number 2361 of 2023. Whereby the learned single judge has passed the following order. The writ petition was filed by the respondent number 3 herein. Wherein he has challenged the endorsement issued dated 7/12/2022. Issued by the first respondent, namely your respondents 1 and 2, who has informed the respondent number 3 that as he is complaining about the construction of a wall, but the dispute in relation thereto is a civil dispute. Therefore, the same has to be resolved by the civil court. Full stop. The respondent, the appellant and the respondent number 3 are brothers who own adjacent built-up properties. The respondent number, very well, full stop. The subject matter of the dispute is a wall which has been constructed, which according to the respondent number 3
Yes.
is affecting the ingress and egress of the respondent number 3 to his portion of the property. That's right?
Yes, my lord.
Full
To
stop.
reach his residential building.
Full stop. It is noted that the learner single judge has called for a report from the respondent number 1 and 2. Full stop. It is represented by the said respondent that the construction of the wall by the appellant herein was a recent one. Full stop. The submission of the learned counsel for the appellant. Full stop. It may be stated here that the basis for the learner single judge to allow the writ petition filed by the respondent number 3 in the manner stated above is primarily on the basis of the stand taken by the respondent number 1 and 2 that the appellant herein had not taken any license for the construction of the wall. Full stop. This stand of the respondent 1 and 2 is being contested by the learned counsel for the appellant by stating that such a stand of the respondent number 1 and 2 is contrary to the plan as approved by the panchayat. In other words, it is his submission. The plan contemplates a wall, and as such, the wall is not contrary to the plan as approved by the panchayat. Full stop. This plea of the learned counsel for the appellant is contrary to the stand as taken by the panchayat, respondents number 1 and 2. Full stop. The same is the same respondent 1 and 2. Full stop. In view of the report as submitted by the, you just say this, the counsel for the appellant also states that the report cannot be relied upon, as the respondent number 3 was, what was he? The previous panchayat?
Not so. Former president, my lord.
Was former president of the panchayat. Full stop. And as such, the report was in his favor. Full stop. Where is the, did you take such a plea before the learner single judge?
No, not taken.
I have.
It is
My lord.
I have.
for the learner single judge.
Yes.
Not the report, my lord. Resolution of the Gram Panchayat. Report is pursuant to the direction of the single judge. That is.
The resolution, very well. The resolution of the Gram Panchayat
Yes.
was in favor of the respondent number 3, as he was the president, was the previous president of the panchayat.
Vice,
Could not- and
sorry,
could-
my lord. Vice president.
Vice president, and could not have been relied upon. We are unable to accept such a plea, as it is a conceded position that no such plea was advanced before the learned single judge. Full stop. We see no reason to interfere with the impugned order.
My lord, such a plea was taken, my lord. Page 115, para 8. My statement of objection starts at page 113. At page 115, para 8, my lords.
Where do you say?
My lords, the petitioner has
No,
ensured.
what we are saying is this, kindly understand. What you are saying is, being the past vice president, the report was in his favor.
Not the present report, my lords, which was filed before the land single judge.
No, the resolution.
Yes, my lord. That is what I have stated.
Where do you say so?
My lords, in view of such previous position held by petitioner, the petitioner has ensured that the respondent number 1 panchayat in its proceedings vide annexure F direct the respondent number 3 to remove the wall constructed over the respondent number 3's property, in spite of knowing fully well that the said wall is constructed in the property belonging to the respondent number 3. I've stated.
We are on a different issue. Plan contemplates wall or not. Their case is there is no license for construction of wall. There is a difference. Getting the point?
My lords, para 5, my lords, page 114, my lords. That the respondent number 3 had obtained approved plan from the respondent number 1 panchayat way back in the 94-95 to put up construction of ground and first floor over the respondent number 3's property, that is so and so. Pursuant to this, in the year 2018, the respondent number 3 obtained permission and revised approved plan to put up construction of the second floor in the respondent number 3's property, and in terms of the said plan, the respondent number 3 has put up construction over his property. The respondent number 3 has put up construction over his property in terms of the plan approved by the respondent number 1 panchayat. That the property of the petitioner lies towards the southern side of the respondent number 3's property. The property of the petitioner is facing the main road and it has a separate exit and entry point for accessing the entire building from the main.
Right. No issue on this. We are only on that wall has the license, have the approval of panchayat. That's all.
That is my case, my lords. I produced the approved plan also, my lords.
That's right, but they are contesting it. And that's a disputed fact.
Please.
We do not see any reason to interfere with the order. Insofar as that liberty is there, you will work it out before the civil court.
Right.
So dismiss. Next.
My lords, initially, my lord said respondent 1 and 2 have directed me to remove the wall, my lords. It was only respondent number 1, my lords, not 2.
Okay, respondent number 1 said, not the executive officer.
Not the, yeah, in fact, directed him to go to civil court. The executive officer directed the respondent number 3 to go to civil court, not me.
Okay. So we say respondent number 1.
1.
Okay. Respondent number 1. Next.
18, serial number 18, Ramesh.
Yes, take the plan.
I wait in tomorrow, my lord. Senior counsel not well. I number 1.
The order shall be executed within a time frame limit. Order.
He say nothing.
Please.
We are only considering the appeal that you will work it out.
Please.
Tomorrow, my number 1 stay application. Very urgency.
You said item 18.
18.
What are these photographs which is referred to?
Construction of the building, my lord.
Just show us the file.
number 1. Stay application. Senior counsel tomorrow.
They say at the request of counsel, a request for adjournment is made on the counsel for the appellant. Just give it after 2 weeks.
Of February,
Right.
serial number 19, Shri Prakash Angadi. 19,
Translated copy is ready, my lords.
Let translation of the.
Will be filed during the course of the day. They registered.
During the course of the day, vide e-filing.
Please. my lords.
20th March. Serial number 20,
This matter I appear for the petitioner. But so translation copy notes R3. If my lordship permits notes. Short matter notes. Premature transfer. Not of the petitioner, IAS officer, not of the challenged the not of the order of the Central Administrative Tribunal. Wherein not of her application, not of the seeking to set aside the not of the premature transfer is held negative, not of against which models we have prepared not of this petition. Not of the rule, not of the cadre rule says minimum tenure is not of the 2 years. But she only came to that post on not of the 11 months, 22 days. Without my lords, any administrative exigency, my lord of the, she has been transferred from my lord of the Uttar Kannada to.
How many years now you have put in?
Lords,
Now
2000.
that period has been now. Where are you now working?
Now, my lords, in Bangalore, my lord, in view of the transfer order, I came to Bangalore and my lord took the charge at.
Where were you transferred?
From my lord Uttar Kannada to my lord of the direct, my lord of the Uttar Kannada to my lord of the chief editor, my lord of the Karnataka Gazetteer Department, Bangalore.
Uttar Kannada to?
Yes, my lord. Deputy Commissioner Uttar Kannada, Karwa, to my lord of the chief editor, my lord of the Karnataka Gazetteer Department, Bangalore.
Now you are working as this department as chief editor.
Now, my lord, in view of this transfer order, which I have challenged before my lordship, now, my lord,
You have joined the place of posting.
my lord, now in view of my lord, the transfer order.
When did you join?
My lord, last month, May. My lord, after the transfer only, my lord, 5/7.
No, after the tribunal dismissed it, you joined it.
Yes, my lord.
Was there any stay before the tribunal?
No.
I think what remains
But
is this.
even not this honorable court, not when the prima facie, not the on the face of it, transfer order is not the bad in law. Not the this not may pass on.
Yeah. No, but tell us one thing.
Yes.
Has anyone joined as deputy commissioner Uttara Kannada?
Yes, no.
Then-
That not I have made her party, not I have challenged that. Has made
Pardon?
her party.
What is the name of the officer? Lakshmi Priya.
Yes, no.
She has joined.
Yes,
Now today, the
Yes.
2 years have been completed.
no, my lord. No, my lord. Not yet, my lord.
Very well. What is the reason for them, given by them for transfer?
My lord, the tribunal, my lord, may I take my lord directly to that page, annexure B, my lord. Page number, my lord, 52, my lord, last end. Government is empowered to take a decision in the interest of better administration. That is the, my lord, the observation made by the tribunal.
Who has passed the transfer order?
Not the government, not the,
Which government?
not the Karnataka state government. 43. Annexure R3, my lord. And A3, my lord, sorry, page number 29.
Who appears for the state government?
Please, Lord.
What was the reason to transfer?
There are allegations against her, your lords. Page 44, your lords. So may I kindly have it next week. I will get the instructions also.
Just 1 minute.
44,
Yes.
please, lordship and guides. The entire proceedings are extracted. More than 280 cases, change of land use was pending, your lordship, as on 36.
This Karwar is the Karwar is the base, naval base?
Yes, yes.
Please, lord. Please, lord.
I don't think in these facts.
Not a- only allegation, not they have made, only for the purpose of this transfer. Not they stated in the, not the, their objection that not I have not coordinated with the, not the naval authorities in solving the, not the local problems. Not they did not, they raise any objection at all. Not only for purpose of not transferring this lady from not there to not Bangalore, which has been not.
Where are the allegations? Where are the, who is the competent authority to transfer?
Not the government.
Government, there must be some, if you are alleging almost, the allegation is something which is bias or malafide.
Yes.
To make a party, look here, for these reasons, she has been transferred in your place. There is some justification given by them.
Not-
And
but-
tell us one thing, these allegations pertaining to, that's what this 44 says.
Yes.
That this issue is, have a national security
Not-
implications
Not a-
or national importance. Some
That
project
project
of
is-
national importance.
Not that project is long back started, Lords. It is not, Lords, recently, Lords, which is started. But even then, Lord, that naval authorities also, Lord, they should say that, Lord, the district commissioner did not cooperate with them. Nothing is there, not
See
these
page 40
person,
see page 44.
44, Lord.
Has not been coordinating with the naval authorities
Is
and is
not
not
government is-
solving the issues locally.
Yes, Lord. Government is saying now, Lord. His performance report, Lord, the compared to the other district, Lord, this is the best district for, Lord, the, for performance wise is concerned in the state of Karnataka. But that report is also there.
Now see, further, the official is not working by giving top priority to naval issues and project Seaward, which is the national importance. In spite of the district in charge secretary giving instruction to the said officials, the pending issues related to Navy and the project of Seabird have not been resolved. The principal secretary of the Government Revenue Department has enclosed the report which shows that the officials have kept.
Lord, this has been part matters on 1/7/2024. Not 5/7 is my transfer order. But before they could pass not of the transfer order, not of this has been passed. Earlier to that, my lord, there is no not of the allegation against it. Throughout her, my lord, since from 2006, my lord, she joined the service. But till date, my lord, there is no allegation against her.
It may not be, you know.
But not,
It's only a transfer posting, that's all which has been changed.
Lord, kindly see the rules, not. Minimum tenure is not the 2 years. Lord, here is not only 11 months.
See, we can't give it an interpretation to mean that that will be
At least,
actually.
my lord, let them show not some administrative exigency.
The report
Only,
was-
my lord,
no.
now, my lord, no, at the time of transferring, my lord, this,
That's what they show
Petitioner.
at page 44.
my lord, at
Page
the- my lord, this
47 is
order
also relevant, your lords. Para 18, page 47, your lords. The opportunity was also given, your lordship. There was a report also.
There is no opportunity has been given, my lord. Which has been
And the
held.
contents of the report were not challenged.
Ultimately, it's the decision or the discretion of the authority concerned.
Lord, even Lord, that decision should Lord before they could take. Lord, which has been placed before them, Lord of the committee. Lord, that is also Lord the rule says. They cannot Lord take Lord of the so moto Lord of the decision to transfer Lord of the deputy commissioner from one district to Lord of the other district. If Lord there is any administrative exigency, but within the Lord of the period of 2 years tenure, Lord such Lord of the such not think to be not the placed before the committee to not the take not the appropriate not decision to transfer not may take not rules also not.
Sure.
May.
And must say so. This must have been preceded by communications, correspondence from the naval authorities or the government of India.
No, Lord, there is no Lord. They have mentioned
How
that.
how will the state government on their own, without there being a correspondence of what they have said at page 44, transfer you? There
Not-
must be.
Only Lord at the time Lord all the Lord see since from 11 months Lord 22 days Lord she worked there. Lord till Lord says the order of transfer. They did not say Lord did not ask for anything. Lord their objection itself shows that Lord the she has been Lord the fastened the work and
To do one thing,
Please.
have the record,
No, I have not.
get the record, we will
Please.
see it, where
Please.
this transfer order was passed.
Please, Lord.
We'll see it. We will see it, what communication they got it from the government of India. Then I don't think we should take it further. Just say that just say that the respondent numbers, number
1, 2, 3, your lords. 2 to 3, your lords.
2 and 3 shall produce the relevant record where the decision was taken to transfer the appellant from Uttar Kannada to Bengaluru. Okay, by say day after tomorrow. Day after.
Typed copy English translation. Only R3 my lords, only one
Just
page
say
is
that
there.
Lena Council for the
But kindly have
appellant has
Monday,
filed
lords.
the English translation of which annexure?
Lord annexure R3 Lord produced before the
Annexure
tribunal.
R3, the same is taken on record.
Monday, lords.
We'll have it day after. Next.
21.
For the appellants.
Yes.
For short accommodation, my lords. Instead only I informed.
Sir, I think Mr. Chinnappa, both of you will will issue notice, file your submissions.
Yes, it's a short matter where the arbitral award has been upheld by the 34 court. In the 34 petition, my lord, no grounds have been raised, not even mentioned even of public policy. And my lord, today, of course, this matter has been pending now for I think 2 years. They've not even moved it over.
No, file your submissions.
Yes, my lord, short submission file.
Yes.
Grant me a short
The
date.
notice, so and so who accept notice, so and so accept notice.
Already on.
Counsel for the parties. Is the complete arbitral record here?
It's
Yes,
been
my
called
lord.
for, my lord. I think the records are here.
No, have you filed it?
No, my lord, last date the hearing
Call for record.
The records are here, my lord.
For
It
the
is-
court, my lord.
They are here, they are here. Counsel for the parties to file the written submissions along with the judgment, they intend to rely after 4 weeks.
Will
Within
it be a
4
shorter
weeks.
date, my lord?
Just give you a date, ma'am.
13th
Yes.
February.
Huh?
13th February, sir.
13th February.
Much of that.
Seal number 22, Shri K. Srihari. 22.
Appear for the response.
Appear for the appellant, my lords. This is the first appeal, my lords, filed by the defendant, my lords. The suit is one for specific
Yes,
performance of
Mr.
contract.
Hariga,
Yes.
what do you say?
My lord,
Have you filed any execution?
my lord,
Yes,
I
lords.
filed the execution for this is, the suit is one for specific performance of an agreement of sale. 19 lakhs was the amount agreed. Entire amount was given to the appellant and the suit was decreed. After the suit was decreed, he did not repay the amount. Then execution was filed. The execution petition was challenged in a writ petition. In the writ petition, they make a statement that the appeal was filed. That time appeal was not filed. They also make a statement, they will make the entire payment. My lord, that my lord finds a annexure
Just show us
3.
the file.
Annexure 3 to the additional objections. In the writ petition, they make a statement. My lord,
Is that?
page 10, my lord, annexure 3 to the additional objections to the application for stay. Worship got it, my lord? That is an order sheet.
That's for confirmation of delay.
Additional objection? Additional objection for what?
My lord, that is an order sheet in the WP 22176. Annexure 3 in the additional objections to the application for stay.
Stay.
Yes.
Additional objection. Objection.
ಕೊಟ್ಟಿದ್ದೇವೆ.
Application for stay.
ಕೊಟ್ಟಿದ್ದೇವೆ.
In that,
In that, annexure 3, kindly see the order dated 28/11/2023.
there is,
My lords,
put up agreement ನೋಡಿ.
it states,
Just show it to him.
Put up agreement.
Just please. Mira the
Next,
annexure.
read.
yes, ma'am.
Objections to stay applications.
Objections to the stay application,
Yeah,
which was what?
Next, Sila.
ಇದರಲ್ಲಿ ಹಾಕಿದ್ರೆ next ಸಿಲ್ವಲ್ಲ.
My lord, there was an additional objections which was filed, not found, madam.
That has not been-
Kindly have it, it is not found here.
Yes.
Right?
I do not have the
And-
copy of the additional objection.
My lord, kindly have it next week or any day convenient to this honorable court, because it says, learned counsel C.K. Srihari themselves for the petitioner would submit that the petitioner is ready to settle the matter by paying the entire amount due as of today in terms of the decree. This was on 28/11/2023. Thereafter, they did not pay. Writ petition was dismissed. Madam. Writ petition was dismissed on,
And the appeal was filed thereafter.
yes,
The appeal was filed after that order.
this appeal, my lord. No, thereafter, there was no appeal against this.
When was this appeal filed? Oh, this was
This
filed in
appeal-
22 itself.
Yes, this appeal was pending
Okay.
because for compliance of objections, my lord, before the appeal was filed, they make a statement before the trial court that appeal is filed. By that time, appeal was not filed. That was also, that annexure was also placed in annexure 2, my lord, which is not now before this honorable court. I will place it.
kindly have it next week. They make a statement before the execution.
Where is your copy of the objection? Show us, where is that order? Just take that.
Please. In that annexure 3 is the order in the writ petition. Annexure 2 is the
You have seen this.
It was not given to me, because I do
Just
not
show it
have
to
the
us.
copy.
Marked portion, annexure 3.
It's only the mode of payment that was to be.
Please, my lord, it is only the mode of payment, but my lords, in the suit, my lords, what the defendant states is he has taken a loan of 7 lakhs. And
And why do you give the statements?
lords, and
See, there has to be something need to be said. Otherwise, why the statement? They contested.
lords, please, my lords, on instructions only we would have made this statement, my
Obviously,
lords.
yes.
I'll find out, my lords.
And that's the reason you must take this instructions
Please, my
on
lords,
this.
please.
Just say this,
Now the court sale is, and the next date is, my lords, is on 24th, my lords, where the auction sale is already over, court sale is pending.
when is that?
24th January, my lords, so before that, any date, my lords.
We'll give you date and must say so. This statement has been made. And that you need to take instructions. Just say this, Mr. Ariga appearing for the respondent would contest the appeal by drawing our attention, by stating that against the appellant herein had filed a writ petition against an order passed in the execution proceedings.
Bringing
Wherein,
the property for sale.
wherein a statement was made on behalf of the appellant that he intends to settle the dispute with the respondent herein. And by paying the complete amount, just show us that order.
Please, my lords. Entire amount as
By
due
paying
as
the
of
entire amount
in terms of the decree.
in terms of the decree. Time was sought only to ascertain only to take instructions on the mode of payment. Mr. Ariga states that no steps have been taken by the appellant to satisfy the decree in terms of the statement made in the writ petition being 22176 of 22. The learned counsel for the appellant seeks some time to take instructions at her request. Just give it Wednesday, 22nd.
22-1.
Obliged.
Just give it to him.
Please.
Next.
23.
For the appellant in this matter, madam. IA number 1/24, my lord, to bring the loss of deceased respond number 3, my lord. The notice was issued and they were served with the notice on the IA also, my lord. Respond number 3, Kamlama.
What do you say?
represented by
Who appeared for R3?
Yes, my lord, I am for the R3.
Now, what do you say on this application?
That application may be allowed. I am already appearing for 3A, my lord.
I've already filed wakalat for respondent number 3A.
Is the amended memo of parties filed?
My lord, the respondent number 2 has passed away. The LRs already on record. I will make necessary correction in the first title along with this respondent number 3 LRs also.
Have the applications be, this 1/24 has been allowed?
No, my lord, not yet, my lord. Now that is under
But now
consideration.
you are otherwise appearing. Just say that 1/24. This is an application held by the appellant
Yes, my lord.
to bring the LRs of deceased R3 on record. Where is the application? For the being 3A, just say this, VG Krishna Gowda. And 3B, VG Anandagiri Gowda. That's right?
You are appearing for both or?
One
No,
more.
ma'am, only 3A, ma'am. 3A.
Only for 3A.
Only.
So
Other
and-
3B
so and
has been
so
served.
appears
3B has been served with the,
Saroda.
yes, my lord.
and so appears for respondent number 3A. We find that despite service on 3B, there is no appearance for the reasons stated in the affidavit in support of this application, comma, and the learner counsel appearing for respondents 3A has no objection, comma, the application is allowed, the aforesaid persons being the LRs of the deceased R3 are impleaded as, are brought on record. Let necessary corrections in the memo of parties be made. Additionally, amended memo of parties shall also be filed. Application disposed of, this the appeal for hearing on. This the appeal on.
Wait, wait.
Next.
18-3.
Let me shorter date, my lords. We have already deposited the balance sale.
Not
consideration.
possible. Next.
Great.
Sir, last week. Before,
Appear for appellant. My lord.
Respondent, my lord.
Last date of hearing, this honorable court had given 1 week time. The 50% of the amount, already on that day, DDs were ready, my lord. The reason for non-deposit, my lord, the counsel on record before trial court was unavailable. We had to file few applications for advancement of the trial court case.
See, we will not extend the interim order.
My lord, there is.
We will not extend.
I need 2 days time, my lord.
We will not extend for a day.
Lord, only 1 week time was granted.
Only 1
We
week.
will
Tell him to
extend.
comply the order.
DDs are ready, my lord.
Maybe.
I
They
will
were-
deposit.
They were ready on that day also.
On that day ready, my lord, counsel, he was undergoing treatment for 10 days before the lower court. DDs are ready, my lord. May I pass the DDs, my lord? For
Nothing
your,
doing.
for the honorable kind's perusal,
Even last
Court
year,
perusal.
interim order was not extended, my lord.
not extended.
It's not,
Not
extended.
I'll
extended.
deposit, my lord, 2 days,
It's
my lord.
not extend. We'll only grant them. How much time?
My lord, by Monday, I'll file the acknowledgement, my lord, for
The
having
learner
deposited
counsel
the
for the
50%.
Appellant seeks a week's time
Please.
to deposit the 50% of the 50% of the decretal amount as directed in the order dated 6/6/2023 before the court concerned,
Please, my lord.
before the court concerned, before the city civil court. His request re-notified. Just give it March. Hmm? Yeah, man.
From the registrar.
He has given it. We suffice to state that the registrar, City Civil Court, has submitted a report. Okay. The same has been perused. That's all. Next.
14-2,
Next.
serial number 25.
Filed a memo for withdrawal in the counter, my lords. It has not been listed. My lords may kindly permit me to produce another copy here, please, my lord. I'm withdrawing the appeal. Copy has been filed, my lords.
Year number 1 of 2024 filed by the respondent number 124 to direct the execution court to release the amount which has been deposited by the appellant is sum of rupees 50 lakhs.
What is this you are submitting?
I filed in the counter, please, my lord, on 13th. It has not been listed, my lords. A memo for withdrawal. So with the leave of my lords, I'm producing yet another copy. It's a memo for withdrawal, my lords. A copy has been filed in the registry, but it has not been put up because maybe it was filed later in the evening, my lords.
You want to withdraw the appeal?
Please, my lord, only seek two indulgences, my lord, my lords, my lord. One, my lords, the miscellaneous and the execution are pending before the same honorable court. My lord, the honorable miscellaneous court, my lords, may kindly be directed to my lord's issue, my lord.
Oh, this is 913 you have filed?
Please, my lord, please, my lord, please, my lord. Lords, they are seeking time, my lords, in the miscellaneous and going ahead, my lords, in the execution petition. My only indulgence, my lord, let there be a direction, my lords, to consider my miscellaneous.
In execution petition, my lord, no order has been passed. No order has been.
In any case, that 913 need to be decided first.
Please, my lord.
Let him decide first.
My lord, suppressing that, my lord, this appeal has been filed. My lord, now when I filed objection brought to the notice of this honorable court, they want to file a memo and withdraw it. But my lord, the grievance is, my lord, the decretal amount, my lord, now interest with calculated 5 crores 15 lakhs odd.
How much?
My lord, 5 crores 15 lakhs 62,950. My lord, they have deposited 50 lakhs. My lord, the the amount may be kindly be, my lord, my lord, may kindly direct the.
We say nothing.
Please.
He wants to withdraw it. We will allow it to withdraw it because of that pendency.
Please.
You both of you agree that first you will argue 913. Then proceed with the, whatever is the outcome, proceed with the execution.
Please, my lord. And then, my lord, I may be permitted to file application before the execution court, my lord, to release the amount because I filed application herein. My lord, then now they are withdrawing the appeal. But I may be permitted to file same application before.
Just say that Lena counsel for the appellant has filed a memo seeking withdrawal of appeal. Full stop. It is noted that a miscellaneous petition number 78 of 2020 has been filed before the court concerned, that is 42nd Additional City Civil Court and Sessions Court, CCH-14 Bengaluru. It is also stated by the counsel for the appellant that even the respondent here, the respondent herein has filed an execution petition which is also pending consideration before the same court. Full stop. It is agreed by the counsel for the parties that they shall argue the application filed under Order 9, Rule 13, being miscellaneous petition number 78 of 2020. And depending upon the outcome of the said application, the execution petition shall be argued.
Please.
Okay.
Please.
Full stop. Noting the said full stop, the learner counsel for the respondent also states respondents for all the respondents.
No, 1 to 4.
1 to 4. Just say 1 to 4. What about others?
He is also one of the defendant before the trial.
No, the contesting parties are who?
Please, 1 to 4. Please.
1 to 4.
He also states that that since the appellant is seeking withdrawal of the appeal, the respondents 1 to 4 shall file an application seeking withdrawal of the amount already deposited by the appellants before the city civil court,
Execution court.
before the executing,
Execution.
before the executing court.
Please.
Full stop. Noting the said submission and also the contents of the memo for withdrawal, appeal is dismissed as withdrawn.
My lords, court fees has been paid, my lords.
File an application, we will look into it.
Obliged, obliged.
Oh, delay, just call it. There is a delay of 2,000 odd days.
Please, more than 8 years, my lord, they filed it.
But since appeal has been
No,
withdrawn.
we will, this is also goes withdraw.
Please, my lord, please, my lord.
The appeal as well as the application, pending applications are dismissed as withdrawn.
Please, deeply obliged.
And the application, which is your application for withdrawal,
The IA number 1/2024.
direction. Just say this, in view of the withdrawal of the appeal.
Please.
And the application seeking condonation of delay, any pending applications are concerned, the same have become infructuous.
Please, obliged.
26, Shivekola.
Three of 24.
Lordships.
Yeah, 3 of 24 months, on the previous occasion, this honorable court has already passed an order directing the parties to maintain status quo. It's in the connected matter where the government is the appellant, was they were to file an application to bring the legal representatives of respondent 3 on record. So that has not yet been.
26.1, my lord, it is preferred by government, my lord, appeal is by government. But we have to take steps for R3 is dead, my lord. You have to bring his LRs on record, my lord.
When?
Seek a short accommodation.
Just say this, the counsel appearing for the appellant in WA 1559 of 2023 states that she intends to file an application bringing the LRs of the respondent number 3 on record. At her request, re-notify the appeals on. Interim order is in the first appeal.
Yes, please. Yes.
Interim order to continue till the next date. Interim order, if any, to continue till the next date of it.
Please.
24.
In the other one, there is no interim order. In
No,
the
no.
interim order in appeal number, just say that 814 of 2023
24-3.
shall continue till the next date of it.
27, Shri Akshay Raj. 20.
Please, lords, respond. Lords, I seek a short accommodation, lord, next week, may be listed for final hearing, lord, for the appeals.
This case.
At the request of counsel for the appellant, you appear in 27.1 also?
Yes, yes.
Appellants re-notify all.
May I make a submission, my lord? May I make a find an application for seeking for an interim injunction, my lord, till the disposal of this appeal. The subject matter of the property, my lord, was given for joint development. Subject matter of the properties, my lord, was given for a joint development. And the learned arbiters has come to the conclusion, my lord, that he did not commence the construction even after 2 years from the date of the sanction plan.
Who has the possession?
I am in possession.
Lord, I'm sorry, my lord, I am still in position.
So that,
Very well.
that, my lord,
In position, I'll file my objections also next week.
that, my lord, your lordship may kindly see the arbitrator's finding on that question, whether who is in
Here, my lord,
possession.
there was a block in the road, my lord, because of the railway construction. We could not approach the site. That's the reason, my lord, because in the agreement also, my lord, there is the clause of force majeure, wherefore under such circumstances, my lord, we are not responsible.
So you have to maintain status quo,
Please.
Yes, please.
You appear for all the respondents?
There's only one respondent.
There is only one. Just say that the counsel for the party states that they shall maintain status quo with regard to the title and possession.
Yes.
In respect of the scheduled
Only
property.
possession.
Possession, just say possession.
Title.
Title is not an issue. Possession. With regard to the scheduled property, their statement is taken on record. Okay,
Yes, lordship may fix a date. for
Obliged.
final.
we'll fix a date, just give it somewhere in March.
10-3.
Grateful.
Next,
28. From
appear for the appellant's counsel. lot of history, but the short point is this. The resumption proceedings start inordinately late. That's my contention. My lord, the point that I want to bring to your lordship's notice is in paragraph 28 of the impugned judgment. What is noticed is a concession that was made. Just show the file. But in paragraph 28, my lord, running page 25 of the appeal compilation, paragraph 28 of the impugned judgment, there is a concession made before the learned single judge, qua the use of the land, in other words, possession. I've given that up, no difficulty about it. But this impugned judgment would still have to be set in challenge by me insofar as, my lord, compensation. Otherwise, I won't get it. That's the only short point. How is this observation relevant? Yes. Purchase granted by the land, granted land by petitioners is in violation of
Yes,
law.
I'll just take a minute and explain. What happened was, there was a grant made in 1945.
In whose favor?
In favor of my predecessor. I purchased, my lord, under 7 or 9 sale deeds in all, my lord, for large conjoint extent of land. I have been in possession since 1960s. Sometime in the since 2015, resumption proceedings are started on the pretext that I did not cultivate the lands. There is nothing on record to show whether or not there was cultivation previously. The only allegation is that I've not cultivated now. Now, the grant condition was that I should cultivate within 15 years then, but going back in time. But today, to apply today's scenario to what was the condition then is not permissible. There are judgments of our court. Those have not been noticed. That's the point I'm on. Now, the difficulty is resumption proceedings under, my lord, the land grant rules has the effect of me losing title also. With that, I won't get compensation. That is my difficulty. I concede the position that the concession made before the
Who is in possession of the land?
Lord, there is today, in fact, I must tell you, lordships, there is nothing that's been built, but I'm told this has been allocated towards the building of a court complex or some such. And so therefore, my lord, I don't want to take all the advocate association. Let me be clear about it. So therefore, I'm not on possession. I'm only on the compensation. And that's what was the submission made by the learned counsel who appeared before the learned single judge. And I am ready to stay on to that, my lord. There's no difficulty. But with this observation and in view of the dismissal of the writ petition, I become disentitled even to compensation. That's why, my lord, I will take notice.
Now, what would be your right otherwise for compensation?
My lord, my right is that I have sale deeds. I'm the owner. I'm the owner of this. What happened was this whole property, they initiated these proceedings only because they said, you're not cultivating it, let me use it. There's a need for
What happened to that decision?
My lord, that resumption alone was what was challenged, my lord, before the Tahsildar. That went against me. That's why, my lord, I eventually came up after an appeal before the learned single judge.
Would even after resumption has been allowed in favor?
Yes.
I would still be
entitled. I would still be entitled because I am only on, like I said, my lord, I'm only on the question of compensation. But I don't want to come in the way of the court complex. That concession that was made before the learned single judge would continue. There's no difficulty.
On a prima facie, you can argue, look here, land belongs to me, and
That's
how
correct.
can
That's
they,
the
once they take away, they can't be, it
That's the
can't
point.
be a
But
situation
in view
where
of
I
this
was not.
judgment, if there is a dismissal of my writ petition, my rights are, I don't want it to be said that my rights are extinguished, and which appears to be the view taken by the learned single judge. The learned single judge would say, because you did not adhere to a certain condition, then everything goes.
But still, Mr. Nandakumar, if resumption proceedings have been upheld,
yes,
what would be the right?
Lord, the right is for compensation. I'm very clear, my lord. That is all that I'm seeking. I'm very clear.
We need to look into that.
Yes, that is what, my lord, I'm. Therefore, my lord, may I make one request? There is one of the appellants who's passed on during the currency of the appeal. I'll have that rectified. I'm sorry, the legal representatives are already on record. I'll rectify the memo of parties and then, my lord, take notice on the other response.
Just this 1/24 has been allowed.
The only ground urged by the petitioners was that, my lord, no notice was served on them. In fact, my lord, before learned single judge, entire records were made available.
Oh, Lord, I'm told that the legal representatives were on record before the learned single judge, but because the office raised an objection here in the appeal, it's been filed once again. Lordship may formally allow it. Those parties are all appellants already.
See, last order is impossible, Mr. Nanda. Please. 3 weeks' time is granted to remove the office objection, which includes non-payment of court fee, failing which the appeal stand dismissed.
That's all been done. That's all been rectified. All of that has been rectified.
And what about?
The difficulty was this. though the legal representatives were brought on record before the learned single judge for, I'm not too sure why, but I'm told that the registry in the writ appeal, my lord, there is actually a practical difficulty, my lord, in the Karnataka High Court rules. The rules are relating to writ petitions or writ proceedings are slightly different from writ appeal proceedings. So therefore, there is often a bit of a mix and match that one has to do in the registry, but be that as it may.
But we just simply re-notified. We have to see the effect of this order also.
No, that has been complied with. There is no noting saying that we have failed to comply thereafter.
No, 3 week, we don't know what are the office objections.
That's been complied with. There is a endorsement that we've given saying we've complied.
Just say that Mr. Nandakumar and a senior counsel for the appellant states that the office objections as noted by this court in the order dated 9/12/2024 have been cleared.
Please.
At his request, yes, then we will re-notify.
But you'll also permit me to take notice on the respondents. There is one, I think private, oh no, they're all, my lord, the government. If my learned friend from the government can accept notice on behalf of the respondents, the matter can even be heard and closed.
Just say that.
Respondents 1 to 5 are all state entities. I'm sorry.
The registry shall give its report on the next date of hearing. Now, what about this LR?
LRs are already on record. I will formally indicate it in the cost title. I'll file an amended memo.
Nandakumar also states that the LRs of the deceased appellant are already on record. He shall file a memo clarifying the position.
Please. In fact, it's been done, but nonetheless, I'll file an additional memo just for clarity's.
At his request, re-notify.
But no, all 7 respondents are state entities, my lord. If
1 to
Just
5.
say that
1 to 5.
we take on record that so and so appears for all the
1 to 5, my lord.
Lord, 6 is Department of Social Welfare and 7 is Executive Engineer. I'll take notice on them, my lord, if. No,
1 to 5 so and so appears. Ma'am, you appear for 1 to 5?
Please, my lord.
Okay, 1 to 5. Notice shall be issued to respondent number 6 and 7.
Please.
Returnable on. Ma'am, you appear for whom? Pardon?
Application, my lord, for Gauri Bindur Association and the president, my lord, Bar Association.
File an application. We will look into it. You have filed it. When did you file it?
It was filed, my lord, when the matter was still in defect.
Full stop. In Kadana, just say this. Reply any to the application being so and so. Filed by. Filed by Bar Association of Gauri Bindanaru. And they say that. And the president of the Bar Association, Gauri Bindanuru. Bidanuru. If any be filed.
Applications filed, you'll also hear them. They were not, the impleading was not accepted before the learned single judge. I don't know when the elections there are coming up, so I don't want to say anything more. Let them be heard, no difficulty about it. They'll only come into the picture if I'm claiming the land back.
We allow them their intervention.
Intervention. You'll also may permit that they be heard, my lord. I have no difficulty with that.
Only intervention, not impleadment.
Great.
You will be heard.
Maybe allowed, my lord, my application.
It was not allowed before the learned single judge. They had made a similar application, is what I understand. It's all right. I mean, it can be taken up on the next date. I have no difficulty. They want to be heard, let them be heard.
You will be heard. Okay. Very well. Just say
Great.
that.
So great.
Mr. Nandakumar states that the application be allowed to the extent that the court may allow the applicants in this application to intervene in the appeal.
But not to be impleaded as a part.
Huh?
Not as an implead. Great.
Counsel for the applicant shall take instructions on that.
Great.
Next. There is a common order, we use an interim order. It is in 461 only. Yes.
29, I appear for the appellant minutes. There's a delay of 703 days. I'll just explain the delay, my lords. My lords may take plaint at page number 63, my lords.
This is filed under 13(1)(a).
Please, my lords. under 13(1)(1)(a), limitation is 60 days plus 30 days. My lords have held that the extension is also possible. I'll just explain the facts, my lords. Page number 67 is a plaint. This was a suit for recovery of the money filed by the respondent number 1 in respect of Nitesh Estates Limited. I was the respondent number 3. The transaction was between the plaintiff and the defendant number 1. Page number 63 is the plaint, my lords. If my lord goes to prayer, my lords, prayer is at page number 72. To direct the defendant to pay a sum of all the reliefs are against the defendant number 1. There is no relief sought against me. I was only a company secretary and I had also retired before the suit was filed. Issues are also framed, my lords. Issues are at page number 84.
So you as a functionary, you were made a party.
Please, my lords. Now the decree has come against me.
Is it jointly, severally, or?
It's jointly, severally, my lords. Issue is at page number 84, my lords. 84, issue number 3. May I read, my lords?
Whether the main contesting, who was the contesting?
Defendant number 1. The company.
I'm for
You are for defendant number 1. Have you filed any appeal?
I'm for defendant.
Who appears for defendant number, respondent number 1?
I'm for respondent number 1, madam. I'm for plaintiff respondent.
Oh, you are the plaintiff.
Plaintiff.
Please, plaintiff is
Now, who appears for respondent number 2?
I appear for respondent number 2.
Now, have you filed any appeal?
I have no instructions on that effect. I have only.
They have not filed any appeal. Execution is going on. And in the IA for delay, I have taken a contention, my lords. I have not been served any notice. Only they have filed the respondent number 1 has filed one writ petition in the year 2.
Before the filing of the suit, you retired?
Please, my lords, that is also produced in my.
Before the filing also?
Before the filing of the suit.
But my lord, at the time of transaction, he was there in the company.
Correct.
Still as a functionary?
Functionary.
Please.
Not rope in everyone, employee who works, retires and then goes. How is he liable? Your contract was with whom? The company?
With the company, please.
What do you have to say now?
Personally, I'm not claiming any.
That's what? The jointly severally he's also come in.
That's right.
I have retired on 2/8/2018, my lords. Suit is filed in 19.
See, we want to know what is the stand of respondent number 2.
Take instructions, madam. I am not opposing his appeal. Those are my instructions.
No appeal. So far this appeal is concerned, he is saying that he will not. What are your instructions?
But already 1 lakh rupees they have deposited in execution petition.
No, you just tell us, would you press this or would you press the decree against him?
No, my lord, I'm only against the respondent.
That's all.
On this
2 and 3, please.
submission, it may be disposed of. I'll
We'll
have.
take the submission on record. We can even dispose of this appeal.
Please.
You will work it out before the executing court,
Please.
maybe against respondent number 1 or maybe against the chief executive officer who are other respondents. You will work it out. Not against him. You are a party there.
Please, Minister, I'm the party there.
In execution petition also is there.
He is a party, na?
I'm the
But
party.
surely you will not press against him. You will press against the company, na?
In
Please.
fact,
So we'll
company is-
record your statement that you will not press this decree, judgment decree against him.
Please.
And we dispose of. Okay?
I have no objection regarding.
Please.
No, he is not gonna, you are the contesting, you have filed the
I'm
execution.
plaintiff, I'm not. I have no objection.
Okay. Just say this appeal lays a challenge to a judgment decree dated 21/6/2022,
What's that?
passed by the so-and-so additional city and sessions judge, civil and sessions judge. At Bengaluru city in COM OS number 1941 of 2019. Full stop. Whereby the trial court has stated as under paragraph 27. So the aforesaid would reveal that the appellant, who was also defendant number 3 before the trial court, has been fastened with the decree against him for an amount of rupees 942,320 along with interest at the rate of 24% per annum. So the submission of learned counsel for the appellant is that the appellant herein was working as a company secretary, please, in the respondent number 2 organization. And as such, and much before the suit was filed, he had also retired. Stop. Any privity of contract between the respondent number 1 and respondent any privity of contract of respondent number 1 was with the respondent number 2. And as such, the trial court could not have decreed the suit jointly and severally, including against the appellant herein. The respondent number 1, the counsel for the respondent number 1, conceding the aforesaid position. Now kindly just mark this. Conceding the aforesaid position states that the respondent number 1 shall not press the judgment decree dated so and so 21/6/22 in COM OS number against the appellant herein. Okay?
Please, defendant number 3.
In the said submission of the learned counsel for the respondent is taken on record. Full stop. In view of the statement made by the counsel for the respondent number 1, the learned counsel for the appellant submits that the appeal be disposed of accordingly. It is ordered accordingly. Appeal/connected applications, if any, are disposed of accordingly. Okay, please, Mons. Thank you.
Grateful.
Next.
Number 30, Shivji Kumar.
Everything goes on. And has come.
Please, I prefer the appellant in this matter. There is a delay of 31 days in filing the appeal.
Yes. Just say issue notice.
Now, my learned friend, there is only one sole respondent. My learned friend has appeared and he will take notice.
You appear for whom?
A respondent.
Only sole respondent?
Sole respondent.
It's a issue notice. Yes, now tell us money decree.
Money decree, it is a relation.
File any execution?
Not yet, ma'am.
In this matter, we are decree holders, sir. Originally commenced.
Have you filed any execution?
Yes, sir. KVA to apply.
So to our
Second
knowledge,
KVA.
execution petition is not filed.
Now tell us how much deposit?
My only submission is the relationship may kindly be seen, my lord. This appeal is by the defendant. Defendant is the owner of the property. The plaintiff enters into a registered lease deed. And the amount so deposited was no interest, no rent. And I had also filed a counterclaim. My counterclaim is also dismissed, my lord.
No, today there is a money
Money decree. As
against-
on today, there is a money
So
decree.
you'll deposit.
We will deposit 25% of the decree.
You will deposit 75%. Computer as of today.
95 lakhs is the amount.
Whatever is there. We are only on the
We will
percentage.
deposit 25%.
No, not that way. Please. Then we will just issue notice.
50%.
We will work it out before the executing. court.
50%.
What is this? We don't understand.
My only,
Very well, you don't want, very well, we just issue notice, so and so accept notice. Let the trial court record the requisition before the next date of hearing. Counsel for the parties to file their written submissions along with the judgment they intend to rely upon within 4 weeks, list after 4 weeks. We are not saying anything on your stay application. Okay? Next.
11-3. Serial number 31.
Come. Yes.
Not be in a position to make any concession, my lord.
Oh,
take rest.
go ahead.
Please.
And I think we have heard you now. What
Nothing more
remains?
to add. Not only the citations, my lord, I'll just.
I'll give the citations. Just say that we have heard the counsel for the parties, orders reserved. just say this. You do one thing also.
Please, my,
You will file it e-filing also.
yes, my lord, I shall do that.
You have already filed it.
Yes,
Just say this.
I'll e-file it also, my lord. One or two authorities will e-file.
We have heard the learned counsel. We have finally heard the learned counsel for the parties. The learned counsel for the parties have filed the copies of the judgments on which they have relied upon during their submissions. The same be filed. The copy thereof has been taken on record. They shall also file the same through e-filing within 1 week.
Great.
Orders reserved.
Please.
Next.
Lord, brief notes of the citations may I also, my lord, place on record. Because
Have
since
you?
The company, no, I'll do it, my
When
lord.
will you do it?
My lord, within a week's time that my lord has granted, I'll do that.
What do you say, Mr. Chin? Do one thing then, Mr. Chinnappa, possibly you can also add on to it your brief note of submissions also.
I'll do that.
So
1
the
week we'll do
counsel
it.
for the, counsel for the party shall also file their brief note of submissions through e-filing.
Please.
And also by giving a copy thereof to the court officer within 1 week. Orders reserved.
Great.
P2,
For the appellant, my lord.
Appearing on
In a
top.
week's accommodation, I'll file my written submissions and we'll argue the matter.
Written submissions have not been filed, be filed within 6 weeks, list on.
21-3,
Obliged.
serial number 33,
Yes, Mr. Joshi.
So this is where I am the co-owner and the rents had to be paid. I had
Ah.
filed an application.
We'll just pass over.
Very.
Pass over. We'll take it end of the board. Once we run through the list,
Very
we'll
well.
just take it.
Very great. Much.
34, 34,
Respondent in this matter. Been under section 37 of the Arbitration Act. Even my learner friend was there.
Where is he?
He also wanted to take adjournment. He needs some accommodation. Me also.
Take adjournment.
Adjournment.
Who?
My friend as well as me also, my lord. Short accommodation.
Just say that.
He is here. Morning we could not, so short accommodation maybe.
Short accommodation, my lord.
Just say that at the request of counsel for the appellant, re-notify both the matters.
Connected matter.
Connected matter.
27-2, 35 adjourn, 36, Shri Gopal Swami. 36,
Oh, for the
Yes,
respondent in this
pass
case,
on.
my lords, we have challenged the impugned order and writ petition, my lord, just appearing the other advocate. In the same subject matter, my lord, just we have filed a writ petition. And that is pending, my lord, that WP number 15545 on 24.
What have you challenged?
The same impugned order, my lord.
Why a writ petition?
My lord, just other advocate has already preferred, my lord, just I got to know recently, my lord, just that is the reason, my lord, just I'll take instruction, my lord, to continue with the case.
Has
Just on
it
the
been
accommodation,
entertained, writ petition entertained?
It is not maintainable, my lord, actually.
Yes. Then what happened?
My lord, just I got to know, my lord, recently, my lord, just I take further instruction, my lord, in this case, my lord, just 2 weeks' time may be granted.
Same order.
Same order.
Where is the counsel for the appellant?
And for the rest.
None for the appellant. The counsel appearing for respondent number, same one respondent, na?
One response.
States that even the respondent herein has also challenged the impugned order in a writ proceedings,
15545 of 2024.
being writ petition number,
15545 of 2024.
full stop. He states that he intends to take instructions in that regard. At his request, re-notify. So you must take this thing call on this. Next.
23-1, serial number 37,
And for opponent. 37.
Inconvenience, if I may request, a week.
It is inconvenience.
Is a
We have
divergent
heard this,
finding.
na? Did we hear it?
Your lords have heard only on the condonation of delay. Subsequently, that was allowed. Matter on the main has not been heard.
Is a divergent finding.
may request the following Thursday, my lords, subject to your lordship's convenience.
You say at the request of counsel for the respondent, re-notify.
3rd March.
Right.
Serial number 38, Srimati Vandana. 38.
Appearing for the appellant, my lord. Kindly pass over.
Pass over.
Great.
39.
Lords, my prayer for setting aside the arbitral award has been rejected, my lords. Therefore, I am before my lords. The arbitral award, my lords, the issue is very simple. Issue is that I have given a road construction contract to the respondent herein. The contract did not have a change in law clause. And my lords, the learned arbitrator, my lords, a claim based on the fact that there is indeed a clause for change in law has been allowed, my lords. On the basis that the decision of the Honorable Supreme Court in NHAI versus ITDC is squarely applicable to this. Now, the scope of adjudication before my lords will be only whether the clause that was contained in the matter that the Honorable Supreme Court was seized of is same as what is contained in this clause. That is all this.
38.1 and 32 there.
Yes.
Please tell us one thing.
Yes, ma'am.
You are relying on 38.1?
My lords, my contention is that 38.1 is a compensation event. Compensation event clause, my lords, would arise if by a positive act of the employer, there is a prejudice caused to the contractor. Whereas in case of a change in law clause, my lords, it is an unforeseen event.
Where is the change of law clause?
There is no such clause. There is no such clause. Now the clause that was subject matter of adjudication before the Honorable Supreme Court had a clause which said unforeseen event.
Show us that.
Yes, ma'am.
So it's a, according to you, it's a perverse finding.
Yes, my lords. It's a perverse finding. It's a conclusion that could not have been arrived at by.
Just see, let's see that, show us that.
May I file the citation, my lords, the NHA versus.
We'll come to that, we'll come to that. Let's see the facts. No? Let's come to the award.
Yes. May I file the contract document, my lord, separately?
They show us. So 38.1, you say there is no change of law clause.
There is no change of law.
That because of, now tell us one thing.
Yes.
Now you are for the
Karnataka Road Development Corporation.
That's right.
The employer.
That's right. Now, according to you, your case is you are liable or you are entitled to claim royalty for the minerals. Minor minerals?
Minor minerals. Minor minerals. My mandate is, my lord, stems from a government circular where I'm asked to deduct and remit it to the respondent number.
It's automatic.
It's automatic. I am supposed to do it.
Without there being a stipulation in the contract.
Yeah, my lords, this stipulation in the contract, my lords, is that I can deduct, my lords.
Where is the clause?
Yes.
For deducting royalty for certain minor minerals in the contract.
Yes, my lords. So there are two questions posed by my lords. First is the contractual clause, whether it is a change in law clause or not. Section 38.
Change in law. Where is the enabling provision of which is the clause which gives you right for deducting the royalty?
My lords, insofar as that is concerned, my lords, the arbitral award issue, additional issue number 1, the learned arbitrator has held the issue in my favor to the extent that as per the circular, there is no dispute that I can deduct the amount. And in addition to that, my lords, until RA bill number 5, until the change in law actually came into force, the deduction continued to happen. And that has been accepted by them in the.
Not contested.
Not contested by them. Even in the cross-examination, they say. I
So
have
here, the only thing is whether it is 2007 or 2014, which will hold the field.
Yes.
That's right.
Lots of.
2007, you have been doing it from
Yes.
the bills, you have been deducting the amounts and
Yes.
sending
Until
it.
RA bill number 5, I have deducted.
You have deducted.
Yeah, I have deducted. There are two contracts in the second appeal, my lords, until RA bill number 5, I have deducted. And thereafter, the change in law came into force. In the first appeal, my lords, the contract was awarded and thereafter the change in law came into force. In both these, the cross-examination has been done and they have admitted to the fact that I have a right of deduction. Their case is that despite that, clause 38 will get attracted because this is a clause which is in the nature of a change in law clause and therefore this is applicable and hence the Honorable Supreme Court's judgment.
Now, how do you answer?
Yes, ma'am.
The 34 court says
Yes, ma'am.
that even if the arbitral award is not patently illegal, but contrary to law.
Para 39, page 16,
Yes.
page 18 of the arbitral award. Page 69 of the appeal memorandum. May I just draw my lord's attention to clause and then may I take my lords through how I am making out my.
No, only thing is.
Yes, ma'am.
You can just consider this also while arguing.
Yes, ma'am.
21, paragraph 21.
Yes, ma'am.
Also, you will consider this while arguing.
Yes.
Now, so you say that there is no otherwise a clause for deducting it, but not challenged. Your right to deduct it against royalty for the minor minerals is not contested.
That is not contested.
What is the higher amount is sought to be contested.
Only insofar as higher amount is
And
concerned.
the reliance is on 38.1.
38.1.
You say 38.1 is not a change of law stipulation. It's something related, something different, not covers this present eventuality.
It does not even remotely relate to it.
Really?
It does
Let's
not even.
see that.
remotely.
Let's see 38.1.
My lords, I have just placed the memo with clause 38. This is a standard KW4 contract, my lord. The clause is same in both the appeals. Clause 38 at page number 25. The following 38.1. The following are compensation events unless they are caused by contractor. The employer does not give access to a part of the site by the site possession date stated in the contract data. My lords will notice in each of these, it's a positive act of the employer in causing a breach, which will prejudice the right of the contractor. B, the employer orders a delay or does not issue drawing specification or instructions required for execution of the works on time. C, the employer instructs the contractor to uncover or to carry out additional tests upon work, which is then found to have no defects.
So what you are saying is this is a compensation
event.
The onus is on the employer if for certain reasons attributable to the employer.
A prejudice is
entitled to, then
Yes,
you will
ma'am.
pay. And the eventualities are A to G.
Eventualities are A to G. And therefore, the subsequent clauses which are relied upon, if the compensation would cause the additional cost, not any other event, the compensation event mentioned in A to G, additional cost or would prevent the work from being completed before the intended completion date, the contract price shall be increased or intended completion date is extended. The employer shall decide whether or by how much the contract price shall be increased or whether by how much the intended completion date shall be extended. As soon as information demonstrating the effect of such compensation event upon the contractor's forecast cost has been provided by the contractor, it is to be assessed by the employer and the contract price shall be adjusted accordingly. If the contractor's forecast is deemed unreasonable, the employer shall adjust the contract price. This is regarding the procedure. Then, my lords, 38.4, which has been relied upon. The contractor shall not be entitled to compensation to the extent that the employer's interests are adversely affected by the contractor not having given early warning or not having cooperated with the employer. My lords, if there is any contributory breach on his part, that is all this clause contemplates. Now, my lords, the question is, in the event of a change in law clause, there is no positive intervention of an employer that is required to be done. It happens by deemed fiction of law that the prices have been increased And that is not what is contemplated under 38. 38.4 specifically, because this has to be within the confines of what 38.1 describes as a compensation event. Now, my lords, in the Honorable Supreme Court's judgment also, my lords, if I may place the judgment of the NHA versus ITDC.
There also the issue was with regard to the royalty.
Yes, my lord, and under the same act, it stems from these Karnataka mineral mines and minerals rules. The
That
increase.
also-
Yes,
that-
that also. That also, but the contract is different.
But there is a contract there.
Contract is different. Now, if I may draw my lord's attention to, my lords, in this, there are 4 civil appeals that have been decided. At page number 21 is the civil appeal, the ratio of which has been relied upon by the learned arbitrator as well as the section 34 court. Page number 21, my lords have para 31. I may have to trouble my lords with reading this a couple of paragraphs. The appeal challenges a judgment and order dated 27/4/2012 passed by the High Court of Delhi at New Delhi in National Highway Authority versus AFCONS. Unlike all aforesaid cases, the clauses in question are not identical and hence this matter is being dealt with separately. In others, my lord, the clause was different. The appellant awarded contract dated 38/2001 to the respondent for the work of 6 laning of NH7, so-and-so in state of Karnataka contract package NS. Clause 13.3 of the contract pertain to taxes and other levies, which is set out here in above. 13.3, all duties, taxes, other levies payable by the contract under the contract or for any other cause shall be included in the rates, prices and total bid submitted by the bidder. 13.4 of the contract pertain to price adjustment. 13.4, the rates and price quoted by the bidder are subject to adjustment. 32.1, my lords will see, this is the clause that has been relied upon. The contractor is to warn the engineer at the earliest opportunity of specific likely events or circumstances that may adversely affect the quality of work, increase the contract price, or delay the execution of works. These are the 3 categories. Quality of work, which adversely affect the quality of work, increase the contract price, or delay the execution of work. The engineer may require the contractor to provide an estimate of the expected effect of the future event or circumstance on the contract price and the completion date. The estimate is to be provided by the contractor as soon as reasonably possible. The contractor shall cooperate with the engineer in making considerable proposals for how the effect of such event or circumstance can be avoided or reduced by anyone involved in the work or in carrying out out any resulting instructions of the engineer. Now, my lords, coming back to 32.1. 32.1 contemplates 3 scenarios. 1, that there is an event or a circumstance that may adversely affect the quality of work. Second, increase the contract price. So this does not say a compensation event. This is any event. Whereas in the contract, that is KW4 that under which he has been awarded, it is confined to the compensation event mentioned under clause A to G. Now, my lords, because this clause is open-ended, any event or circumstance that has the effect of increasing the contract price, such future event which has a result of increasing the contract price, he is entitled to the amounts. This, my lords, has been the scenario wherein an arbitral award has been passed in favor of the contractor, and at para 34, 33.2 and 34, my lords, if I may come to 34 at page number 23. The award accepted that the revision of royalty rates in respect of minor minerals by the government of Karnataka being subsequent to the contract would be covered under the expression future events in 32.1, entitling the respondent to raise a claim. It is observed that there was no dispute between the parties that royalty was not included in WPI and that in other contracts, the reimbursement towards additional costs incurred as, this I may have to skip, this regarding price adjustment, it is not included. The High Court, while affirming the view of the arbitral tribunal, additionally relied upon the fact that the claim as regards reimbursement on account of cess was accepted by a separate award relying on very same submission, which view was affirmed by the High Court as stated here above. We have gone through the record and considered rival submissions. The view that a result of upward variation in the rates of royalty pursuant to subsequent legislation, the matter would be covered by 32.1 is certainly a plausible view. While quoting the initial rates and prices, it would not have been in contemplation of the party as to the framework of any revision in rates of royalty as a future at a future date. Clause 32.1 can be said to have covered such eventualities. We therefore see no error in the assessment and approach of the arbitral tribunal. The High Court, in our view, was right in dismissing the challenge. Consequently, this appeal fails and is dismissed.
So what is said by the High Supreme Court is anything which will have a bearing on the increase on contract price. Then the contractor is required to warn the engineer.
Is
At
covered
the
under
earliest
32 point.
opportunity of specific. So the increase in royalty
Increasing royalty.
would also affect the contract price.
And it's a future event which is not foreseeable.
A future event. And he is required to
Notify.
notify the engineer.
Under clause 32.1.
But in this case, it's not a general stipulation.
Yes, my lord.
But it's specific to compensation which a contractor is entitled to in certain eventualities.
Where the
For
employer
for the reasons attributable to the employer.
For the reasons attributable to the employer. Now, my lords, there is one more event that is transpired. Ideally, my lord, this is a scenario where the Karnataka Road Development Corporation versus the contractor should have been a party to the arbitration proceedings. During the arbitration proceedings, they implemented the Department of Mines and Geology. So that is respondent number 2 to respondent number 5. On the ground that the money that I have deducted, I have remitted with them, and therefore they are required to pay. Now, the arbitral award, my lords, the liability is fastened jointly and severably on me as well as on them. Now, my lords, they have to stick to one stand. If they are making a claim for recovery of money, my lords, they are making a claim for recovery of money that I have just held in trust and I have transferred it to the Department of Mines, then the case should be only as against them. Insofar, if their claim is for compensatory damages under section 73, that there was a future event that has caused damage to them and therefore they are supposed to recover, then it should be confined only to me because I am the employer. Now, my lords, it's a strange scenario where the same arbitral award has been challenged by both of us, me as well as the state. The state's arbitral appeal is, my lords, 34 is still pending. In the meanwhile, I am before my lords.
That's listed.
My lords, that is listed. Just one moment.
But you have filed 2 appeals.
So I have filed an appeal independently, Karnataka, because it's a corporation.
No, there is a connected also, no? Item 40.
It's a different.
There are 2
claim.
contracts. There are 2 contracts. Both have the same clause. In both, the invocation was made. They have so these are the 2
identical facts.
Identical facts, identical clause. My lords, why I brought it to my lords' notices, they must be clear whether it's compensatory damage or recovery of money, because their relief as well in the now, my lords, before the trial, before the section 34 court, my lords, because the nature of recovery is such that they want to get the money from the Department of Mines and Geology, it should be deemed as a recovery claim, and therefore, my lords, I enjoyed a stay without any deposit.
But in any case, in all the running bills,
yes,
you have deducted the royalty?
In all the running bills, I have deducted.
So you have recovered whatever was required to be paid,
Yes,
paid by
I have
them
recovered and
as
paid
royalty.
Only the increased
And
royalty they are
remitted the
claiming
amount to, and remitted the amount to the mines.
Department of Mines and Geology.
So that's complete payment.
That part, that leg is complete. Now they are claiming the difference in the earlier notification, whatever was the increased royalty, only that component they're claiming here.
No, yeah, obviously. No, you have also recovered the additional amount also in terms of 2014.
Yes, my lords, in terms of 2014.
Now, what do you have to say on this?
Please, my lords, I am not asking for compensation. I am asking for the refund of the excess royalty collected by them, which is impermissible under law.
How do we get that? Where is the stipulation?
Because at the time when I executed or signed this contract, I was liable to pay royalty at the rate of notification dated 2007. In 2014, this rate of royalty was revised unilaterally in excess of the powers available under Rule 36 of KMMC rules. That I say that it is not applicable to me. I have signed the contract at the rate of notification prevalent as in 2007, my lords. It's a so simple case. And here in the question of compensating doesn't arise. I may kindly be returned because the running accounts bills, they first deduct without notice to me, and they said we have credited to the account of the government.
No, so very well. But why that reliance on 38.4? Why reliance?
The one I may kindly be permitted to.
Why reliance on 38.1? 38.
Because it is unforeseen. Nobody could eventually seen at the time signing the contract that rate of royalty would be increased.
No, where do we get unforeseen?
At 38.1D, it is at page number 66 of the.
Read that clause, 38.1D. Employer gives an instruction for dealing with the unforeseen condition caused by the employer or additional work. Now, what is being said is.
So that will be read with 38.4, my lords.
Very well.
The contractor shall not be entitled to compensation to the extent that the employer's interests are adversely affected by the contractor and not having given early warning or not having cooperated with the employer.
That's the interpretation is what is being argued is by the other side is only in a case where you are entitled to compensation.
I am not asking for the compensation.
So you are not asking for compensation?
I am only refund of excess royalty collected from me. And that is, in other words, it is deducted from my running account bills.
So 38.1 has no applicability.
Only except that is unforeseen demand.
1 minute, we will read the clause together. If it is applicable in toto.
Yes.
Or otherwise it is not applicable.
Yes, ma'am.
You will not pick up one line to say that this would be applicable, otherwise the main provision is not applicable. You will not say.
Please, my lord, I
So
will not.
38.1 has no applicability. It is only in the eventuality that a compensation need to be given to the contractor for certain reasons attributable to the employer. This 38.1 will come into play.
My submission would be, my lords, the question of compensation doesn't arise because unauthorizedly and illegally excess royalty has been deducted from my running account bills, which is impermissible for the contractor and to the government. They could not, because the government could not have received the excess money, whoever comes and deposits. There must be some source of.
I know, you're right. This compensation is to you.
Yes.
This 38.1 is for giving compensation to you for certain reasons which are stipulated here A to G by the employer. But that's not the case here.
Yes.
It's the case of royalty. Now your argument is this. When the contract was entered, 2007 circular was in place.
Please, madam.
Okay. During the execution of the contract, the royalty has gone up. Okay. When did you complete the work? When did you complete the work?
2016.
So during the period of execution of the contract, there was an increase in royalty which they were to deduct and they were to send it to the mines department. That's right. Now, tell us one thing. You did not contest the payment of royalty?
Yes, I have, because I have objected.
No, in terms of 2007.
Yes, my lord. I said that you are permissible or authorized under law to collect only royalty at the rate of 2000 notification, not 2014 notification.
Right, you have said so. But per se, there was no stipulation in the contract.
Yes.
For the payment of royalty, for the adjustment of royalty from your bills by them. There is none.
No.
But still they were doing it.
Yes.
And you did not object.
I objected.
No. You have objected 14. But principally, you had not objected for them to recover royalty and giving it to the Department of Mines.
No,
or not.
That is law. I could not have objected to that proposition.
Now the question is only this. No doubt, when the contract was executed, 2007 was in place. Okay. But during the execution of the contract, the 2014 comes. Okay. Now, which will they recover? 2007 or 14?
2007, my lord.
Why?
Because there is no condition or authorization to deduct royalty at a higher or enhanced or revised rate.
What we are saying, there was not even a condition to even adjust 2007 also.
Yes, it is there, my lord. 2007 is there.
Very show us.
Yes, my lord. Because I will.
Is there any stipulation? Is there any stipulation in the contract for adjusting the royalty at the rates stipulated in 2007 circular?
13. It's not specific to the circular.
I will.
Just one. Show us that.
Clause 39. Very next clause.
No, these taxes must include the royalty also.
No, that's right. The recent
royalty is not a tax.
9 judge
Royalty is
decision
not
of
a-
honorable apex.
Royalty is not a tax. Royalty is not a tax.
Yeah.
It'll be a cess. It'll be a cess. So because it's an inclusive, deemed to be inclusive of. The rates quoted by the contractor shall be deemed to be inclusive of sales, labor cess, other taxes that the contractor will have to pay for the performance of this contract. So.
These are taxes which are understood in the normal course, but not a royalty per se.
Royalty, my lords, is a cess.
No.
The idea is,
I beg to
my
differ,
lords,
my lords.
the idea.
Royalty is not neither a tax or cess.
It's a
Tax
fee.
on royalty is a cess. That's what the Honorable Apex Court has given in this judgment of.
No, but whether this word taxes shall include the royalty? No.
No, that's
Now,
excluded.
where is the enabling provision for them under the contract to even adjust the royalty? Where is that stipulation?
Yes, Madam. Rule 36 of KMMC rules provide.
Back after lunch, we'll continue.
No, in the meantime, if permitted, I will file the statement of objections, and on that basis,
It's purely a legal issue.
please, my lord.
Look into
Please,
it.
please, my lord.
That's serial number 58. I want a small accommodation. my lord.
Which one?
58, my lord. The paper book getting
Is the
ready.
other side.
I have informed my lord, Jay Prakash. I'll get the paper books also ready in the meantime.
You just gave it at the request of you for the appellant.
Yes, my lord. Oblige.
Yes, sir. April.
Madam, ಇದು ಹಿಂಗಿರೋದು ಪೇಪರ್ 34. ಟೈಮ್ ತಗೊಳ್ಳಿ. Okay, thank you. ಪೇಜ್ ನಂಬರ್ ಮ್ಯಾಚ್ ಆಗ್ತಿಲ್ಲ ನಾನು ಹೇಳಬೇಕು ಅವ್ರಿಗೆ. ಅಲ್ಲ ಇದು ಅಪೀಲ್ ಮೆಮೊರಂಡಮ್ ನಾನು ಹೇಳಿದೆ ಸಾಹೇಬ್ರೇನೋ ನೋಡ್ತಾ ಇರೋದು ಏನು ಅರ್ಥ ಆಗಲಿಲ್ಲ. 7 ಪೇಜ್ ಅವ್ರು ನೋಡ್ತಾ ಇಲ್ಲ ನಾನು ಈ ಪೇಜ್ ನಂಬರ್ ಅಂತ ಇದ್ದೀನಿ ಅವ್ರು ಬೇರೆ ಪೇಜಿಗೆ ಬರ್ತಾ ಇದಾರೆ ಅದಕ್ಕೋಸ್ಕರ ಏನೋ ಮಿಸ್ಟೇಕ್ ಇದೆಯಾ ಅಂತ ನೋಡ್ಬೇಕಷ್ಟೇ ನಾನು. ಬರೀ 379 of 2024. 1 second ಅಷ್ಟೇ ಅದು ಆರ್ಬಿಟ್ರಲ್ ಅವಾರ್ಡ್ ನಾನು ಹೇಳಿದ್ದೆ ಒಂದು ಪೇಜ್ ಸಾಹೇಬ್ರು ನೋಡ್ತಿರೋದೇ ಒಂದು ಪೇಜ್. ನಾನು ಯಾವ್ದೋ ಪೇಜ್ ಹೇಳ್ತಿದ್ದೀನಿ ಅವ್ರು ಯಾವ್ದೋ ನೋಡ್ತಾರೆ. ಹಾ ಓಕೆ ಓಕೆ ಓಕೆ.
Yes.
39, serial number 39.
Lordship's kind leave, my lords. May I make a mention for the adjournment minutes? Serial number 60. I appear for the appellant minutes. The respondent is served unrepresented. My senior has some difficulty today in the afternoon minutes. May I request for any other day?
Just the request of counsel for the appellant adjourned to
Please. I'm obliged to this.
come.
21, 3.
Who you appear for whom? That the request same order. Yes.
There is only, before he commences, I just want to point out one paragraph in the arbitral award regarding the controversy, page 64 of the memorandum of appeal, which is para 33. The issue regarding my right to deduct under the circular has been held in my favor and not challenged. I just want to point out that portion.
Come, which point?
Page 64, my lords.
Yes.
Para 33. Answer to additional point number 2. The learned counsel for the respondent 1 relied upon the circular issued by the government of Karnataka dated 20/2/2014 directing all departments, including first respondent, to connect the enhanced royalties from month 3 2014. There is no dispute about that circular. The first respondent, being subordinate to the government, is obliged to deduct, but such deduction, whether it is legal, is question, requires to be decided.
Now, where is this provision, enabling provision to deduct? Where is that?
There is a circular, my lords.
Where is that?
That is marked as an exhibit, my lords. It's with the arbitral records. I may have to file the entire, this is come up for the first time.
No, show us that.
Yes.
Do you have a copy?
I have.
Just show us. See, it is by operation of that circular, it is to be done.
Yes, it is by operation of the circular. I am entitled to deduct the enhanced royalties.
That is not 2007 circular or 2014. It's an independent
It's an
circular.
independent circular. Otherwise, my lords, if I do any mining, I am supposed to pay the royalty and then lift the minerals. That is the norm.
The governing rule is Rule 36 of KMMC rules, my lord. Karnataka Minor Mineral Concession Rules, Rule 36.
We will see that.
Empowers either the state authorities or the instrumentalities of the state to collect royalty on the mineral extracted from Mother Earth, whether it is consumed or transported.
I produced only one circular. That is a paper book I had filed before the trial court. I'm just passing on that.
Mines Tribunal was a.
My lords.
What
That
does
is
this
the
say?
circular.
What does this say?
Yes, my lords. I will read it so that ಕರ್ನಾಟಕ ಸರ್ಕಾರವು ಉಲ್ಲೇಖಿತ ಅಧಿಸೂಚನೆ ಪತ್ರದಲ್ಲಿ ದಿನಾಂಕ 1/3/2014 ಜಾರಿಗೆ ಬರುವಂತೆ ಉಪ ಖನಿಜಗಳ ಮೇಲಿನ ರಾಜಧನ ಮತ್ತು ಸ್ಥಿರ ಬಾಡಿಗೆ ದರಗಳನ್ನು ಪರಿಷ್ಕರಿಸುತ್ತಿದ್ದು ಪರಿಷ್ಕೃತ ರಾಜಧನ ಮತ್ತು ಸ್ಥಿರ ಬಾಡಿಗೆ ದರಗಳ ಆದೇಶ ಪ್ರತಿಯನ್ನು ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿದೆ. ಸದರಿ ಅಧಿಸೂಚನೆಯಂತೆ ನಿಮ್ಮ ಜಿಲ್ಲಾ ಕಚೇರಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಗುತ್ತಿಗೆ ಕಾಮಗಾರಿಗಳನ್ನು ನಿರ್ವಹಿಸುವ ಇಲಾಖೆ ಸಂಸ್ಥೆಗಳ ಸಂಬಂಧಪಟ್ಟ ಕಾಮಗಾರಿಯ ಬಿಲ್ಲುಗಳಲ್ಲಿ ಪರಿಷ್ಕೃತ ದರಗಳನ್ನು ದಿನಾಂಕ 1/3/2014 ಅನ್ವಯಿಸಿ ರಾಜಧನ ವಸೂಲಾತಿಗೆ ಕ್ರಮ ವಹಿಸಲು ಸದರಿ ಇಲಾಖೆಗಳಿಗೆ ಉಲ್ಲೇಖಿತ ಅಧಿಸೂಚನಾ ಪ್ರತಿಯನ್ನು ತಲುಪಿಸಿ ಕಾಮಗಾರಿ ಬಿಲ್ಲುಗಳಲ್ಲಿ ರಾಜಧನ ಕಟಾಯಿಸುವ ಬಗ್ಗೆ ಸೂಕ್ತ ಮಾರ್ಗದರ್ಶನ ನೀಡಲು ಸೂಚಿಸಿದೆ. So essentially, this is a direction by the Department of Mines and Geology that a direction be issued to all state entities which are awarding contracts, construction contracts, to deduct the applicable royalty from the running bills. So this is
2014.
Yes, my lords. This is a 2014. Earlier to that, there was another circular, my lords, which is not in dispute as between both parties, because that the deduction under the earlier regime is not disputed by them. The deduction under the.
This is now where is that provision 36?
Rule 36, my lords, I have
Just
only
show us.
one copy of the book.
No, just show us.
Yes,
I will just, I have, ma'am, do you have?
Rule 36, not MMDR Act, it is KMMC rules. It is a subordinated legislation under MMDR Act. If permitted, may I read, my lords? Rule 36. Payment of royalty and dead rent in advance. The holder of a quarrying lease or a license under these rules shall pay dead rent at the rate specified in Schedule 1, as may be modified from time to time, or a royalty at the rates specified in Schedule 2, as may be modified from time to time, whichever is more, whether minor mineral is removed or consumed by him or his agent, manager, employee, and contractor. This is the enabling provision of law, authorizing or permitting them to collect a royalty. So this is as per Schedule 2. Schedule 2, I think recent Schedule 2 may kindly be, I think it is at page number. It is in my book, it is at page number 160, my lords. So Schedule 2.
Yes.
So, see,
We are concerned with which minor mineral?
This is ordinary building stone.
There are
It
three
is,
minor minerals, my lord: building stone, muram, and sand.
It is at clause number
Yes,
10, my
that's
lord.
one thing. The recovery is, or the adjustment is, or the payment of royalty is by operation of law. That's right. There is a provision. Neither they have a say, neither the mines department has a say. There is a royalty which has been fixed in terms of Schedule 2. Whatever is there, that need to be paid. You are not contesting the payment of royalty, adjustment of royalty. You are only contesting it should be at 2007 rates, please, not 2014.
Please, my lord.
But let's assume for a moment that and it's a fact, 2014, the rates have undergone a change. Now, whatever would be the rates in a particular year, that need to be paid, or that need to be paid, royalty or adjusted by them. Getting the point?
I
Not
beg to differ
something,
on that.
not something which was the rates in 2007, that will continue to govern the contract. This is by operation of law.
But my submission would be that since there is no price escalation clause as far as taxes and royalties and such other levies are permitted.
Okay.
So he cannot say that on a future date, if the contract will extend in 2025, also you pay at the rate of 160 rupees royalty, I will be totally declared as.
You are, the only tenable argument can be, look here, when I bid for this work, I bid for the work taking into consideration all the eventualities, including the royalty which I need to pay or which will be adjusted on the rates which were prevailing on the date of the contract.
Yes,
that
ma'am.
can be an argument.
That is one aspect of the case. Second thing, my lords, the headings in the contract have no such relevance or meaning. That itself, the contract itself makes.
How much is the difference between 7 rates and 2014 rates?
It is almost
Yes,
double, my lord.
it is double, my lords.
30 rupees per metric
The
ton. or
contract value is
60
about
rupees.
13, in the first matter, it's 154 crores. In that, my lords, the total claim that is made is about less than 1%, the difference. The idea, my lords, is that because it's not a long-term contract, you're supposed to contemplate that there may be some increase and we have not put any change in law clause. It's a short-term.
How much, see, although that royalty doesn't inure to your benefit.
It is not inuring to my benefit.
Neither it goes to the ministry,
It
the
goes to the
department.
ministry.
But the only thing is that affects his
Total
cost,
costing.
his
contract price.
tender rate or his tender award or the
And for this,
amount.
I will be
Challenging the
blacklisted so that I am unable to complete the work.
challenging the rates, my lords, and a writ petition was earlier filed, which is WP number 501.
I have not filed a
2017.
writ
I'm
petition.
not concerned with that.
Yes, ma'am.
There, the direction was that if there is anything, you got to go and resolve this in arbitration as between you and the contractor, and you can't challenge the rates. So that is the background.
We have not challenged the rates, my lords. The thing is, there is no enabling provision of law to collect the royalty at the upward revised rates. That is the issue involved. If the other side is in a position to show that I have signed such an agreement that even all future revised rates, I am liable to pay the penalty royalty, then it would have mattered much.
But let's assume a situation. Here the royalty has gone up.
Yes.
Instead of going up, it has coming down. What will do? You will still say 2007 or you will say
I
2014?
have asked this very same question to the witness, my lords, in the cross.
Price adjustment clause will come into picture, my lords. And in India, it is, or in a practical approach, it is impossible to get a lower rate of taxation. For everything, every year, every budget, the taxation are going on, except in barring few instances, direct or indirect taxes, there might be. But this is the state. And the respondent petitioner is an instrumentality of the state. They are in one and the same. They are hand in glove. They can't differentiate that, no, the state is different, I am different.
Obviously, they are different. Who is fixing the rates, royalty rates, someone else?
Because they being the instrumentality, only their job is to collect as per notification and credit to the state exchequer.
How much is the difference of rates in 2007 and 2014? Have you worked out that?
100%, my lords. It is 30 rupees previously. Then in 2014, it was increased to 60 rupees.
Double
of my lords.
Per ton.
Per metric ton. And now the issue is going on before the government. 1 minute, just it's only for clarification. State government is amassed with 6,000 crores of rupees royalty collected unauthorizedly. And issue is there before the assembly. Every time from last Belgaum assembly election, it is being agitated. No answer is found. It is the Comptroller General of India has pointed out 6,360 crores rupees has been collected by these means, unauthorized means, my lords. I don't want to do that. I'm not a party to all those things, my lords. My only simple thing is I'm a class 1 contractor.
Got it. Yes.
And this, if my lords permit me, that interpretation clause at page number 19 of the document, tender document, agreement, my lords, at point number 2.1, my lords, in his memorandum, learned government, the petition council at number 19, my lords, page number 19. It is at bottom 2.1, 2.2 interpretation. In interpreting these conditions of contract, singular also means plural, male also means female, or neutral, and the other way around, full stop. Headings have no significance. So that is compensation event that is mentioned therein, in stricto sensu cannot be brought into play.
You said page 19.
Yes, my lords. Of their contract agreement. Just in the morning, they have submitted, my lords.
Conditions of contract, GCC, page 19.
Along with the memo, they have submitted, my lords. Dated 17/12/2024.
Which provision you are reading?
2.1, my lords.
Yeah.
In the bottom. Headings have no significance. Full stop. In the interpretation clause. So it is in generality they have mentioned.
No, you read further.
Further, shall I read?
Words have their normal meaning under the language of the contract unless specifically defined.
Yes.
The employer will something instruction clarifying queries about the conditions.
That's noise.
Okay.
That's
Page 25 is the clause. Not only about the heading, the entire clause is about compensation events. What they're trying to point out is that the heading of clause 38 should not govern the clause. But the heading, it's not confined.
That's what his is.
That's what his is.
But the next line is also relevant.
Words have their normal meaning under the language of the
That's
contract.
right.
Yes, my lord. So if normal meaning is attributed to clause
What is,
38,
even the normal meaning is also what possibly you want to contend or he want to contend, that must be given effect to.
yes. So the normal meaning, my lord, here is compensation event described. The contours are defined under A to G. So there is no, I don't
If
think there
that
can
be
be.
given such a stress, my lords, I would draw my lords' attention to 38.1D. That makes it clear, my lords. 38.1. It is at the internal page 25, my lords.
Yes.
the employer gives an instruction for dealing with an unforeseen condition. Because I could not have any say in the year while signing the contract that royalty would be doubled up, or that has been very precisely called down by Honorable Apex Court in NHAI case matter. If permitted, I will read that relevant portion, my lord.
The employer gives an instruction dealing with an unforeseen condition caused by the
Caused by
employer
the employer, my lord. It
Yes.
stays.
or additional work required for safety or other reasons.
Yes. But herein, unilaterally, without notice to the contract, the bidder, they have increased the royalty.
They have not increased.
I would say that they are stepping into the shoes of the
No,
state.
we will not take that. Let's be very clear. They are, even the circular also is in exercise of these rules.
Rule
which have
36.
nothing to do with it.
Rule 36.
That's right. Who operates 36 rules? A
State.
different entity, not they.
True, my lords. They don't have legislative.
I will say, they may not be knowing it also. It's only after that circular had come to know, they look here, we have to deduct this much. They started doing it.
Yes. Now herein, there is no price escalation which is
Okay.
provided.
Anything else you want to add? Anything else?
So I may be permitted to file the statement of objections.
Why objection? We are in a 37 appeal. These are not a fresh proceedings in that sense. Almost a second appeal, except the fact that this is not.
Then I will
in that
only
sense.
present, I will only present the judgments, my lords. NHI case, I think my learned
NHI
friend
case
has
I have only
already
produced.
submitted.
NHI case which they are trying to rely upon. I have only produced that.
So I have culled out the portions of the judgments in this statement itself, my lords, that if permitted,
Generally, after how much interval they come out with the fresh circular, the state government?
not less than 3 years, because there is an embargo of 3 years. Once in 3 years, they cannot.
So once 2007 issued, for next till 2010, they can't issue.
Yes.
There is an embargo. It is a statutory provision?
Yes, it is in MMDR Act also similar is found out.
So now they brought it in after
2014.
almost 7 years.
7.
Yes, my lord.
Then just shows that.
And my only last submission would be that for asking for refund or making refund, my lords, there is no such authority is needed. When it is excessively collected, that needs to be as a matter of.
That's what the arbitrator has said.
Yes, sir.
What is this judgment?
So I think that.
We have filed the objection. We'll take it. Just give him a copy also.
Yes, I have already given. It is the judgment of Honorable Apex Court in Tarapure Company versus Cochin Shipping Yard.
See, please sign these submissions.
Yes, sorry, my lord. I'm sorry, my lord.
Get this also signed. And you do the e-filing also and give it this also, we'll take it.
Yes, ma'am.
You also do the e-filing of this.
Yes, my lord.
Also-
That I will be.
Yeah, I place on record just 2 judgments, Sanyong judgment and the Delhi Metro.
That's on 34.
That's on 34. What I'm challenging here is the 34 court did not appreciate the argument that the conclusion that has been arrived
No,
at is not.
He meets in 21. You see paragraph 21.
21 of the,
Paragraph 21 of the impugned 34 order.
yes, my lords.
Read it.
It is pertinent to mention that it is settled position of law that the scope of interference with the arbitral award is very much limited to section 34 of the act, provides application for setting aside of the arbitral award. Under 34(2), the arbitral award can be set as only if there is sufficient proof produced before the court to the effect that the party was under some incapacity or the arbitration agreement was not valid under the law, or parties challenging the award was not given a proper notice of appointment of arbitrator or arbitral proceedings, or the award deals with the dispute.
Come to
which
the
was-
last 3 lines of that paragraph.
The proviso to section 34(2)(a) provides that the award shall not be set aside merely on the ground that an erroneous application of law or by reappreciation of evidence. My lords, here, the very case I was.
See the next paragraph.
The embargo created by the statute is the proviso to section 34(2)(a), clearly mandates that the court cannot set aside the arbitral award on the ground that there is an error in application of law. And further, the court shall not also not undertake the exercise of reappreciation of evidence.
These are basically the contours.
I am very well with the finding, my lords, but
You said
what-
this would not be applicable.
No. What I would urge before my lords is that this is if my lords, there is an interpretation of clause 38, which relates to a completely different scenario. And that wrong, erroneous interpretation they've applied in this case is my case. Now the question is, if this were to be extended, tomorrow a termination payment clause could be extended to say even that is included. Now, my lords, we are bound by the parties are bound by the terms of the contract. Now, the clause itself does not apply, and that clause has been applied to give them a relief. That is where I am at, my lord. So even from the judicial precedents, my lords, it's more or less it's settled that on an interpretation of a contract, I cannot normally agitate a section 34.
Where two views are possible.
Where two views are possible. But in an event where it is not a plausible view at all, no reasonable man could have arrived at that conclusion as laid out in Sanyong. In fact, even in the NHA judgment, my lord, para 25, it says the same thing. So, my lords, on that ground, can this interpretation be stretched? A compensation event clause be stretched to mean it's a change in law clause? That, my lord, would lead to an absurd situation. Because there are specific contracts which the governments award where there is a specific change in law clause. So, my lords, it's a time-bound contract. 11 clause 2 and 3 of the bid document says that any eventuality that may have the effect of increasing the contract price, you should have taken into consideration before you bid. Now, my lords, in the contract specifically, there is no clause which says that there is in case of a change in law, I am going to compensate him. So that scenario, my lords, this interpretation would lead to an absurdity. That's all. To support that, may I be permitted to file Sanyong and Delhi Metro?
They don't challenge the very
levy.
The very levy itself.
They don't challenge the levy. So now if
that's something, which is not mentioned in the contract at all.
That's what they say, but they admit that fact that I'm bound to deduct under the contract.
But the only thing is, the other side could not point out any perversity. There is
the perversity is that, my lord.
No, that it should be demonstrated.
Let's go. Give it to us.
Yeah,
Just say this, we learn a counsel for the appellant has filed a copy of the contract. Contract agreement executed between the parties and also the judgment of the Supreme Court in the case of National Highways Authority of India versus ITD Cementation India Limited. 2015, 14 SCC 21.
My lord, and two more judgments, I've just passed on.
And so and so. On the other hand, learned counsel for the respondent has filed statement of objections. Okay. The same are taken on record. The counsels shall also file the above documents oblique judgments, oblique objections in the registry to e-filing. To start. Having heard the learned counsel for the parties, we reserve the appeal for orders. Next.
If execution is posted on the 20th,
if take a date in the execution.
Yes, sir. I think it is posted this month itself.
I know that's what he's saying. You get it adjourned by 4 to 6 weeks.
Please, my lord. Okay. But only thing, if permitted, I will produce the full judgments which I have extracted in my statement, my lords.
In the objections?
Yes, I have extracted only relevant portion. I may kindly be permitted to produce the.
You have
I'm not ready with that, my lord.
We will look into it, or otherwise do one thing. Tell your briefing counsel he should give it to the court master during the course of the day. Just give him a copy. Give her the copy, court officer.
Please, my lord.
You have reproduced that Rekhi, everything, all those judgments, na?
Yes.
Just give him copy to her.
Yes, my lord.
Thank you.
I will be giving it the workflows. I will.
Should I be filed? I had filed a paper book before the trial, section 34 code.
We don't require, it's purely a question of law. What is this? Acha, this is yours, or just give it back to him. Give it back. Ma'am, what did you say? These are two.
Both are the exact same
Reserve.
contractual clause.
41. Serial number 41, Shri Sadashiva.
I represent the appellant's blood. Not the appeal is filed by the tenant before the trial court. Not prior to that, in the year 2011, not they entered into an agreement for sale of the property. At that point of time, 34 lakhs has been paid. In addition to that, 4 lakhs has been paid to them. Within 20 days, I have directed to perform the contract. They did not come forward to produce the records before to obtain the sale deeds. At that point of time, they filed a arbitration before the Honorable Court. In the arbitration, the Honorable Court was pleased to direct the refund of the amount with interest. That has been confirmed by the civil court. Now, the matter was pending before this court, and the matter is dismissed for non-prosecution for non-compliance of the office objections, for which the matter is pending before the Honorable Supreme Court. Is not listed before the Honorable Supreme Court. It is one set of claim. No, Lakshmi Kandi, in the meanwhile, after the arbitration order came to be passed by the Honorable Court, they initiated the proceedings for eviction of the present appellant before the court. We contact this only, out of 5,000 square feet was agreed to be purchased by me, out of which, in the midst of that, 1,500 has been surrendered to the very landlord. They are already in possession of the property. Now, as on date, 3,500 square feet, we are in continuous possession and enjoyment. Since the huge amount has been paid towards the advance money, that is the advance to the purchase of the property, the amount was not paid. During the pendency of that, we have took the contention, saying that any of the fact that we have entered into an agreement to purchase the property. Therefore, we took the contention saying that there is no tenancy, the relationship was there. The court negated the fact. No, the court has declared the suit and to vacate the premises by granting 2 months. But no, by virtue of that, they already filed an execution petition and warrant has been issued. Therefore, we are before this Honorable.
Now, are you seeking any specific performance of the agreement to sale? What happened to that?
That is not attached to be board before, matter is to be board before the court.
Matter?
Supreme
The
Court.
arbitrator rejected the claim for specific performance, ordered for refund of the advance amount received, 34 lakhs. Then 34 also, my lords, it was lost. There was only a modification saying that we'll have to pay the interest from the date of the agreement. We have tendered the payment. They refused to accept that payment.
No.
Then they also refused to vacate the premises. And the appeal under 37, my lords, was dismissed thrice for non-prosecution. Now he claims he is before the Supreme Court. We are not received.
Against that non-prosecution.
Yes,
Yes,
for non-prosecution of
For which,
for 5 years it was kept pending.
That would be an independent cause of action for your.
Of course,
What is observed by the,
How is that will have a bearing? If ultimately you succeed, you'll get the position.
Only I'm putting the facts before this Honorable Court.
We got it. We are just putting it to you.
not right
How
from.
those proceedings have a bearing insofar as this decree is concerned.
No, the matter is going to be listed before the court. Honorable
Very
Supreme
well,
Court.
it's all right. If it is listed, then it will come back, 37 will be decided, then you will get.
No, Milad, that is another thing is, Milad, no, the vacation of the premises, Milad, warrant has been issued, Milad. There is a threat of vacation.
Tell us one thing, how those proceedings have a bearing on this? Tell us that.
And as far as this aspect is concerned, Milad,
There is no bearing?
course.
So whatever is pending before Supreme Court, it will be dealt there.
Yes,
And if it comes back, will be dealt separately.
of course.
How that has a bearing here. So let's go by this.
Yes.
Now you argue this.
Yes.
That's all.
By virtue of this, let me kindly appreciate, we have invested huge money for the industry and other things.
So let's proceed in a seriatim. So tenancy cannot be disputed.
I'm not disputing.
You are not?
For the reason, because pendency of the matter is there, therefore, I cannot.
No. Till you succeed in your specific performance.
Yes.
You can't deny the relationship of
Yes,
a landlord tenant.
of course.
So there is a tenancy.
Of course.
Very well. And tenancy was pursuant to a lease agreement.
Yes.
That period expired.
Yes.
So what should be the consequence?
As far as legal aspect is concerned, the termination of the tenancy has been terminated. I want to vacate the premises for the reason that now we have invested huge money for the.
How that will be relevant?
Only sympathetically, I request the Honorable Court, if ultimately this court votes that I'm not entitled for any relief.
So when did the lease expire?
Yes.
When did it expire?
In the year 2011 itself.
Where are we today?
After the suit was proceeded before the court, therefore, ultimately after the matter was decided by the court.
So 2011 lease expired.
Yes.
So you enjoyed 14 years thereafter.
Definitely,
Then what is
No,
the
Maharaj.
justification? How
Maharaj,
can the equity
only-
come in?
Only justification before this Honorable Court, if the court courts that, I'm not entitled for the relief that I have sought before the trial court. No, only time may be granted till the vacated.
You got how many years?
The parallelly, proceeding.
What do you say on this prayer?
If they are willing to deposit this amount, my lords, and there is a FDP proceedings ordered in this thing, we are about to initiate, my lords. Only an ad hoc, an interim damages has been awarded.
Yeah,
At
you're
50,000.
right. No, those proceedings are pending now.
No, execution has been filed. Now we are about to,
There is a final determination on the mean profits.
Yes,
that is to be
That
done.
is there.
That we are yet to initiate.
That you yet to initiate.
Yet to initiate.
So what he has been granted is 50,000
50,000 per month.
per month.
From 2018, but he has been enjoying from 2011. We filed the suit only in
So
2018.
tell us how much time you want and when are you giving this, satisfying the award or the decree? See, you want time, it cannot be both.
Please.
You want time, possibly we can put it to him. But he's saying, you look here, I have areas.
Subject to order passed by the trial court. That it has to be inquired to by the trial court under Art 20 Rule 12.
What?
The two
Mean profits.
means profit.
That will be worked out.
As
That
far as-
inquiry would be
as far
carried
as-
out separately.
As far as rents are concerned, I'll deposit some amount.
See, it's like this.
Subject to consultation by the executing board.
If we have understood you,
Yes.
you want time to vacate.
Yes.
Very well. He says no issue on time to vacate, subject. He said there are areas of rent from 2018.
But my money is with them only.
We will go whatever is the decree.
Yes.
Did you file any counterclaim?
I've stated so many grounds.
Yeah. But your claim has not been determined.
Not determined by the court.
There was no counterclaim.
No.
So whatever is the decree that will stand.
Counterclaim, we have sought for set off, as we have paid some amount.
Have you sought for set off?
Set up in the
Have
sense,
they?
Only in respect
As a
of electricity dues. That is the only claim, my lords. They're saying that I have paid on his behalf, on behalf of the owner. That's the only.
Oh,
That no formal claim is made, no proof is produced.
very well. Let's go by the decree. That's all.
Time may be granted, otherwise,
How much time you want?
if 6 months time granted.
Very well. When are you paying the areas?
Subject to payment of the amount, 3 months my time.
For what? For paying all the areas?
Arrears, my lord, sir, that has to be subjected to verifying the court by the under R20 rule 12.
Not understand. There are two aspects of it.
Room.
Possession granted.
Not here, last week.
1 minute, please.
Sorry.
Possession granted, temporary mean profits, temporary rent,
Yes,
subject to final determination has been determined by the court,
yes,
saying that you will pay 50,000 per month till such time there is a final determination, subject to adjustment
yes,
after final determination.
yes.
No issue. You want 6 months, we will put it to him. He says, areas, when are you paying? Are you saying within 3 months you pay the areas? We will record it.
Admitted facts, not 6 months. may tell you. Admitted facts, not as per the.
What do you say on 6 months?
And that I'll consider. I'll just put a word to it.
So 6 months and 3 months you pay all the areas.
At least time may be granted, man. Otherwise.
What else you want?
Please,
Very well.
please, please,
You are filing an undertaking
definitely, definitely,
before this court and
definitely,
we'll fix a time frame and time date also.
definitely.
And you must tell him also the consequence of violating it.
But when I'm undertaking the.
Yes,
They shall, no, 6 months is,
6 months, 3 months for the areas.
that may kindly be reduced, my lord. 3 months, because we have
How
been.
much
deprived.
according to you? How much according to you?
Let it be 4 to 6 weeks, my lords.
4 to?
6 weeks, they'll let them deposit the amount.
He says 4 to 6 weeks.
It be 6 months.
And let them pay the rent as applied
That
up
in
to
any
date,
case.
my lords.
That is part of the decree, no?
Yes, my lords.
You continues to pay.
50,000 is determined.
You tell us the time, 6 months,
May-
4, 5 months, it's, what is the nature of tenancy? For what, is it a residential?
No, my lords, it's a manufacturing
Industry.
unit, my lords. Polymers.
Then I think 4 to 6, I don't think so.
No, let them make the payment. My lords, 6 months, I'm willing to give them to vacate the. premises.
Obviously, so we take it, he will agree, he agrees for 6 months.
Yes.
You will pay areas within 3 months, continues to pay the ad hoc arrangement which has been put by the district court till you vacate within 6 months. For every month, you continues to pay.
Not the rate on which, my lord, the court committed the amount or the admitted agreement.
Whatever the court has said, that you need to pay.
Please.
Now, court has said at least whatever we have read is this,
50,000.
50,000 every month.
Yes,
And the areas would relates back to which year? Which year? 2018?
18.
2011,
Date of-
From 2018?
18.
That's right.
That's right.
2018 till 3 months.
Yes,
Huh?
please.
Or you do one thing, till 31st of January, you pay all the areas. February and 6 months would take us to July.
July.
So till that date, you will continue to pay every month that 50,000 which has been determined. Everything will be subject to the inquiry that need to be undertaken.
Please.
Okay?
Yes.
The present appeal has been filed by the appellant. Just mark his appearance also. Challenging the judgment decree dated 31st July 2024. Passed by the so-and-so additional city and sessions judge, Commercial Court, Bengaluru, in form OS number 3838 of 2018, whereby the learned judge, learned trial court, has ordered as under page 40, para 46. We have heard the learned counsel for the appellant and the respondent. We'll stop. After some hearing, comma, the learner counsel for the appellant on instructions from the, is he the appellant who is present?
Yeah,
Yes.
both are present.
Who is present in person, states that the appellant be granted 6 months' time from today to vacate the premises in question, being, what is the address of this premises? B 184. Situated at 4th Main, that's right?
Yes.
Please just listen to this. Second stage, Penia Industrial Estate,
Yes.
Penia, Bangalore, 560058. Measuring 3,500 square feet?
3,500.
3,500 square feet. On or before. Today is what?
End of April.
15th of July, 2025. He also on instruction states that the appellant shall continue to pay the rent oblique mean profits as determined by the trial court of 50,000 per month effective from 1st of February till 15th of July 2025. He also states that the areas as granted by the trial court of the where does he say effective from 18?
It's on the date of the suit. Date of suit at page 76. That's
No, from the date of suit.
date of the suit till date of
The
handing
date
over.
of suit till 31st of January 2025. Till 31st January 2025, within a period of 3 months from today. First of the learner counsel for the respondent on instructions from the respondent who is also present in court and identified by his counsel, states he has no objection, he is no objection if the submission made, if the appeal is disposed of based on the submission made by the counsel for the appellant. Oh, I'm sorry, we are just, oh, you are the representatives now?
Yeah.
What is their designations?
As far as the respondent is concerned, he is the proprietor of that.
He is proprietor. On instructions from for the appellant, what is his designation? Is he a partner?
Partner.
Is a partner?
Partners.
Partner in the appellant firm. And who is Malesappa?
Yes, one of the party.
Partners.
One of the partner.
No, is he present?
Yes, both are present.
Both are present. On instructions from the appellant number 2 and 3, the partners in the appellant number 1 firm. That's right.
Yes.
And now this is for appellants. For the respondent, the proprietor of the proprietor of the proprietorship firm Hydro Products. Respondent. Okay. Full stop. If that be so, comma, we dispose of the appeal by directing the appellant, by directing the appellant to hand over the vacant and peaceful possession of the aforesaid premises to whom? To the proprietor of the respondent proprietorship concern, namely what is his name? Haridas Potta. Haridas Potta on and before 15th of July 2025. He shall continue, he shall pay the areas of rent oblique mean profits computed from the date of filing of the suit till 31st of January 2025. Within a period of 3 months from today, that is on or before 15/4/2025. Full stop. Okay, he shall continue to pay the rent oblique mean profits. Say mean profits, don't say rent. Don't say rent in the earlier also. Mean profits for the month of February, 1st February, effective from 1st February 2025 till 15/7/2025. When just say this, he shall continue to pay the mean profits as determined by the trial court till he hands over the vacant and peaceful possession of the premises in question to the respondent. To stop. The appellant shall file an undertaking on the aforesaid terms in this court with a copy to the learned counsel for the respondent within a period of 2 weeks from today.
Yes.
Just say that the appellants 2 and 3. The appellants 2 and 3. There are 2 partners. The appellants 2 and 3 shall file undertaking on the aforesaid terms within a period of 2 weeks from today. The appeal is disposed of.
4 weeks. I'll get the.
2 weeks.
File undertaking. One more submission, my lord. Suppose if the matter listed before the Supreme Court, my lord, questioning the validity and ultimately they reverse the order passed by the dishonorable court, then my lord, liberty may be given to.
No, my lords. As observed by your lordship, that has no bearing on this, my lord.
Right.
This is an independent.
It has no bearing.
Court
If you
has,
succeed, you will succeed.
Yes.
Let there be a wording, my lord, by the dishonorable court, my lord. Ultimately, my lord, it not should be a final.
Now tell us, this decree, does it say so subject to outcome?
Prove.
It doesn't say?
Prove.
We leave it at that. Thank you.
And this would be without
Next.
prejudice, my lords, to pursue my remedy to determine the actual.
We
mean
say nothing. That in any case goes. We have not said so anything. Next. We just say this. It is clarified that this order only disposes of the challenge made to the judgment decree dated this and this in this appeal. Rest you will work it out.
Please.
Thank you. Next.
42 urgent, 43 government advocate.
Last week, the company application 487 of 24 was heard, your lordship.
Is there any connected matter?
Disconnected matters, we have filed a memo also, your lordship.
When is that those listed?
Today, 6/3, your lordship.
Item,
The very same
item,
connected matters.
item?
43, 44 and 45. 45. All the 3 matters.
These are the 3 matters.
Please, Lord.
There
We
are
have
no
filed a-
other matters.
There is one more matter, Lord. 486 of 2020.
Is it listed today?
Not listed. 23rd it is.
Just say that we notify these appeals on. You get it listed on that day.
Please.
File a memo.
6/3.
Public.
46.
46, Shri.
That's the appellant. My lords, this is a suit. I have filed an appeal against my suit being dismissed, my lords, under Order 7, Rule 11, B, my lords, that is barred by law. The ground on which the Honorable Lower Court has dismissed it is that the appellant number 1 herein, my lords, is an unregistered partnership firm. Therefore, the bar under Section 69 applies. My lords, but my rights that I am agitating here is a statutory, common law right of passing off, my lords. And my lords, my submission is that this is against a settled principle of law that an unregistered firm can enforce its rights, statutory rights and common law rights. And the bar under Section 69(3) does not apply, my lords. I may be permitted to rely on these,
You can also argue
my lords.
Either the plaint would be rejected in totality, but not in part. Now tell us one thing, the appellant number 2 could have independently maintained a suit?
Yes, my lords.
It could have?
Could have, my lords. My lords, but my only submission is, my lords, now the respondents here in, my lords, are continuing to run business, my lords.
All
and-
right, ma'am, you have to serve them. We'll issue notice on this.
My lords, my lords, but the suit has been dismissed on the point of law, my lords. So
No, no,
my,
You have to hear them. See, ultimately it has got dismissed in their favor.
right,
Clearly, they are required to be heard. Just say issue notice. You serve them.
obliged.
27 to serial number 47. 47.
Please, ma'am. Because the appeal is arising out of a money recovery suit, having been partly decreed
Will
against
issue
the appellant.
notice. Have the
Lords,
file execution?
Not yet, please. Lords.
Issue notice.
One of the grounds for my appeal is that the commercial court had no subject matter jurisdiction itself to pass.
Did you
the
take
judgment.
that point?
That point I've raised also, please, my lords. The other-
Here,
Yes, in
there,
there also, please.
what happened?
They said they cannot accept my contention on two grounds, please. One is initially the suit was filed before the city civil court. Then based on my
Then
application.
it should be an RFA technically.
No, it was anyway transferred to the commercial court, please.
But it was transferred.
Transferred to the commercial court and the plaintiff having consented that it's a commercial dispute. So the commercial court was of the opinion that I cannot approbate and reapprobate the same issue and that the issue of this jurisdiction is covered under res judicata.
No, was it your contention
Yes,
that it wasn't just a normal suit, not a commercial suit?
yes, please.
Then we will look into it. We say nothing on it. Today, effectively, a commercial court had passed the impugned order.
Yes, yes, yes. The
Issue
other
notice.
aspect, please, my lords, is the judgment is based on one particular exhibit produced by the plaintiff, which is an email sent by the appellant itself to the plaintiff. In that, please, my lords, that was with regard to the determination of the quantity of work carried out by the plaintiff. In that, please, my lords, the Excel sheet, there's an Excel sheet, if I may take my lords to that document. Ink page 104, please, my lords. Make sure. Sorry, I'm sorry, please. 142, please. Ink page 142. This was marked as exhibit P18. This is an Excel sheet which was issued by the appellants to the plaintiff, determining what are the works he has done, what are the works he has not done. Those can be seen, please, my lords, in the remarks mentioned at the right side. Measured. Some are mentioned as incomplete. That means saying that we were disputing the work he claims to have done. Now, my lords, the commercial court, looking at on the next page, please, my lords, if my lords would kindly see. The total amount of work here is mentioned as 73,81,740. And the admitted amount which he has received in the plaint is some 54 lakhs. So the commercial court decided that the 54 lakhs minus this 73 lakhs is the difference amount which is admitted by the defendants. Whereas, please, my lords, here, some of the works, I have remarked it as incomplete. I have disputed those works.
Those have not been deducted.
They have not been deducted. If that has been deducted, in fact, I have paid 5 lakhs extra, excess, please.
So this can be an argument for maybe on a stay.
Please,
or a deposit. We say nothing, we'll just issue notice. They have not got you have not received any execution notice.
Not yet, please, my lords. It's almost 60 days
To
now.
notice.
They might.
We'll give you a date fix. We'll give you a
Please,
date.
please.
4th March.
My lords, with regard to respondent number 2, the notice may be dispensed with, please. my lords,
Why?
Because she was defendant number 3 in the commercial suit. She was only a formal party. No prayer was made against her. She was placed ex parte. And the suit also stands dismissed against her.
But that would be at your risk.
Please, please.
This is respondent number 2.
Yes, please.
At the outset, learner counsel for the appellant submits that he shall press this appeal only against respondent number 1. We are not recording that.
Yes, yes, please.
Uh,
Yes, please.
In other words, it is a submission that the suit was primarily directed against respondent number 1. And in any case, she was an ex parte before the court below.
No formal.
As no formal prayer was sought. against her. Issue notice to respondent number 1 at the risk of the appellant renoted for the date fixed for returnable on.
4-3. Serial number 48, Shri Ajit. 48.
Counsel for the respondent,
This-
Your Lordship.
This is the defendant's appeal in a suit filed by the respondent herein for eviction and for arrears of rent. Now, there's a bit of a background to this case. I just take my through the relevant dates. On 29th of May 2020, 29/5/2020, I entered into a lease deed with one Mr. Ramesh. Mr. Ramesh is not a party in this suit. I'm sure your lordship has seen that. That is where the problem is. Now, sometime in June 2023, I receive a letter from the respondent herein stating that the property has been sold. Of course, there is nothing to evidence that, but I receive a letter. Now, in all fairness, I received that letter. I asked Mr. Ramesh orally tells me, no, you please keep paying me rent. Then on 8th of August 2023, I received the termination notice saying that you have not paid arrears of rent since April 2023. Therefore, please vacate the premises and also pay the arrears of rent. Then I write to Mr. Ramesh again. In fact, I replied to them before that on 7th of September, stating that I've been told by Mr. Ramesh that I have to continue paying rent to him. Then on 5th of October, this is interesting. On 5th of October 23, Mr. Ramesh says there has been no sale. There has been no conveyance of the property at all. Please continue paying rent to me. And in fact, he goes to the extent of extending the lease by another period of 10 years. So initially, I pay a security deposit of 5 lakhs with him. Then, in October 2023, since the lease is extended for another period of 10 years, I pay another 25 lakhs with him. Then, the suit is instituted. Finally, the impugned judgment is passed. Now, what the trial court finds, couple of submissions, my respectful opinion, of course, there is possibly on a legal issue itself is completely wrong in my respectful submission, where one, the trial court holds that I, as a tenant, cannot dispute the title of my landlord. But there, that is on the, is premised on the fact that I accept him as my landlord and I have not returned to the tenants. So that, there are enough judgments on that count. Section 116 only bars me. If I was disputing Mr. Ramesh's title, then that's a different matter altogether. Here I'm not disputing Mr. Ramesh's title. Then, what the trial court does is goes into, there is a sale deed. Sale deed is yet not registered. There is some issue regarding valuation. It is yet not registered. The trial court refers to that sale deed. It refers to a partnership deed between Mr. Ramesh and the respondents here. The respondent is a firm where Mr. Ramesh apparently was one of the partners of the firm. The partnership deed included a clause which said that if I think the partnership was constituted to construct a property on this, construct a building on this property. Since the respondents were investing a fair amount of capital, one of the clauses said that in case Mr. Ramesh is not able to hold his end of the bargain, the property will be sold. Based on only that partnership, on that clause in the partnership deed, and on the letter of 7th of June issued to me by the respondent, the trial court, I would respectfully submit, erroneously holds that the respondents have title. Now, another aspect which the trial court is also aware of is that sale deed, which was entered into between Ramesh and the respondents, there is a suit pending for cancellation of that sale deed also. He alleges that it was fraudulently obtained and so on. By Ramesh. I'm not a party in that suit. Ramesh is not a party in this suit. So therefore, I am now in a quandary where I have paid rents. Of course, for whatever reason, it's
Let's assume for a moment that is set aside, the sale deed.
Yes.
What would be the bearing on
then, assuming Mr. Ramesh holds his end of the bargain, my tenancy should continue because he has extended my lease deed up to 2035. The only reason why I have been directed to be evicted is because the respondents, according to the learned trial judge, has title over the property. Now, the dispute regarding title is in the other suit. I'm not a party in that suit. So to answer your lordship's question, in case the sale deed is set aside, then the title would...
But your status is still as a tenant?
Absolutely. I'm not claiming title.
You're not claiming title. If that be so, possibly that argument you can be,
yes,
if that is suit is determined in favor of Ramesh and Ramesh having extended the lease till 235, your tenancy would continue.
That's a thought that occurred to me also, but then my only respectful submission to that would be The learned trial judge in this suit, my lords, I would respectfully submit, has probably put the cart before the horse when the question regarding title itself is disputed and the sale deed itself is disputed and it's not a registered document. Admittedly, it's not. Even the trial judge notes. So therefore, could the learned trial judge have decided title in this suit and held in favor of the respondents? That is possible issue.
What is that finding? Let's see that.
I'll just take my lords through it. It is the page 34, if my lords were to kindly see, that's where the observations begin. Page 34.
Yes,
Paragraph 18, my lords. That is the point I'm making. In the present case, the defendant has challenged the title of the plaintiff. It is settled principle of law that the tenant cannot challenge the title of the landlord. That may not be correct with great respect. The paragraph,
in these facts.
In these facts, of course, in these facts. And in fact, there are two very recent Supreme Court judgments which reiterate this very principle. If I am challenging the derivative title of a assignee or a vendee, then I can always challenge the title. But here, since he's admittedly he's claiming through a derivative title, I can always challenge it. So paragraph 18 may not be correct. Paragraph 19, the learned trial judge goes on to hold. However, in this case, DW2, that is DW2 is Ramesh. Earlier owner has categorically stated in the plaint of OS 6582, that's instituted by him, that he has executed a sale deed in favor of Mr. So-and-so and received the amount of rupees 1 lakh. And further, he has stated that the sale deed is pending before the sub-registrar's office. It is also admitted fact that the said DW2 Ramesh has filed a suit for cancellation of the sale deed before the City Civil Court in OS 6582. Further, DW2 has not produced any documents to show that as on the date of filing of the suit, he is the owner of the suit scheduled property. DW2, though he has stated that the defendant is regularly paying rent to him and the defendant used to pay rent through the bank, but in this case, the defendant or the DW2 have not produced statements.
Interestingly, he comes as a witness of the defendant.
He comes as
your witness.
DW2. Well, of course, probably the mistake that I have to admit that both of us made, Malas, is that there was nothing produced on record to show that the rents were paid. But those documents were filed along with an IA for production of documents now. So may I suggest this, Malas, if your lordships is I run a Maruti service station there. I was under the assumption that at least up to 2025, I would continue the service station. Now it's been extended up to 2035. Now, initially, the termination notice was issued, and the attornment notice, or what they claim is the attornment notice, was issued, directing me to pay rents to them. Could your lordships consider, there is a direction to pay about 11 lakhs odd, which is the arrears. If the arrears is what they were interested in, I will deposit it either ideally into the court and subject to the outcome, or if they can withdraw it later. They will at least get that. I will continue paying rents to them. Of course, there's a dispute, we'll pay it into the court, but of course, if they seek an IA.
Ramesh may also come and say.
Ramesh may then come and say. But Malas, I am stuck between, in their dispute, my only intention is, Malas, to continue running the service station, which I believe, Malas, I had a right to continue until 2035. But if the respondent, Malas, initially it appears as if their interest was only arrears of rent, I'll deposit into the court now, if that is the case. Initially, I was told by Ramesh and I was made to believe that Ramesh is the rightful owner. But since, let him, as your lordship rightly pointed out, let him prosecute his suit. Until then, I will keep depositing the rents. They can withdraw it if the court.
Because in any case, you were not paying to Ramesh.
I was paying to Ramesh.
You were paying to Ramesh.
I was paying to Ramesh. There are documents to show that, Malat.
Even the latest rent was also paid to him.
All paid to Ramesh. And in fact, in addition, as I was submitting, initial security deposit of 5 lakhs I paid to Ramesh. When he assured me that he has title over the property and that he will extend the sale deed up to 2035, I paid another 25 lakhs with him. So of course, this is, I'm undergoing a severe financial burden because of this, but it is what it is, Mars. I have no option but to at least try and extend this olive branch to the respondent.
Now the court below has now said that you will pay to them.
Yes, Mars. The arrears of rent. Malas, may kindly see the operative portion, page 42.
Pay the arrears.
That's right.
Along with interest from the date of filing of the suit.
Till the date of realization. And further damages from the date of filing of the suit until date of.
But there is no direction to continue to pay till.
That I am undertaking, because the first direction is to vacate the premises. So therefore, there is no direction to continue paying. So if that is stated, at least I can continue the premises. I will continue paying the rent, whatever rents I was paying.
What do you say, ma'am?
Your lordship, kindly seek 2 weeks' time so that we can file the objections properly for whatever is being submitted today.
Just say that issue notice. So accept notice. Letter request. Now, today the suit has been disposed of. We can call the TCR also.
Yes, sir, absolutely.
Just say this. Let the TCR be requisitioned before the next date of hearing. Why pleadings, ma'am? You will file some submissions. That would be better. Counsel for the parties to file their submissions along with the judgments they want to rely upon within 3 weeks.
Yes,
But
sir.
you are not seeking any execution.
We have already filed an execution petition in the commercial court. The next date of hearing is 17/2, your lordship.
Then do one thing, then you deposit here in the court
We'll do that. We'll do that.
and, but only about the future rent.
Yes, ma'am. Future rent, we'll have to, well, ma'am, I leave it to this honorable court. If future
Hmm.
rent, if we have to deposit into the court, we will do that. Or if we have to pay the respondents.
No, the respondent then, although in terms of this, in terms of the impugned judgment decree, they have the right to receive it.
Because there is a finding regarding their title. It was what my.
Then you will deposit here.
We'll deposit into the court.
How
Because
much
then
has
we are
been,
worried
how
Mr.
much has
Ramesh
been,
will-
how much has been determined per month?
1 lakh, no, that's damages. 1,63,375 was the latest rent. There was a 5% escalation every year. So for 2023, it was 23, 24.
Defendant liable to pay damages per month from the date of the filing until the date of the handing of the possession. That's also there, Mr.
That's also there.
Full stop. You know, just say this, the appellant shall continue to deposit an amount of 16375. The damages as determined by the trial court with the Registrar General of this court on or before 5th day of the calendar month. Okay, till the next date of hearing.
Yes.
Just give it in March, man. And the amount to be deposited by the appellant on the strength of this order shall be invested in an interest-bearing FDR with periodical renewals till further orders.
There's a direction that should not be evicted in the meantime. That's my only apprehension.
Be assured.
Full
we
stop.
will.
In view of the above order, comma, the learner counsel for the respondent states that till the next date of then, you do one thing, you have filed execution, notice issued,
It has to be issued, your lordship.
states that the execution petition has been filed in the concerned court. The same shall not be pressed till the next date of hearing in these proceedings. Okay? Give a date.
21st March.
We'll allow this stay application then.
Grateful.
Your lordship.
Yeah, we keep it pending. We have said so till next date, no?
Till next,
Yes, your lordship.
Let it be. Just say notice in that also.
we'll file our
Stay
submission.
applications, file your submissions.
Grateful.
49, Shri Madhusudan Rao.
Yes, Mr. Hola.
Respondents. Our father of the appellant, my lord, one Ahubal Acharya. He had, my lord, 7 sons, 3 daughters. There was a house, my lord, where he was residing, my lord, my parents were residing. My lord, the appellant was also residing there. He, my lord, executed a will. As per the said will, clause 8.2, my lord, specifies that, my lord, on the death of our father, it will, my lord, be shared, my lord, by all the sons. What has happened? All the sons. What has happened is, he also, my lord, made 2 of our brothers as executors. The clause 10.2, my lord, specifies, one is, my lord, 8.2, where, my lord, it says, my lord, that it will be taken by all sons in equal share. Clause 10.2, my lord, specifies that, my lord, 2 of the sons are appointed as the executors. What they do is, they call a meeting, where, my lord, they say that, no, we want to now sell it. I said, I am prepared to purchase this. My lord, my offer, I said I'll pay the market value. My offer is not accepted. They, my lord, sell it in favor of, my lord, 2 third parties. I am still in the house. I am, my lord, residing there. I filed a suit.
No,
They
no.
filed a suit, my lord, for eviction. That is, my lord, the purchasers. I, my lord, contested it, saying that the sale itself was bad because, my lord, the will specifically says, my lord, it will be shared by all the sons. One. Secondly, my lord, when I made the offer for purchase at the market value, they ought to have given it to me, not, my lord, to third parties. I am residing there. This aspect, my lord, has been ignored. Trial court, my lord, holds. My lord, I specifically pointed out that, my lord, I am willing to purchase this. In my notice also, I stated that. Trial court says that, you did not, offer to purchase. Therefore, my lord, this is one. Secondly, my lord, the trial court, my lord, what it does is, the will says, I hereby appoint, my lord, so and so, that's the two sons, as the executors of the will. After the lifetime of my wife, executor shall take possession of the property disposed of under this will. My lord, disposed of means, my lord, given under this will, and shall divide them in equal shares. Trial court holds, disposed of means, my lord, they can dispose it off. Of course, it also held, my lord, that 307 of the Succession Act empowers, my lord, the executors to, my lord, dispose of the properties of which, my lord, they are the executors. My submission is that, my lord, has to be read in conjunction with, my lord, the terms of the will, and not, my lord, dehorse the will, terms of the will. Will specifically says it shall be shared, my lord, equally. One. Secondly, my lord, when they were wanting to sell it, I offered to, my lord, purchase it at the market value. That ought to have been taken.
During the lifetime of the mother,
Ah.
it could not have been
No, it
even
could have been sold.
sold
Yes,
and even divided also.
absolutely, my lord. Absolutely. Absolutely.
During
This
that
happened
time,
after that,
it's
after the mother's death. my lord.
but she is alive?
No, my lord.
No, she's.
She is not.
She died. This is, my lord, the short question for my lord's consideration. My submission is, my lord, I'm supported by a few judgments of the Supreme
This is the eviction now they have granted.
Yes, my lord. That has been stayed by your lordship's
Okay. Then just show us this.
Can I, my lord?
order sheet. Yes, yes.
Can I draw your lordship's attention to page 103 of the paper book?
When was the stay granted, Mr.
My lord, it was initially granted, then, my lord, they gave an undertaking.
We undertook, I think,
Orally, sorry.
not to file the.
My lord, I stand corrected.
This shows that. No, we have a. Will not execute the decree.
Yes.
Page 103.
Okay.
103, my lord. Refers to the judgment. Let kindly see clause number 10, my lord. Your lordship. Yes,
Yes.
I hereby appoint my sons, Sirangan and so and so, that is respondent 4 and 5 before your lordship. After the lifetime of my wife, the said executor shall take possession of the properties disposed under this will and shall divide them in equal shares among my sons. They will pay rupees 5,000 to each of my 3 daughters. That 5,000 in 1974 will be about 1,47,000 today. Now the executors called a meeting, took out paper publication, nobody objected, entered into agreement with the respondent before lordship purchasers. Now thereafter, the total measurement of the area is about 4,000 and add. This 5,000 to the 3 sisters could not have been given but for the fact that the property had to have been sold. Now, what the executors did is, the built up area is about 3,000 square feet. The total sital area is about 4,050 square feet. If the property were to be divided, it can only come to about 500 and odd square feet. But
Was it
physically, there
possible-
was no possibility.
Is it possible to divide meets and bounds?
No, it was impossible. There was a 3,000 square feet built up area. And Milad, most important is 5,000 rupees, which comes to about 1,40,000, which comes to, if we calculate 3,000, the inflation value, they had to be given. Therefore, they called a meeting. Thereafter, took out paper publication. Sale agreement was entered into, and in 2013, the property was sold. Now, all the 9 children, they are with me, including the executors. Now, this gentleman, he did not want to purchase. He entered into an agreement with another person to sell the property. That is admitted fact. He wanted to sell this property, his share is referred to in the sale deed.
Now his only contention is my consent should have been taken. Now 307, which is interpreted by the Honorable Supreme Court, specifically says if the executors are appointed, they step into the shoes of the legal representatives, and the statutory operation, by statutory language is they have the power to dispose the property. This is not the learned judge does not use the word dispose from the will. Learned judge refers to the word dispose under section 307. May just your last I notice not section
But
307.
did he pay offer more than what the appellant had offered?
I offered the market value, my lord.
No,
I paid about 3 crore in 2013, which comes to about 15
I
crore
not
today.
offered the
For 12 years, my lord, I did not get the position. Not kindly see my predicament. I'm a bona fide purchaser. I'm sorry, Mr. Ola, sir. Sorry, sir. I'm a bona fide purchaser. Sale agreement was entered into. 2 paper publications was taken out. And he did not object. There was no objection. He tried to sell his 1/7 share.
By a paper publication?
Calling for objections from the objectors, if any. So nobody objected. And we purchased the property for valuable consideration, about 3 crore and that, which comes to about almost about 15 crore today. Now my predicament is last 12 years, I'm not able to get the property.
Yes.
307 of the 2025 Act.
Yes, दिखाइए.
But power of executor or administrator to dispose property.
Yes.
Subject to the provisions of subsection 2, an executor or administrator has power to dispose the property of the deceased vested in him under section 211, either wholly or in part, in such a manner as may think fit. If the will only provided for dividing the property, the executor could have simply said, effect the partition deed and say, each of you take 1/7 share and forget it. It is for them to divide the property by means, and each of them would have got about 24 into 24. A built-up area of 3,000 square feet. There was humanly impossible to squat on the property, except the fact that the built-up area is already there. It is not even floor-wise. It is horizontal construction. Now, the reason they sold the property is 3 sisters had to be paid 5,000 rupees each, almost 1974 valuation. As I said, it comes to about 1,50,000 today. Therefore, but without selling the property, as per the power granted under section 307, read with the terms of the, there was no embargo under the will to sell the property. And they were executors bona fide, called for objections, entered into agreement and sold the property and paid off all the 3 sisters and all the 7.
When did the mother die?
2010.
2010.
Yes,
Immediately thereafter, the meeting was convened. I said, my lord, I want to purchase this property at the market value. They did not give it to me.
But tell us one thing, otherwise what is the right you have?
My lord, my right is, my lord, if they are wanting to sell it to third parties, I am residing there. I am a sharer, co-sharer or co-owner. Therefore, my lord, I am entitled to. My lord, please look at, my lord, a judgment of the Honorable Supreme Court for my lord's consideration. 2005, 9 SCC 375, where the lordships have held the will, my lord, 307, my lord, power has to be read in conjunction with, my lord, the will, terms of the will. Terms of the will specifically says, my lord, it will have to be shared along equally amongst all of us.
No, but
I'm residing there.
How would you reconcile that with section, this clause 10?
My lord, clause 10, what does it say? My lord, please have a look at clause 10 again.
Yes.
It does not say that, my lord, their disposal, my lord, is where? Disposal, my lord, in terms of this will to the, my lord, the sharers. It is not disposal to third parties.
After the lifetime of my wife,
correct, my lord,
the said executor shall take possession of the property.
Absolutely.
Disposed of under this will and shall divide them in equal share.
Correct. Clause 8.2, my lord, specifies that, my lord, it has to be, my lord, given to all the 6 sons, my lord, 7 sons in equal share. 1.
No, read the words, Mr. Sir. Said executor shall take possession of the properties. And mind it,
yes,
this would be taken by those 2 persons.
Yes, absolutely.
Dispose of under this will. Dispose of under this will. And shall divide them in equal shares among all my sons.
Next sentence.
Dispose of, see, what is the relevance of the word dispose of, Mr. Hola?
My lord, not dispose of, disposed under this will. Please look at it, my lord. Look at the word.
Disposed of.
No. Disposed of under this will. Wording used is disposed of under this will.
Properties disposed. Very right.
Under this will. That under this will, my lord, clause 8.2, my lord, specifically says.
Clause 8. This.
Yes, my lord. 8.2 specifies that, my lord, it shall be, my lord, shared equally by all the 7 sons?
No, after my, if you see paragraph, just a page before that,
Yes, my lord.
page
Page
102.
102, sir.
Page
Yes.
102.
Yes. After my device, the said house shall vest in my wife, but with no power of alienation. During her lifetime, she shall be entitled to reside there, lease out the entire house or portions thereof, use the rent for herself. She shall also be entitled to raise loans if necessary on the security of the said house for the purpose of effecting repairs, additions and alterations to the said house, and for any other domestic purpose in consultation with my first dash sons. I don't know what this is. First 2 sons. She shall not be entitled to dispose of the said house by way of sale. After the lifetime of my wife, said house shall be taken by my sons in equal shares. Then, my lord, paragraph 10. Next page. I hereby appoint my 2 sons, Srirangan and Saumya, as the executors of this will. After the lifetime of my wife, said executor shall take possession of the properties disposed of under this will. Disposed of, my lord, in terms of clause 8. And shall divide them equally amongst the 6 sons, all my sons. That's why, my lord, Honorable Supreme Court in 2000, my lord, 5-9 SCC specifically holds, it has to be, my lord, this power under 307 has to be, my lord, exercised in terms of the, it can't be contrary to, my lord, the terms of the will.
That goes without saying, Mr. Ola.
That's
It
all.
has to be, ultimately, this is a will, it need to be the.
Correct. My
Even if I-
submission to your lordship is when I, my lord, offered to purchase it, my lord, sibling rivalry has come to the fore. That's all. I said I am prepared to purchase the market value. They should have given it to me. Now they can't, my lord, and this gentleman, my lord, has purchased it.
Did you offer any amount?
My lord, I offered him the market value, whatever is the market value. I
A
said,
very vague word, Mr. Hola.
There's no document.
in fact, my lord, what we said was, I'm told, my lord, let the valuers be appointed. Whatever is the valuation, I'll pay it. Whatever is the valuation. I specifically said that.
And
in the meeting.
after he has offered, did you say, so I will give you more than what he has offered?
There was no offer at all to us.
No, but he, in any case, he had purchased it.
My lord,
Surely must have expressed himself.
nothing was shown to me. Nothing was given to me. Nothing was indicated to me. Straight away, my lord, those 2 persons, my lord, have sold it. That's my problem. My lord, I am residing there. I've been residing with my parents from the very beginning. These are all persons, my lord, who are outside. Sisters have got married and gone out. Brothers, my lord, are all outside. I was looking after my father and parents, my lord, and I was there all along. I am residing even now. Where do I go? I am a co-owner. Therefore, my lord, my submission to your lordship says, clause 8.2 and 10 has to be read together. It can't be, my lord,
It was
divorced
set
that.
out for hearing.
Millet,
Huh.
Millet, your lordships are aware. He cannot exercise the right of preemption available under section 8 because the will ousts that preemption under section 8. Millet, 8 does not apply because the will is now the executors could have dispossessed him in 2010. It's only because the executors did not dispose, because the executors were asked to take possession of the house in 2010. Kindly similar, I'll read it again to 2000.
No,
Page 1.
the relevance of 10 is the mother expired.
In 2010.
10.
2010.
Just say this, after the lifetime of my wife,
Yes.
the said house shall be taken by my sons in equal shares.
Yes, before that, just before that, my lord, before that, the executors shall take possession of the properties. My lord, in 2010, he could not be in possession of the property because the executors, my lord, thought.
Where are you reading?
My lord, page was 103, my lord, clause number 10. Clause number 10. I hereby appoint eldest brothers after the lifetime of my wife and said executors shall take possession of the properties disposed under this will. In 2000, but he said he is the only person who is, and he is not even residing there. He is residing elsewhere. That's a different thing. He did not offer for sale. There is not a single piece of paper. He wanted to sell the property. Kindly see page 100.
But tell us one thing, Mr. Hola.
Page 100.
Just one.
I'm sorry, man. I apologize.
The intent was.
Yes, ma'am.
That the property need to be divided.
Yes, ma'am.
There is no question of executors.
Absolutely.
There is no question of executor disposing it off. There cannot be any.
Yes.
But it is there.
Yes, ma'am.
Now, how would you reconcile?
Yes. Therefore, my lord, a co-owner always has a right of, my lord, saying that I will purchase a property at the market value. My lord, please look at it. Is it not, my lord, an inherent right in a co-owner to say, don't sell it to third parties. I am giving you the very market value. After all, my lord, for what purpose, my lord, are they selling?
Okay, we will see that. We'll set out for hearing.
Please, please.
Yes.
Preparing for executor.
You are,
The eldest brothers, as I said, out of 10, 9, they've already joined the sale transaction one way or the other.
we'll set out.
Yes, yes, certainly, my lord, certainly, sir. But in the meanwhile, my lord, there is a money decree against them up to about 65 lakhs. Let them deposit 50,000 rupees as damages awarded by.
My lord, there's already a deposit. 60,000, my lord, we had deposited.
60,000.
65 lakhs.
Okay. Yes.
They have deposited 65 lakhs to be paid to us. That is still there. And
That's
we have
below
not
the
taken it.
code below.
Yes. That's what, my lord. That's why, my lord, on the
So I
last
must-
occasion, my lords, my
Must
lord,
get something, my lord, for 12 years. I'm a bonus.
taking that
Mr.
into
Holla, sir, cannot find fault with me for purchasing this property.
taking that into account, my lord, your lordships have granted an order of stay.
He wanted to sell this
Thereafter-
property.
Now tell us, Mr. Hola, very well. Any mean profits has been determined? No, insofar as the property is concerned.
My lord, there are two things. One, my lord, they say that, my lord, 65 lakhs which they have deposited should be paid to me. And then they say pay 50,000 rupees per month. My submission is, my lord, 65 lakhs, my lord, which was to be given to me is still there. Therefore, my lord, on the last occasion when the matter, first occasion when the matter came up, your lordship, my lord, took that into account and granted an order of stay. Thereafter, they came and said, I am granting my lord, I am giving an undertaking. They can't have, my lord, when your lordship granted an interim
Just say
order.
this.
That it is their share of sale consideration.
We will
That
determine. What is your submission?
Kindly see, this is only a residential property, may take the lordship to section 211, my lord. The executors would be the,
Yes.
my lord, the executors would be the legal representatives for all purpose, my lord. I will step into the shoes of the testator, my lord, my father, my lord. Now, what happens, my lord? Though there is no attempt, my lord, it's only to squat on the property, the defendant number 1 tried to take control of the property. Never about that, it's only on the paper, my lord, he instead wants to sell the property by 1/7 share, my lord. Now, kindly see, my lord, once I am a legal representative of the testator, I step into the shoes. Legal representative, my lord, what it has been divided under section 211, my lord. Who in law represents the estate, my lord. Now, the entire property vests with me, now 307, my lord. 307 gives a power, my lord, to the executors to, my lord, literal mean, not the, even the literal meaning, my lord, the will has to be given the effect, my lord. 7 brothers, my lord, the properties could not have been divided, my lord. We have taken that,
money.
even if we divide, my lord, it comes.
No, he's now forget insofar as the property getting divided by meets and bounds. His now submission is only this. The right he has as a co-owner to purchase it first. That's what he's putting at it.
That's one. And
That, my lord, if the succession is under
in this judgment, 211 was considered.
if it is under section 8, my lord.
My lord, co-owner, that's an exception of under this section, under this
Indian
Succession Act, my lord. The very same judgment what the learned association council relied upon, my lord.
We will hear you. We'll hear you. Just say this, list the appeal for hearing on. Counsel for the parties to file the written submissions along with the judgment they want to rely upon. The TCR has come, ma'am?
Yes,
Yes, my lord.
well, let them deposit the damages, my lord. What, let them deposit the damages.
Well,
What we have deposited is his sale consideration. If he wants, I'm sorry.
65 lakhs is there. Your lordship is granted in absolute stay. Then thereafter, they come and say, my lord, that
What you are saying, Mr. Hola, is in any case, suppose you don't succeed, that money will come to you.
that's all, my lord. I
That
have not
can be-
taken it.
That can be adjusted against.
Correct. Therefore, my lord, his
No.
his interest is safeguarded. More than that.
No. What the trial court has done is, from the date of filing of the suit, I am deprived of the possession. Though the kata is entered, sold it. Therefore, you pay the damages to me. That is what the trial court has said. This is nothing to do
No,
with this.
you are not understanding.
Yes,
You're
I'm
right.
sorry.
This 65, what is the relevance of 65?
65 lakhs is the sale consideration which
Which
he
should
would
go
pay.
to him.
He want to dependent one.
Which should go to him. That's right. He says 65 lakhs is now deposited. To that extent, you are secured. Anything by mean profits, if he doesn't succeed, you will take it from there. That's what he's saying.
That's all. Great.
Just say this, submissions, okay? And trial court record has come.
Yes, sir.
Trial court, paper books be filed.
Please.
Paper book be filed within 3 weeks, list in first week of March.
Yes,
Till next date of hearing,
the undertaking shall continue.
the undertaking given by the learned counsel for the respondent number.
Five and six.
5 and 6.
Alva?
5 and 6.
My friend appears for 5 and 6. One,
Yes, Srirangan and
1 to 4. I'm 1 to 4, the original.
you are
plaintiff.
1 to 4. No?
Yes, madam.
1 to 4.
Yes.
Shall dated 26 on 26/9/2024 shall continue till the next date.
Is published date.
Serial number 50. Srimati
Yes.
Devi.
Now, did we hear this matters at any point of time?
No,
Mr.
my lord.
Naganan?
Has to be, my lord,
No,
No.
because there was one set which had come before me and Justice Joshi.
no, my lord.
It's
this was
not.
It's the dispute is regarding the seniority of appointments by transfer, my lord. To certain category, my lord, what happened was appointment of assistant engineers, junior engineers. Because there was no qualified candidate, they had a system of appointment of a lower level officer who had still not yet got that qualification. With a rider that as soon as he gets qualification, he will get confirmed in that position. So the question now, the dispute is on seniority.
Whether it should relate back or it should be from that date.
Correct.
That's the
No,
issue.
my lord, yes. What has happened is from this policy, my lord, was in 1996. After that, several seniority lists have been issued. And only in 2020, a writ petition is filed, saying that we have to get seniority above them. And they have not challenged the seniority list.
When was the seniority issued?
My lord, there are at least 6 seniority lists starting from 2000 onwards.
And all seniority lists were acted upon.
Yes, acted upon. So that's one of the main contention. Learned single judge, my lord, has said, whatever it may be, I have to give effect to the 96 order. Retrospectively from 1986, I must redo seniority. Many of them are no longer in this world also. Naturally, my lord, 86. And so, my lord, we'll file our synopsis and then, my lord,
414. Who appears? You appears for the officers.
I appear for the electricity undertaking, KPTCL board.
So then what is the effect then? If that is allowed to stand, everything has to be redone.
Everything from 1986.
What do you say?
Lords, I represent Lords respond number 6. Lords in the present writ petition. Lords, this is pursuant to Lords the direction issued by the Honorable Supreme Court. Lords, this is not a case where Lords they can draw it Lords on the ground that somebody has Lords published the seniority list and we did not object to it. Lords, the policy Lords which was brought into force Lords that was challenged before this Honorable Court. This Honorable Court specifically Lords sets aside the policy relying upon Lords the decision of the Honorable Supreme Court. Lords, where Lords the entire issue is with regard to Lords, we were recruited earlier to them. Lords. That is an admitted fact. Lords, so far as Lords the persons who were holding the post of junior engineers, Lords, they were Lords promoted or appointed by transfer. Lords, above us, placing us Lords below them.
By transfer means from elsewhere.
No, Lords, from the junior engineer post to the post of Lords assistant engineer, based on the Lords policy that since they acquired the degree, that's why they shall be placed Lords above us, notwithstanding the fact that Lords we entered into the cadre Lords much earlier to them. The retrospective seniority Lords is given. And in fact, Lords, these issues Lords are fully settled Lords by this Honorable Court and the Honorable Supreme Court. They implemented it Lords from 2010. What made them Lords not implementing the order of this Honorable Court and the Honorable Supreme Court order Lords from 1986 Lords is not forthcoming. One more aspect Lords is that how Lords the 6 seniority list.
But tell us one thing, when was the first seniority list was issued?
Yes.
Based on this interpretation which they're trying to give. The
Yes.
earliest one.
Yes.
When was that?
Lords, they say that Lords,
14/11/2000. 14/11/2000.
they did not Lords specifically mention that these persons came from junior engineer position Lords appointment by transfer. They did not Lords. They published in 2017 for the first time. That's how Lords we came to know that. Otherwise Lords there are several thousands of Lords engineers or Lords the appointees who were there. Lords, we were totally unaware of Lords those facts. Lords, they did not publish Lords. That is admitted fact.
You are a recruit of which year?
Lords, I am a recruit of Lords between 1988 to 1998 Lords.
from 1988 to 1998.
So,
They
but-
published,
but
my lords, only in 2017.
The first seniority.
No, my lords,
Huh?
giving details of, my lords, the persons who were in the junior engineer post, my lords, they were specifically promoted.
Previously, they were not.
They did not, my lords. Let them, my lords, point out.
No, but
any of
tell
the-
us one thing, once they initially issued a seniority list in 2000,
Please.
the names and the date of transfer would be reflected in the,
Lords, that is not, my lords.
oh, that was not done.
That was not. Otherwise, my lords, even we would not have come to, my lords, the knowledge of this particular, my lords, issue.
We'll set out for hearing. I think this would take time. Just say pleadings, otherwise everything are complete.
Complete.
Hey, synopsis,
Not there, no?
not filed yet.
File it.
Yes.
But we are only saying you appear for the
Board. Yes,
the
The transmission corp,
transmission corporation.
KPTC.
I think possibly then, Mr. Nagaran, anything, if we can be any chart-wide description, I think that would be better.
Yes, my lord, I'll file.
Relating back, from which earliest point of time the seniority would undergo a change if you have to carry out the exercise?
Earliest
Today.
point, yes. As per directions of the learned single judge, from 1986, I have to redo the seniority. That's the direction given by the learned judge.
They gave an endorsement,
That's the
my lords, on
operating
5/3,
portion of the order.
2020, stating that, my lords, that would, my lords, involve 179 engineers.
And
Now
here-
tell us one thing, this is another interesting. 86% who gets a seniority, where will he be when he actually gets retired?
Exactly.
Maybe he will say managing director.
Some of them, my lord, have retired from their posts, some have retired from the world.
Very interesting matter had come before me. Sorry to interrupt you. See him, that fellow, he gets employment from a bag day. He says now I should be as the topmost. But these are the eventualities which need to be looked
The
into.
topmost position, my lord, engineer can go to his chief engineer. Beyond that, it is a selection post. That is for director, executive director, director.
The submissions be filed by the council for the parties within 4 weeks. List on. This would, this is a typical of seniority issues.
Absolutely.
Just give it my March.
5th of March.
Please.
Yes.
Anyone? Serial number 51.
My pleasure.
Just re-notify. We'll have it some other day. What is this issue?
Lordship, in this case, pension and gratuity benefit has been withheld.
Just take it. What was the issue?
Please, your Lordship. On the ground that, ground of conviction in a.
Yes. See, you have just gone in appeal. That doesn't mean that there is no conviction against you.
Please, your Lordship, but in this case, what has happened, your Lordship? After the superannuation, your Lordship, the benefit has been withheld.
The provisional pension.
Yes, your Lordship.
Now, where is the order on that Rule 19? They issued a show cause?
No, they have issued a show cause under Rule 9.
Tell us one thing.
Please.
You have
May-
been
may-
convicted?
May I make only one submission? We are trying to get the matter listed, your Lordship, in that criminal appeal.
Wow, it has no bearing. That will come in on its own turn. We will see it.
No, if that is disposed
No,
of,
it
your
will not
Lordship,
have any bearing. Just see it, just.
Yes.
You were convicted
Yes, your Lordship.
by the time you retired.
Yes, your Lordship.
A show cause notice is issued. Conviction lead to your, maybe dismissal. Dismissal could not have been done because you had retired by that time.
Yes,
So it is bearing only on the pension.
pension.
They say 100% cut in pension.
Yes.
Okay. Now, once there is a 100% pension cut, there is no question of provisional pension. You have gone in appeal.
Yes,
That's right.
yes,
That appeal till such time it is decided. If it is decided finally in your favor, you will get everything.
yes, your Lordship.
That's how it has to be seen.
Yes, sir.
That's all.
My only respectful submission is that, your Lordship, Rule 9 of CCS, pension rules is applicable only in respect of a government servant, not for a person who is already, superannuated.
No, see, it's like this. Though you are convicted, though you cannot be given 100% pension, but they should give you provisional pension.
Yes.
That can't be taken. That we can't accept.
In fact, your lordship, rule itself, in fact, it provides for withholding of either full or part. My respectful submission is,
That's the reason when your trial, everything was pending, they were giving you provisional pension. Right? Once you got convicted, they've stopped because there is a penalty of 100% cut pension. You have gone in appeal. You can't take benefit that fact that, look here, there is a conviction, but I am in appeal. Let them give me provisional pension.
at least, some part of the pension can be given, your lordship, because of.
That's the reason we are
facing a lot of
saying
health
you
issues.
succeed in the appeal, you will get everything. That goes without saying. Once you succeed in the appeal, everything, then you will make a claim, look here, now I have been acquitted. Okay, my conviction set aside. You give me my pension back. You will claim that time, not now. Okay.
Short accommodation may be given, your lordship. I'll place on record some of the judgment, your lordship, where they have held. The provisions of Rule 9 is not applicable.
We are with you on that. Rule 9 is an eventuality when the proceedings are pending. When the proceedings were pending before the trial court, before conviction, you were getting provisional pension. That's right. But once a conviction has been effected, there must be some consequence. You can't be in the same position as was there pre-trial or pre-conviction. You can't be. And on Rule 19 notice, they have issued 100% cut in pension after taking the advice of UPSC. We will dismiss this, we'll pass orders. Okay. No, I don't think we should take it.
Short accommodation, your
No
lordship.
need, no need. There is nothing. We have seen it, please. We have seen it.
Only thing, I would like to drive your attention to Rule 9 of the CCS.
You show us, we will see it now. Just show us that CCA rules.
Public servant or somebody to enter.
It would not make any difference. See, Rule 9 is what? You have Rule 9?
No,
What is your submission?
it is,
You are not the public servant as on the date when the order was issued.
that is my first submission. The other submission is that, your lordship, it also provides for, withholding of pension or gratuity, either in full or in part. Because I'm facing some severe health issues, your lordship, so I'm just
is
requesting at least 50% of.
Pension rules. Leave it. We will just access it from here. Yes, let's see. Rule 9.
Please.
Which part of the provision?
First.
See, Rule 9.
One, your lordship. Right.
The right of president to withhold and withdraw the pension.
Yes.
Okay?
Yes.
If in a departmental or a judicial proceeding, the pensioner is found guilty of grave misconduct or neglect during the period, including service under further UPSA consulted the departmental proceedings. Now, what are the judicial proceedings? Judicial proceedings means shall be deemed, now judicial proceeding means shall be deemed to be instituted in case of the criminal proceeding on the date of the complaint or report of the police office, the magistrate in case of. Yes, which part of the rule you want to rely upon?
Sub-rule one, your lordship, presents, a president reserved to himself the right of withholding a pension or gratuity or both, either in full or in part, or withholding a pension, ordering recovery from a pension or gratuity of the whole or part of any pecuniary loss caused to the government, if in any departmental or judicial proceedings, the pensioner is found guilty of grave misconduct or negligence during the period of service, including service rendered upon re-employment after retirement.
So you have been convicted, your conviction stays as long as not set aside. So today you are a convicted person. If the only sentence has been stayed, that serene judgment which they have relied upon, tribunal, has rightly been relied upon. That's what the Supreme Court says.
Yes, your lordship.
Okay. Now today your claim is that it should be given provisional pension.
At least, I mean, the rules provides for withholding of either full or part of the amount. So my respectful submission in this case is that, your lordship, it's like a mercy petition, your lordship, that I'm only on the ground that I'm suffering from various health issues, your lordship. So it
Right.
may be permitted.
What
at
were the
least,
charges against you?
And it's under section 13 of the.
That's right, it's a serious charge.
In fact, your lordship, it is recovered from the table. It is recovered from the, on the table. The amount which was kept.
We
on the
say
table
nothing.
and-
That's a but there is a conviction on that basis.
Yes,
Right,
I do.
right. It can't be. Okay, can't be difficult. We'll dismiss it, we'll pass orders. Just call the next item.
52, serial number 52, Shri Aditya.
My lord, serial number 52, I beg to appear for the appellant.
Opponent.
Lord.
I'm the respondent.
When was the penalty imposed?
My lord, first penalty was imposed on 28/7/2007.
6 months means
6 months means, my lord, rule says from the date of communication of that order.
the rule says so.
Please, my lord. May I-
But even otherwise,
Huh.
let's see, even from the date of the order, 6 months will expire when?
My lord, 6 months will expire, my lord, on 27th of January 2008.
Okay, now when did you invoke this?
My lord, I issued, my lord, the show cause notice to the respondent on 24th November 2007.
Before the January?
Please, before January, before the.
Then what is the basis for the learned single judge to set
My
aside?
lord, learned single judge says, my lord, our contention was that we exercise the power of the revision within 6 months from the date of communication of the
But
penalty.
will that make any difference? Even from the date of order or even from the date of communication?
Please.
If it is within 6 months,
Please.
you are within your rights to invoke?
My lord, that's the learned single judge said, my lord. If I would have invoked the exercise the power within 6 months from the date of the order,
Huh.
my lord, that would, I ought to have passed the order before 27th of January 2028. My lord, I have passed the order on 11th of February 2028,
Okay,
counting 6 months from the date of communication of the order.
let's see.
Please, my lord.
Let's see that section, the revisional section.
For my lord's convenience, my lord, page number 13 of the petition appeal may be.
Yes.
Lord, para 22.
Does the rule require, after you invoke revisional jurisdiction or a suo motu power, the final order should also be passed within 6 months? Or it's only the invocation and issuance of show cause notice that you are exercising the power under that rule,
No, passing of the order.
passing of it?
Please. May I request?
Show us that.
My lord, page number 13 of the appeal memo. Lord, paragraph 22. And below the paragraph 20, I called out the 50, rule of 54. of
Yeah,
the-
revision. Any
May I read,
authorities
Milo?
appear to the authority making the order.
May I read, my lord?
Yeah, yeah.
Rule 54 revision. Any authority superior to the authority making the order
may either on his own motion or otherwise call for the records of any inquiry and revise any order made under these rules and may A, confirm, modify, or set aside the order, B, confirm, reduce, enhance, or set aside the penalty imposed by the order, or impose any penalty where no penalty has been imposed. C, remit the case to the authority which made the order, or to any other authority directing such authority to make such further inquiry as it may consider proper in the circumstance of the case. Lord, E is important.
Where is that position? It should be from the date of communication.
Please, ma'am.
Where is that?
My lord, E, clause E, my lord. May I read, my lord? Pass such orders as it may deem fit within 6 months of the date of the communication of the order proposed to be revised. My lord, my original order was passed on 20.
When was the order communicated to him?
My lord, 17/8/2007, even as.
After almost 1 month.
No, my lord. Original order was passed on 28/7/2007. My lord, order was communicated to him on 17/8/2007.
17/8 communication means it was out of your possession or he received it?
He received it.
On 17/8.
Please, my lord.
When did you dispatch it?
At my lord, I will ensure, my lord. But even my lord, even his appeal against the original order, he has himself stated that he received the order on 17/8/2007.
Yes, what do you say?
The
See, this interpretation of the learned single judge, just let's see that order. Admittedly, the revisional paragraph 7 has exercised the power. This means if the revisional authority, paragraph 8, decided to pass an order, he was required to do so within 6 months of the order which he had decided to revise. Admittedly, the order of punishment which the revision suo to revise was passed on 28, and as a consequence, the commandant revision ought to have passed the orders on or before. See, now this 28/7 is an order which was passed.
Yes.
Not communicated.
Not communicated.
Communicated was on 17/8.
17/8.
Now, how would you interpret this provision E of the rule? Pass such orders as may deem fit within 6 months of the date of communication of the order proposed to be revised. So what was sought to be revised is an order of 28/7.
Yes.
When was it communicated? 17/8.
17/8.
When was it revised? Is February
11/2/2008.
2008. So will the date of order becomes relevant or date of communication becomes relevant?
Date of order.
But how do we get that? E doesn't say so. How would you interpret the word deem fit within 6 months from the date of communication of the order proposed to be revised? Otherwise, this order should be, E should be from the date of the order proposed to be revised. That's enough. But there is a word communication also that becomes relevant. And there may be a purpose. There may be a purpose. Which, and it was 6 months within 17/8.
Please, ma'am. 6 months.
Yes. Then it should not be correct. And you increased it by 3 increments.
Please, ma'am. That order is not.
But there is a serious charge against him.
Yeah.
There is a serious charge against him.
Moreover, in merits of the case, without holding any inquiry.
No, but that power is there, no? You're not understanding. This is suo motu power. The record is saying, the disciplinary authority says 1 increment. He says, no, 1 increment would not suffice. It should be 3 increments based on the charge. That's what. I don't think we should.
Moreover, my lord, complainant also is, my lord, at the time of investigation, my lord, they seize the mobile. And then, my lord, after some time, my lord, they return the mobile to petitioner also, my lord. In merits of the case, my lord, there is no evidence, and also moreover.
But that's not the subject matter before the learned single judge.
But my lord, in my pleadings, my lord, petition, my lord.
I know, but he didn't go into this. He didn't go into this. He only went, possibly this is the only plea which was raised, that it is beyond 6 months. That was the only plea raised. The challenge in this petition is to an order dated 21st September 2023, whereby a single judge has allowed the petition filed by the respondent herein by allowing the writ petition by stating in paragraphs nine, 10, 11, 12 as under. Full stop. The submission of learned counsel for the appellant is that in terms of Rule 54 of the CISF Rules 2001, more specifically subclause E, which is a revisional power, comma, subclause E stipulates that the revisional authority can within 6 months of the date of communication of the order proposed to be revised, exercise the jurisdiction of revision, thereby revise the order passed by the disciplinary authority. Full stop. Passed by the authorities below. Authorities below. Full stop. The learned single judge has allowed the petition only on an interpretation to clause E, which reads as under page 14, clause E. Full stop. The submission of learned counsel for the appellant is that it is not the date of it is the date of communication of the order proposed to be revised, that the revisional authority shall within 6 months revise the order, and not from the date of the order. According to him, the revisional order was passed on 11/2/2008. According to him, the order dated 28/7/2007 was communicated to the respondent on 17/8/2007, and the revisional order was revisional order was passed on 11/2/2008, revising the penalty, which is within the period of 6 months, as is contemplated under 54E of the rules. Full stop. The learned counsel for the respondent do not contest the fact that the order dated 28/7/2007 was actually communicated to the respondent on 17/8/2007. If that be so, the order dated 11/2/2008 was within the period of 6 months, as is stipulated in subclause E of Rule 54 of the rules of 2001. If that be so, comma, the order of the learned single judge is clearly contrary to the provisions of 54E of the rules of 2021. Full stop. The order dated accordingly. The order dated so-and-so of the learned single judge is liable to be set aside. We order accordingly. The appeal is disposed of. Appeal is allowed. Appeal is disposed of as allowed. Thank you. Next.
53, serial number 53.
53, ma'am.
Now, in this matter, I appear for the appellant. The impugned order, your lordships may kindly peruse, that is at page number 13.
What was the condition you were challenging? Oh, condition of that renewal.
Yes, my lord.
2 years.
Yes, my lord.
Extension of 2
But
years.
you also got the benefit.
Yes, my lord. Because the very period of contract was for 1 year. And instead of calling for fresh tenders after the conclusion of the tender period, to extend it by double the period of the tender is opposed to law, is what I had contended in the impugned.
But tell us today, 2 years have gone. have expired or still subsisting?
Still subsisting and it
How
would
many
expire
months?
28th February.
28th of February by
Next month?
Yes, my lord.
How many years benefit you got?
My lord,
1st March 2019 to 28th February 2022. 3 extensions they got. They did not challenge it.
my lord,
They got the
once-
benefit.
No, so you say it should be 1 year extension?
Yes, my lord.
Then it can be further 1 year, then it can be further 1 year. In totality, it will become 3 years.
My lord, now the point is this, my lord. Whether the extension granted in the instant case is proper or not. My humble submission is, if we look into the facts of the case and the relevant law on the point also, the rule 24 says only 25, rule 12. Instead of
All the rule 12 of which rules?
I'm sorry. Rule 12 of Karnataka Transparency in Public Procurement Rules, my lords. Here, Rule 12, Class 5 says the tender document shall indicate the quantity proposed to be procured in the tender. Now, quantity, that is the manpower requirement in the instant
That's
case.
right.
And the tender accepting authority shall ordinarily be permitted to vary the quantity finally ordered only to the extent of 25%. So they can extend the procurement in quantity by 25%. Now by
You can increase it.
Yes, ma'am. Here, by extending by 2 years, it is almost 200% extension of procurement of the quantity.
Over a period of time of.
Yes. That is one thing. But let us now peruse the very relevant portion of the judgment that is rendered by the Honorable Single Judge. Now, my lord, para 10 of the impugned orders, your lordships may kindly see. Para 10 and in ink page 21.
What is the reasons given by them for extension?
My lord, the reason given is they have exercised clause 32 of the tender contract condition, and then said if it is up to them unilaterally, if they are satisfied that the tenderer is performing his obligations to their satisfaction, they can extend it.
You are also part of the tender?
No,
Did you
my lord.
apply for it?
My lord, earlier, what they have done is, they unilaterally, they extend the financial criteria for application, for applying or applying for tender. They say that in the past 2 years consecutively, continuously, the tender, the return should be 200 double the tendered amount continuously for 2 years.
That's an eligibility
and
condition.
overall for a period of 5 years. Any period 2 years, in a span of 5 years, the tendered amount should be more. Now, my lord, this is what I would make my submissions with all respect. My lord.
Just 1 minute.
Yes, ma'am.
Now tell us one thing. Have you issued a fresh tender?
My lord, as of now, I'm not sure. I'll have to take instructions. The last date is 28th February. That I am sure.
No, the apprehension can be that you will may further extend.
No, my lord. May I request your lordships to kindly
You
take
further
page
extend, then it
58.
would be.
The contract itself does not provide for it.
We don't know.
No.
Oh, my lord, please.
No.
see-
He holds the contract.
No,
It
but
was extended.
Was 2 years permissible?
Yes, my lord. Yes,
No, it
page
was
58. Clearly it is permissible. When I invited the tender itself, this was clearly mentioned that it is for 1 year, and upon satisfactory completion, you will be entitled for 2 more years. And the learned single judge also tells, I find nothing wrong with this impugned order. Just to ensure that there is more transparency, have a relook at this. That is all the learned single judge.
And did they apply?
They have not participated in the tender at all. That is my first contention. They had no locus to question this tender at all.
My lord, as on the date.
No, he may say Very well, I didn't want to participate. I know it's for 1 year. But I was sure that after 1 year, there would be a fresh tender.
My lord,
But what did you do? You extended for 2 years?
it is permissible under the contract.
Yes. Tell us one thing.
Yes,
There is a stipulation in the tender condition that it can be extended for 2 years, yes or no?
yes, my lord.
Very well.
Yes.
If there is there,
Yes,
then the power to extend exists.
power to extend exists, but we have challenged the very power, and the and the honorable court, this honorable court rightly holds that the same term, this is what it holds in
What
para
is your
21.
locus?
This is arbitrary. What the trial court, what the first court holds is extension would not inspire confidence or generate a transparency in procedure. That is what it says. The court comes to the conclusion, this extension is bad in law.
Very well. Just one minute.
Yes, ma'am.
Did you at any point of time previously
Yes,
also applied for this tender?
yes, my lord.
For how many years that was?
My lord, for 3 years.
Was
It
it
was for
initially
one-
for 3 years or initially for 1 year and then extended?
It was initially
1
for,
year and then extend.
So you are the beneficiary of such a rule, of such a condition. You were the beneficiary.
my lord, yes.
If you are the beneficiary,
Yes.
how can you challenge the rule? How can you challenge the rule? What does he want to say?
Yes, ma'am.
Yes, what do you want to say?
My lord,
My lords, they cannot seek the negative equality, and at that point of time,
Oh.
so no other bidder has challenged the said clause.
Now
or
it
any
will come.
extension.
Ajay, tell us one thing. We are putting it to you. You were the beneficiary.
I was the beneficiary.
Can you challenge it in law?
No,
A stipulation of which you have taken the benefit?
no, I had taken the benefit since they had issued it at that relevant point of time. Here, what has happened, my lords, at that relevant point of time, no other bidder has challenged any extension issued in my favor.
Okay.
If that
That's
was,
that's no test.
even there cannot be a negative equality, my lords. In addition to that, my lords.
What is
when-
negative equality?
No, so since I have enjoyed and also I can also enjoy the same, that should not.
Surely you would not challenge. Someone who has not taken the benefit, he may come, we will entertain it. We will test it. But surely you would not. That's what we are saying.
May I make one submission, my lords? As on the date of inviting the tender, I was the existing service provider. If financial condition was imposed so as to oust me from participating in the state tender, my lords.
Where is that plea taken before the learners?
My
Court?
lord,
It was
I will
taken in
give
the
an
ori-
explanation for that
No,
also.
no, where is the,
that plea was taken in the original writ petition, in the writ petition filed in 3206, my lords.
the same order, the same
No, no,
petition?
it is
It
referred to,
the-
my lord.
It is referred to, my lords.
Your lordships may kindly
And in
refer to
addition-
page
And
19.
it has become a single bid, my lords. It has become a single.
But did you succeed in the writ petition?
No, I did not succeed, but however, I preferred a review petition. Review petition came to be disposed. In the review petition, they had filed a memo stating that the tender tenure is coming to expire. On that ground, the review petition came to be disposed.
Oh,
Then I was under the apprehension that the new tender is likely to be issued, and immediately after the disposal of the review petition, I had given a representation that kindly, based on your submission, kindly issue a fresh tender.
My lord, review petition specifically stated to urge all the grounds available in the subsequent writ petition
No,
to be filed.
no
That
issue on
spec-
that.
Yes, my lord.
But you may urge every issue. The court will consider which issue is relevant, which is not.
Yes, my lord.
And we are putting it to you, being a beneficiary, whether you can challenge such a stipulation. Tell us, in law.
My lord, whether the question of estoppel arises now,
We are not
Because-
saying estoppel.
because
We are saying on acquiescence, maybe
Yes.
very well, very well. We will not say even acquiescence. Surely we can invoke 226 in a petition where a challenge is laid to a stipulation that this clause of extension is totally illegal. That's the
Yes.
challenge. But it is at a behest of a person who actually not once, twice given the benefit of that 1 year extension.
Thrice, ma-
Thrice.
twice.
no, no.
No, no.
Produce extension orders also.
Don't think we should.
One second.
There was no such clause for extension of 2 years.
And in the first writ petition, they don't challenge this clause. Now in the second writ petition, they come up with this.
This is, this one, date.
My lords, my humble submission is, my lord, I anticipated and wanted fair participation in the tender. Now, by enhancing the financial criteria, which was not there in the earlier invitations for tenders, and even the subsequent invitation for subsequent means they have to
That's
call.
a better argument. That's a better argument for you. Where is the plea taken? Where
My
is
lord,
this
that
plea?
plea is taken.
Show
in-
us.
Yes, my lord. In,
So we will.
yes, we have taken that.
We show us this plea. Where is the plea?
Yes, my lord, I will, that is. My lord, I have taken it in the grounds of the writ
Show
of plea.
us, show us. Let's
Yes,
see in
sir.
what manner the learner single judge
sir.
deals with it.
Yes, my lord.
And did you urge
In
this
the-
point before the learner single judge?
Yes, my lord. I, both that ground was taken and it was urged before the learned senior.
Does he deal with it?
What? My lords, para 9 and 10 of the impugned orders, your lordships would get the
Sure
answer.
that
my
the
lord.
facts narrated are not in dispute, lie in narrow compass.
Para 9 and 10, man.
Whether this comes to be dismissed, a review petition filed, the impugned award is extended by a period of 2 years. What requires to be? Where is that where is that this urge point?
My lord, it was urged in the first writ petition, it was dismissed. In this writ petition, that was not under consideration at
No,
all.
here, your lordships may kindly see.
Show us.
Yes, yes, my lord. Sure. Here, anyway, I'm sorry, I'm aware, but still, I request your lordships to kindly refer to synopsis at item number 2 of the synopsis. That also forms part of the second respondent had issued invited a decision-oriented systematic analysis, tender notification being reference so-and-so, manpower service so-and-so, Bangalore, to favor the third respondent, I have said. The appellant filed a writ petition so-and-so, challenging so-and-so, and that in that writ petition also, it was urged. I
know you should urge here, na?
Here also we have urged.
Show us that.
At 40 and 41 of the grounds.
Petition.
Of the
Page number
petition.
36.
Page number 36, your lordships may kindly see. The financial eligibility criteria, your lordship gets it?
Which paragraph? Yes, 40. Was increased to
Para
attract
40.
less competitors only to avoid competition in favor of the respondent number 3.
Yes, ma'am. That is what I have said. So that point is urged in the earlier writ petition.
But not in this writ petition.
40 and 41, your lordships may kindly see. That
Is the earlier writ petition?
Yes, my lord, which is impugned. Idene, nodi. This is the present grounds taken in the present writ petition. 40 and 41.
How much the financial criteria increased from which, what amount to what amount?
Double the amount put to tender, my lords. Initially,
Initially, it was how
it was
much?
50% of the amount put to tender. It was in the earlier tender notification.
That should
which-
be your,
Four times enhanced.
it was enhanced to 4 times.
Yes.
4 times, and only one particular entity has got benefited and only to favor.
What do you say on this?
Initially, the tender was called for a 30-seater customer helpline. This time it is for a 100-seater. The amount put to tender has increased. Therefore, I have also increased the tender conditions. And this is in accordance with annexure R3
The
and R4.
previous tender was for a less,
Yes, my lord, 30-seater. The amount put to tender was less.
this is for, I think, outsourcing the employees.
Manpower services for customer helpline in BESCOM.
Okay.
So naturally, the financial condition also increased. And as per the government order, if it is above 10 crores, I have to ask twice the amount. That is, I have just followed the government order and the BESCOM circular. I produced it at annexure R3 and
My
R4.
lord, one submission. There is no standard bid document for availing man services.
No, what he says is, depending upon the requirement of the personnel, the tender condition would vary. Or the base price or the condition, like in this case, the previous tender, it appears to be for a lesser manpower. But when they increase it to 100, then the amount, tender amount would also go, and connected with this is the eligibility condition. Suppose the tender amount is, let's hypothetically 10 crores. Then it should be 55 crores should be the eligibility condition. But suppose in the case of 30 people, the total amount is 3 crores. It would be 1.50 crores. That the eligibility will come down automatically.
My
That's
lord,
what he's trying to convey.
my lord, that is opposed. If that is so, that should have been found a place in clause 30, which is extracted by the honorable court. Clause 30 only provides 32 at page 20, your lordships may kindly see. Here, page 20, ink page, clause 32, the contract is for period of 1 year from the date of contract order, and based on the satisfactory performance, the same is extended up to 2 more years at the same terms and conditions of the contract. So this, it should have been provided here.
That what is required to be provided here?
Here, in fact, if the tender is for a period of 1 year, the financial criteria is sought only for a period of 1 year, my lords. If at all, if it was for a period of 3 years, then they ought to have sought the financial condition for 3 years.
No, how many personnel were called for outsourcing? How many personnel?
There are near about 400.
Previously, the previous tender was for,
Previously, there were about 278 employees.
so there is an
Here, the
increase.
base price will increase, my lords. But however, the financial condition ought to have been, they ought to have been imposed a condition in order to facilitate more bidders.
So you're not
50% ought to have been sought for.
See, you're not
Here-
understanding. If the cost of the tender is more, the condition would also invariably change. Because the obligation would be of that nature.
Correct.
The obligation on the part of the tenderer would be of that nature, where he must financially secure it.
Correct, my lords. I do concede to this fact, my lords, but here the tender is invited under the category of services. If it was invited under this category of works, then they ought to have sought the financial condition, more financial condition. Here, the financial condition has got no much nexus as it is in the works.
No, suppose for a moment, let's assume, we'll tell you. They are entitled to minimum wages, the personnel, they are entitled to labor law compliances.
Yes, my lords.
The contractor doesn't satisfy anything. where will the obligation fall upon? Obligation will fall upon the principal employer.
Yes, my lords.
Principal employer, where will he meet the obligations? It is these conditions will become relevant.
Yes, my lords. Here, in order to see that the bidder has competence, they will seek for past performance. It is not the case that I was not at all having any past performance. I had an experience. I had provided the similar services in the very same corporation. It is a very decision-oriented systematic analysis tender only to favor one particular entity.
Possible.
Again, there is a probability, and it is very much what happens now in this scenario. It is not possible for us to show that absolutely it is made for him. Only it is the court which can make out, my lords.
But tell us one thing, how come your requirement goes up? Initially was how many personnel?
My lord, initially it was 30. At that time, the number of consumers were also less. Then Bangalore grew, the number of connections increased.
This is which year, 2000?
This was in 2022. The previous one was in 2018.
No.
There was some variation.
May I make
And in
one
fact,
suggestion?
by this exercise, I am saving money. I have produced a table at page 237. When compared to the amount that he had quoted, the present tenderer is quoting less. I am saving money. Public money is being saved.
Oh, he
Please.
quoted more.
Yes, my lord. Please see page
No, quoted
237.
more, he did not participate.
In the previous tender. This tender, he did not participate. So when
That may
compared to the
not be
services,
relevant.
See, here, his case is, look here, you have set the conditions to favor the third party, not them. That's their allegation.
I'm basing my conditions on a government order and a BESCOM circular. I've produced it also. I have to follow this. Please see page 251, my lord.
Page 237. But
Annexed
tell us
to
one thing, now it's expiring in
Yes, ma'am.
28. So have you taken a decision to issue fresh tender?
I will have to take instruction.
But in any case, once they issue. Oh.
Extension granted for tomorrow is
See, they have made certain observations. He's right in saying so. Initial period is 1 year. You are extending it for 2 years.
Yes.
We can imagine 2 years is initial period, reducing it to 1 year.
In fact, before.
We don't see any logic in that. And that's the reason the learner single judge says you need to
Yes.
relook into.
Yes, my lord. We have in fact undertaken that exercise. Before the learned single judge also, we told that we'll have a relook at this.
Obviously,
My lord, what
this will
happened
give.
was,
So
in the-
effectively, with 1 year, he's getting 3 years.
Yes.
That's obviously it will be something which is pinching. He said for next 3 years, I am out.
But with this extension, the learned single judge has said nothing is wrong with this. I
no,
won't
no, no,
interfere.
single judge has said that it is arbitrary.
No.
It is not transparent.
He says so. He says so. There can be an allegation of arbitrariness. Yes.
The learned
But would
single
you
judge-
like to now continue this or you wait for the tender to come?
My lords, we don't know whether they would publish the tender because this is what happened after the disposal of 3206 and the miscellaneous case for review. And we made an.
You are right. You are right.
In review, because the period was coming to an end, we said we will not
Press it.
pursue because they would issue fresh tender. They did not do that
Did
at
not
all.
do that. Okay, it's all right. But how would you now answer the arbitrariness? But did they urge this point before the learner single judge
regarding the extension.
regarding this condition?
In the first writ petition, they did. The
No,
second,
they raised this point at page.
they've raised it, but before the learned single judge, the arguments were restricted to the extension part. Only this portion, that's why the learned single judge also gives findings on this extension aspect.
My lords,
And in the first one, they don't challenge this clause.
Yes.
my lords, in the miscellaneous.
Tell us one thing. Let's assume we agree with you.
Yes, my
The
lords.
stipulation condition. What will follow?
My lords, we want a precedent so that in the next, at least subsequently, they should not illegally extend by
Where
years
is your,
together.
where is your explanation for that condition of tender condition?
My lord, that is at
Page 41.
my lord.
No, paragraph
No,
41.
It's at page 58, my lord. Clause 632. Page 58. This
Hmm.
permits me to give this extension.
Pardon?
May I read, my lord? The contract is for a period of 1 year from the date of contract order, and based upon satisfactory performance, the same is extendable up to 2 more years at the same terms and conditions of the contract.
He's not on that. He is on that tender condition where the money has been increased.
My lord, kindly take page 251, my lord. 251, annexure R3.
251.
251. The relevant portion is at page 252. In the bottom, my lord, KW4. Qualification, it says usually not less than 2 times the estimated annual payments under this contract. I'm just following this condition in the present tender also. And they had raised one more contention.
Where is that? Where is that?
My lord, page 252, it starts at the bottom, qualification. And the relevant part is at 253. In brackets, it's there, my lord.
Qualification.
Brackets, usually not less than 2 times the estimated amount.
Not less than estimated cost under this contract for works costing
10 crores and above. And thereafter, Bescom also has issued a circular that is at page 258. It says, as far as works costing 10 crores and above, KW4 shall be adopted.
Hmm.
Page 258, my lord.
Hmm.
It says KW4, value of contract in the portion that is in bold, my lord.
Yeah.
It is clarified in the GO number so-and-so dated 14/10/2008 that as far as works costing 10 crores and above, KW4 shall be adopted.
What is KW4?
The one that I showed at page 257, my lord.
My
That
lord.
I have to put it 2
Yes,
times the
let him
amount put
complete.
to tender.
My lords, may kindly peruse page number 249.
Tell us
which-
one thing.
which is the first page. This applies only to works, not for procurement of men. This is what procurement of works. Use.
Okay,
of-
just 1 minute.
Yes, my lords.
There was a stipulation, this stipulation was there. Why didn't you challenge it before he could award it to someone else?
It was challenged in the first writ petition.
Before the work was awarded? When the condition was put and you were ousted because of that condition, you should have challenged it.
We have challenged in writ petition 3206. 3206, which is part of the record here.
No, when
The
did you
appeal-
challenge? After the
Yes.
award? After
No.
the issuance of tender?
No,
It was already awarded to the
7/2/22, 7/2/2022, writ petition number 3206 was filed, my lords. Letter of intent was issued subsequent to filing of the writ petition. During the pendency of the writ petition, a letter of intent was issued.
that is why.
That is.
There
in
was,
bit-
there
on
was no
18/2,
stay of the
lords.
proceedings. There was no stay of the proceedings. So we proceeded with the tender.
It was challenged on the very same ground. And however, the court was pleased to dismiss that writ petition. And in the review petition, the court observed that all the defense that is permissible, all grounds could be urged in an appropriate proceedings. Your lordships may kindly see 198, page number 188, 198. Here, this is what para 3 says. When this court pointed out that the tender period would come to an end in another 2 months, the learned senior counsel appearing for the appellant, that is appellant hearing, KG Raghavan fairly submits that review petition could be disposed of, observing that observations in the order in this review is on the fact situation of the present case and keeping open all the contentions, taking note of above submission, the present review petition is disposed of, making it clear any observation made in this review petition on fact situation of the present case, the contentions raised by the petitioners or as well as the respondents are kept open to be urged in any future proceedings.
Where is your stand on this?
Yes, my
petition?
lord, here itself.
1 minute. Where is your stand on this?
Financial condition.
Yeah.
my lord. I've taken that stand in my statement of objections. It said, my lord, it starts from paragraph 10 at page 217. From there, I've given an explanation regarding the financial condition as well as the extension. And one more submission is that they claim that this is the only tender where I've put such a condition. Before the learned single judge, I had produced 5 other tender notifications where a similar financial condition has been imposed. Just because they are not eligible to participate in this tender, they're saying this condition is arbitrary.
Why can't they say so?
My lord, this is not the only case where I've imposed such a condition.
But have you said so in your count?
Yes, my lord.
My lord, not in all tenders.
Okay.
In some tenders it is followed. In some tenders it is not followed.
I've also
Financial
produced it.
criteria is not followed.
In
Your
fact,
lordships may kindly see, that is the ground that we urged in the.
Well, now, very well.
my
Yes,
lord,
madam.
and I also refer to one judgment of our Honorable High Court, where they say that imposing such a condition is not arbitrary. Our High Court decision.
What condition?
Putting the financial condition of twice the amount of tender. That is not arbitrary, is something that our High Court has held.
Sure. Where do you say in 247? In view of the monsoon approaching, there is increase in number of complaints received. Period of 2 years inviting fresh tenders is up. Would impact capacity bidders. Where is this ground of double the tender?
Well, that's at para 10, man.
Para 10?
Yes, it starts from para 10.
You said 247,
217.
217.
17.
Oh, 217 of your objections.
Yes, of
Which
the
you are
of this
filing
writ
today.
appeal. No, it's a part of the record.
Okay. Thank you, sorry.
My lord, the judgment I'm referring to is at page 88, my lord, of this compilation.
Does that condition say double the amount?
Yes, my lord, same facts. Page 88. And in the
What's
next
this?
judgment, the Supreme Court in fact says that if the tender amount is increased, it is good that you impose a higher financial condition. I have produced that judgment also.
Which judgments?
My lord,
page?
first I would refer to page 88, my lord. The judgment of this honorable court.
Page 88 is first, then
Page 88,
which para?
paragraph 6, my lord.
And next judgment?
My lord, in the index itself, I've mentioned the relevant paragraphs.
Okay.
In the next judgment, the relevant paragraphs are 50 to 52.
50 to 52 or 52 to
50,
63?
51 and 52, my.
Though, same judgment?
No, my, it's the next judgment.
Acha,
The
next
judgment of the Honorable Supreme Court.
50 to 50.
Yes,
What
it's
is
at
the
page
proposition?
101.
What is the proposition?
Proposition in that matter was also that the amount put to tender was twice the amount. The Honorable Supreme Court says it is good that such a condition is imposed. That's exactly at para 52, 51 and 52.
Okay, any other judgment?
Yes, my lord. The other judgment is National Highways Authority, where it says that a non-participant to a tender does not have the locus to question the tender.
That judgment may not be applicable because I'm not a mere non-participant. I was given the contract till.
His case is only simple this.
Yes, ma'am.
Because of the condition I was not meeting,
Yes.
I could not have applied.
Yes.
Simple.
But this judgment that I referred to squarely covers this matter. That was not challenged in an appeal.
These
also.
judgments could be distinguished on the simple ground that all these are with respect to the works that to be executed.
See, it doesn't make any difference. Be an engineering-
Procurement of
Forget it.
manpower.
No, nothing of that. Ultimately, it's a full tender process. They are inviting it.
Yes, let us see this way. Had that been the case, in all the tenders which they have called for, they should have imposed such a condition. But in a manner of pick and choose, in some tender they call, and in the later tenders which they have produced, they don't fix any financial criteria. That is an arbitrary fact, is my humble submission. Because it should be uniform.
Okay.
My lord, annexure R7.
Yes.
Shall I reserve? Next.
My lord,
Thank
in
you.
annexure R7, I have produced the other tender notifications in which a similar financial condition has been imposed. That is
Okay.
it.
Thank
R7
you.
of my statement of objections.
You just give it to me.
ಅದು ಹೇಳಿ ನಾನು. ಹೇಳಿ ಬಿಡಿ, ಹೇಳಿ.
Yes,
May I make one submission, my lord?
yes.
There is a standard bid document in respect of works, my lords, based upon the value of the tender. But in respect of services, there is no standard bid document either issued by the PWD or by the finance department. So they cannot pick and choose wherever it is convenient, though it is a prerogative of the inviting authority to impose the conditions. But the conditions cannot be arbitrary and mala-fide, my lords.
Have you alleged malafide?
Yes, my lords. Only
Yes.
on that sole ground, the writ petition survives.
On whose part?
On the part of the corporation, inviting authority.
Who is that authority? See, you can't be corporation, everyone is there.
On the tender inviting authority, third respondent.
What is the name?
Name I have not named because since I had challenged the tender notification,
See,
I did not.
See, you have to have foundational facts. Not this gentleman wants to favor the selectee. He has put this condition and you must allege. You have to make malafide means something which is serious. We may be with you on that. That this is intentionally they have framed these conditions in such a manner only to favor him. Can be. Now he is trying to say, support the Supreme Court has said, every court, even this court had said, such a condition is permissible. He is trying to justify it was not 30, it is 100 who need to be recruited because the number of calls had increased. So we had to cater the large number of people. For catering large number of people, we required extra hands. For extra hands, we had to issue extra tender, the new tender. The new tender means this is the consequence for which we have put this condition.
There has to be uniformity. It is not there. That is one.
Okay, thank you. Next.
One more.
It's all right. We have heard you.
Now kindly see para 23 of the Michigan versus State of Karnataka, the judgment which they had filed. my lord.
Read it.
There should, the basic requirement of Article 14 is fairness in action by the state and non-arbitrariness is essence and substance in the heartbeat of fair play. So here, the basic requirement is there should be a fairness in their action while inviting the tender. The very purpose of inviting tender is to give wider participation so as to save the state exchequer, my lords, in order to get a very fair price. So here in the instant case, it was a single bid. If that was the intention of the inviting authority, then they ought to have, there would have been more participants.
We'll tell you why that requirement of you should have this kind of a turnover for the last 5 years. That shows the capacity of a person to execute the tender.
I concede, my lords, only that particular entity fits in that condition.
That is it. See, oh, very well. I take it. Then you would allege, though under the garb of, increasing the number of people to 100, they have put this condition, but otherwise no person other than him would be eligible under this condition.
I had stated in the writ petition, my lord.
Now this is a one, was it only one tender which had come? How many had come?
Only one.
Only one.
Only
Single-
one.
It has become a single.
But regarding that contention also, I have produced one judgment which says, just because there is lesser participation, it does not mean it is arbitrary.
Not a lesser participation is vague word. One person as against lesser. One lesser means it
But-
can be more than one.
But another issue is that this is the first time that I've called for such a tender. This was not done previously. This is the first time. Hence, I had to increase the financial condition.
My lords, my last submission, with that I will close.
We have
Ye-
heard you enough.
Only one sentence, if your honor permits me. Your lordships asked as to whether the tender inviting authority is made a party. Yes, respondent number one is the tender inviting party, and they have been made as party, and that is evident from the tender.
By name,
Not by name, my lord. Not by
The,
name.
here, the tenders also do not say by name.
you are alleging mala fide. You are alleging mala fide against the tender inviting
Yes, I
committee.
understand.
If that be so, you would make allegations against them or enable them to file an affidavit controverting your stand. That's how it has to be worked out.
One last submission. There is a delay in filing the appeal. I do not have a copy of the delay application.
How much is the delay?
7 days.
47 days.
Just one.
Okay. We will allow delay application.
Thank
Just say that this is an application seeking
Yes, ma'am.
explanation of delay of 47 days in filing the appeal for the reasons stated in the affidavit. The delay is condoned. Then we have heard the learner counsel for the parties. Okay. The learner counsel for the respondent has filed the compilation of judgments. The same is taken on record. He shall also file the same through e-filing.
Yes,
Within 1 week, orders reserved.
great.
54,
Next, ma'am.
54. Deepak Bas. 54.
I appear for the appellants in this case, my lords.
That
Serial
is some
number,
other day.
yes, my lords.
My lords, so
Because the interim order may be extended.
55 and 56.
54, 55, 56.
Yes, no, it may be connected together, my lords, and it arises out of the common judgment.
Same judgment.
Yes, my lords.
Interim order may be extended, my
You
lords.
just say that re-notify on. We have been informed that WA 46824, 48324 and 48724 arises from the common judgment dated
My lords,
19 February
19 February
2024.
2024, my lords.
2024. And as such be heard together. It is ordered accordingly. List on.
3rd of April,
Much.
57.
To appear for the petitioner in this matter, madam. Lord, the matter pertains to my claim for the period that I was kept out of service on an inquiry and a report, my lord.
We'll hear you some other day.
Please.
Just say re-notify on.
My lord, it is against the order of the tribunal. Notice may kindly be ordered in this matter.
We'll see if let us
Please,
hear you.
please.
Next.
17-2.
Much lord.
58 Arjun, 59. 59. Pallavar.
Just say none for the parties re-notify.
7th of April. 60 Arjun, 61. 61.
Written submission be filed within 6 weeks.
My lords, 2 weeks, my lords, we'll file it. These are ready to be filed, my lords. We'll hide it in the counter. We'll
But
be ready
we'll
for
still-
arguments. my
We'll
lords.
still give you 6 weeks date
My lords.
or possible. Just say after 6 weeks.
My lords, it's an interim order for speed
Interim
of the
order-
execution.
Interim order if any to continue, just check up that. No
73.
one is appearing for the other side.
They do appear, my lords. On the previous days they've appeared.
Mr. KPS Manian,
Yes.
62.
My lords, I appear for the appellant in this matter as well. I appear for the appellant in this matter as well, my lord, 62.
Same submissions.
Yes, my lords, we'll file them.
24-3.
Submissions be filed within 6 weeks. List on.
60.
There is no interim order here?
No.
63,
63. Rishikant Prasad.
none for the parties adjourned to.
84.
65.
64 Arjun, 65.
65 appear for the appellant.
This need to be heard, na, this together. This is the same that application and condonation.
Please,
did.
please, ma'am.
Just list for hearing on both the matters.
9th of April,
Next,
66, Shri Anand.
Appear for appellants, pray for a week's time.
renote, you just say that at the request of counsel for the appellant. You are for the appellant,
Yes, my lord, for appellants.
list on
26-3.
Much obliged,
67,
my lord.
67, Shri Muttanna.
none for the parties adjourned to
27-3, 68,
Hearing for respondent, your lordship.
Lord, I am for the appellant, my lord.
They take to file wakalat for respondents, your lordship. Filing memo of.
file it in the registry.
My lord, I have filed an IA for extension of 12 weeks, my lord. I have paid 6 lakh rupees, my lord. There's another pending of 7 lakh rupees. My lord, kindly give an extension of
Why
8
did you
to
pay the
10
complete
weeks.
amount?
Lord, there's difficulty situation, my lord.
Well, I see, once we have said so, not in piecemeal.
My lord, kindly give
Said so
an,
one amount. We have never said so. Why should we give you extension?
there's difficulty in the house.
Very well, difficulty, you don't deposit. Where's the execution? See, we are seeing this trend.
Yes,
50, we will deposit 20, we will deposit, we'll seek an extension. We will not allow this.
Lord, at least for 4 weeks, my lord.
Why should we allow it? Tell us. Once there is an order, this need to be deposited.
Yes, my lord.
It need to be deposited.
A small extension, my lord.
What small extension? Not even a 1 day. Why should we? What was the order? What does the order say?
My lord, that's if I pay 50% of the principal amount,
How much time?
8 weeks, my lord.
Then, when was this order passed?
Lord, 26/7/24, my lord.
Where are we today?
That is
6 months and 9 months thereafter. So effectively you had 9 months, not 8 weeks.
yes, my lord.
We say nothing. We'll allow you to deposit the cost, pay the cost. Legal Services Authority, let them have some money. We'll allow you. We'll give you 4 weeks, but you'll pay cost.
My lord, a small extension, my lord.
We'll give you small. Why? We'll give you large extension, but cost.
My lord,
This is not called for.
at least another 3 weeks, my lord.
That application is not.
Where is the application?
My lord, IA was filed, my last date,
When did you file?
it was not here, my lord.
Get it listed. We will see. We want to see the reasons why it was not deposited.
Lord, it was filed on 26/9/24, my lord.
What is the IA number?
IA number 1, my lord.
Is it there, ma'am?
One of 23 is first.
First day.
That's for stay. (26/7), the matter, the time was granted.
Yes, my lord.
And when did you deposit the 20%?
My lord, we have deposited 6 lakh rupees, my lord.
How much is that?
My lord, that is 25. My lord, the total was depositing of 50% of the principal
How
amount.
much 50% comes to?
My lord, 13 lakhs, my lord, 13,75,000.
So you have deposited
6
effectively
lakhs, my lord.
25%.
Yes, my lord. 6 lakhs we have
Very
deposited.
well. You file an application, we will look into it.
Yes, my lord.
Just at the request of counsel for the appellant, adjourn to
Obliged.
come.
5-2.
And it pass over, ma'am.
Pass door matters. 16. The number 16.
Oh, just have it day after tomorrow. None for the appellant, even on the second call, re-notify day after tomorrow.
17-1. 33. For the responding number one, your lordship.
In this case, my lord, any date after 27, senior counsel has been engaged in this matter.
This is the same matter where Mr. Joshi had a.
Yes, ma'am.
Yes,
With regard to rents, my lord,
Huh?
Yes, ma'am.
please.
rents, with regard to rents.
Just say that, re-notify on. When do you want?
After 27th, any date, ma'am.
Just say after 26.
29-1,
Much.
Much obliged.
38,
Yes,
Tomorrow, this, sir, I wouldn't bother your lordships.
you are ready?
I just in 2 minutes, my lord, but for the reason that, my lord, we
The
are already
time is
holding your
already-
lordships at 5:30.
What is the issue, Mr. Kumar?
An issue specifically was framed with respect to, my lord, the matter being outside the limitation. And very, my lord, thankfully, the learned judge would extract all the contradictions we have taken in the cross-examination. The learned judge would say that it is admitted that the claim is more than 3 years old. The learned judge would also record that it is admitted in the cross-examination that they have already maintained another 138 proceedings for the same. Everything, my lord, the learned judge would extract. Issue number 2 was specifically framed whether the matter is passes the muster of limitation. But, my lord, the learned judge would simply say,
Doesn't deal with it.
no, zero, my lord, findings on that. And even on the merits of the matter, my lord, the learned judge would extract the particular portion of the cross-examination where, my lord, the PW1 admits that the matter, the cause of action arose in Coimbatore, Tamil Nadu. Learned judge, my lord, would extract that. I have posed specific questions that the cause of action, my lord, with respect to different contracts is different.
No, this is, you said limitation, no?
Limitation is also one issue.
No, but tell us one thing. When according to you, the limitation, the cause of action has started?
Well,
According to you.
4 years prior to filing of the suit. 4 years prior. It's admitted. Clearly, my lord, I'm so thankful, my lord, the learned judge would extract everything in the
Just
judgment.
We'll have it, Mr. Shyam Sundar, at a, just say that re-notify on. Does he go, what is the basis for him to say that, entertain the petition, say that it's not barred?
There is zero finding. My lord, I would have been happy to, my lord, argue something if there was something, my lord, substantial where I could deal with before your lordships. And, my lord, the execution proceedings have been initiated that
When is the execution?
My lord, in fact,
The
they have
warrant has been issued.
obstructed the enforcement of the decree on Monday by stating that we will make the payment. Now I am not on that issue. The matter is set down for 22nd. The equation is regarding the limitation. May I take your lordship to the annexure N at page number 226. It spells out entire ambit of the
When is the execution?
execution is now it's posted 22nd. I'm not going to precipitate that matter till they let them deposit. They have to deposit the money.
How much is the liability, Mr.
Liability is 2 crore 35 lakh 12,005.
They're part of the liability, my lord, for the same cause of action, a 138 proceeding is maintained. Before 138 court, we have already deposited. That is also admitted.
No.
They initiate, my lord, check bounce proceedings for the same liability. And also, my lord, move the commercial court, saying that no, this is for a different amount. That part is also covered by the learned judge, but there is no finding. My lord, I wouldn't mind, my lord, depositing, provided, my lord, I was even remotely liable. Every contract is different, my lord, all piecemeal contract. All contracts put together, my lord, they form a cause of action in respect of more than 15 to 16 different contracts. A single suit was filed outside the limitation.
My lord,
We will look into it, just say it. Just say the re-notify. March, first or second.
5th of March.
Just see, 22nd January, it's coming.
yes.
Yes, my lord.
20
Warrant has
matter
already
may be.
issued.
Yes, I am not denying it. We have been to there to enforce. May I take your lordship?
Do one thing, then you take a date beyond this date, which we have fixed in the execution proceedings.
20, can I have that on 20?
It's very difficult. With this board, not possible.
No, I am not going to precipitate the matter. That
will-
undertaking I would like to,
We will not say anything in the order.
yes,
It's between an understanding between Mr.
yes,
Chairman and you,
certainly, I will honor that.
both of you. will take-
Yes, I will honor that. I will honor that.
Fairness of my learned friend.
I'm not going to
I-
insist upon the enforcement of the warrant.
Hear it, let's hear it. What he's saying is the kind of a limitation, everything. We look into it.
Yes, my lord. That is,
Okay.
on that,
That's all, ma'am. Thank you.
My lords, may I make a
I'm so
submission?
grateful.
In serial number 39, it was requested my lord's permission to file a compilation of judgments. May-
Item 30,
39.
just
39
take
and
it.
40. Please, ma'am.
sir, ಯಾವಾಗ?
ಅಲ್ಲ ಅದಕ್ಕೆ ಅಷ್ಟು ದೊಡ್ಡದು ಕೊಟ್ರೆ ನಾನು ಪಾರ್ಟಿಗೆ ಯಾಕಂದ್ರೆ ನನಗೂ ಕನ್ವಿನ್ಸ್
ಓಟಿಗಳು ನಮ್ದೇ ನೋಡಿ ಫೈಲ್ ಆನಂದ್ ಅಂದ ಆನಂದ್ ಹೇಳ್ದ ಮೇಡಮ್ ಇದು ಕೋರ್ಟ್ ಅಲ್ವಾ ಹೌದಾ
455 ಇದ್ದಾರೆ ಫೈಲ್ ಇದೆ. ರಿಸರ್ವ್ ಆಗಿದೆ ಹುಷಾರು. ಇಲ್ಲ ವಾಪಸ್ ತಂದು ಕೊಟ್ಬಿಡು. ಮೇಡಮ್ ಚೇಂಜ್ ಮಾಡಿ ಇಟ್ಟವ್ರೆ.